Commercial Division in 2022. Thereafter, we had made an application for disclosure of additional documents, which my lord was pleased to not allow. The appellate court has allowed our application for additional documents, and we've written and also has directed for expediting the suit. And we have completed discovery and inspection. We had written to the defendant for giving us inspection, but they have not replied, my lord. So I'm mentioning for fixing the matter on some date. And we've given notice to the other side also, my lord.
When it be? Tomorrow? Let it be tomorrow as to be mentioned.
Very well, my lord. Great. Oh, sorry.
My lord, this is that matter where my learned friend was supposed to bring some judgments. He said that in case of those suits which are transferred from the regular division to the commercial division, they are entitled to get 120 days from the date of transfer. And that there are judgments galore of this Honorable High Court in support of that proposition.
Lordship, I am appearing for the defendant. It's appearing under to be mentioned. If your Lordship kindly keeps it any other day, my lord.
It was fixed at the instance of my learned friend.
Actually, yesterday the matter was mentioned.
Yes, my lord.
Your senior Mr. Basu was here.
Yes.
And he told them, let it be fixed today.
Your Lordship kindly grants a passover.
My lord, let me complete my submission because I have brought the judgments. I'm carrying those judgments since yesterday. Let me start. I believe if his senior comes in, then your lordship will hear
Where
him
is
out.
your senior?
He's stuck actually.
Where he is?
It's stuck outside.
Where he is stuck up?
On way now.
Traffic or in
No, he's not
court?
reached court. He's stuck.
So, may I start? Because I'll take some time to show the judgments. May I just start?
Let you take note of it.
Yes, you start taking notes. Let me. My lord first looks into the order of 30th August 2023, which your lordship had passed on the earlier occasion. There, your lordship will find that we had indicated that we have already taken appropriate steps in compliance of the order dated 9th of August. So 9th of August was the date when your lordship, on the basis of our submission, allowed the transfer to take place from the regular division to the commercial division.
Yes.
And thereafter, the learned counsel who had appeared on behalf of the defendant on that day submitted that there is a time for filing written statement, only that much. And your lordship accordingly granted an adjournment for 2 weeks. Now, if your lordship kindly takes up the Commercial Courts Act, Section 15,
whether they
under
not
which...
file the written statement.
No. Now,
Okay.
interestingly, I'll just give the timelines. So far as the regular suit is concerned, my lord, it was filed in the year 2013. Writ of summons was served on 25th of February 2016.
Correct.
They entered appearance, but they did not file the written statement or even take out any application seeking extension of time to file the written statement. Now, 17th of July 2023 was your lordship's order for transfer. And 9th August, we took time for compliance of the order. And then 30th August, my learned friend appeared after the transfer had taken place. So 120 days from the date of writ of summons had already lapsed. When the suit was appearing in the regular division, they had not come up with any application seeking extension. Neither have they sought for any accommodation when the suit got transferred in the commercial division as well. Now, if your lordship kindly looks into section 15, subsection 4, proviso.
Correct.
I'm laying stress on proviso to section 15.4. It says, may I just read it out for your lordship? Provided that the proviso to subrule 1 of Rule 1 of Order 5 of the Code of Civil Procedure 1908 shall not apply to such transferred suit or application, and the court may. This part is important because Order 5 speaks of writ of summons. So I don't have to cause a fresh service of writ of summons after the transfer. The second part is important, on which I'm laying stress. And the court may, in its discretion, prescribe a new time period within which the written statement must be filed. To this extent, my learned friend's submission was that this honorable court has time and again considered this and has granted 120 days time from the date of conversion. So on that basis, the matter was adjourned till today. Now, may I just draw your lordship's attention to Bombay High Court. My lord, the decision of the Bombay High Court.
Now, what you want?
My lord, I just wish to submit that this is the discretion of the court within which your lordship will consider the new timeline will be set. Because of this provision under Order 8, Rule 1, the mandatory provision in case of commercial suits, which are usually applied when the suit is filed in the commercial division, that particular 120 days will not be applicable so far as section 15(4) is concerned, because these are all the pending suits which are transferred. In fact, I have got the decision of the Bombay High Court, Andhra Pradesh High Court, and also of our High Court, my lord, where our High Court had granted only one week. No? 1 week's extension to the defendant, also given the fact that the defendant had already taken out an application seeking extension of
No,
time.
but in this case, see, 9th August, this court has transferred the suit.
Yes.
At that point of time, neither
17th of July, my lord. Actually, the order for transfer was 17th of July. 9th August, we had took time to comply with the
correct.
yes. And
17th July it was transferred. 9th
transferred.
August you have taken time for compliance. And
Yes.
30th August you stated that it has been complied.
Yes, and they said that
And
they
they
have
said
the
that
time.
they have time to file.
Yes.
They
at
have
that
time.
Neither 17th nor 9th nor 30th August, you have not also raised objection with regard to the written statement.
Now,
And on 30th August, when this court, they have made a submission, they have a time to file written statement, you also not raise objection.
no, because my lord,
But whatever the time
Hmm.
time period has been given, 2 weeks, but this court has fixed on 12th September, October instead of 12th.
yes, instead
Now-
of only
Now
that
only
was the correction.
Only the thing is that whether the defendant is ready with the written statement. or
Yes. Let
If they
them
are ready
show
with the
that if
written
they are
statement-
ready with the written statement, your lordship will consider that.
But I am entitled to 120 days time.
No, but 120 days time court has not granted. See,
No.
after transfer of it is not automatically 120 days. It is not automatically 120 days if this court is found as per section 15 proviso. If it is court find that yes, it has been transferred, then discretion of the court to extend the time for. But you have not asked for any extension of time on the last occasion. You have stated that written time has not been expired. Neither this court has also not gone through the earlier order on your submission. The court has fixed. Actually, 2 weeks time was granted, but unfortunately, the date has gone on 12th October instead of 12th September.
Yes.
So now whether you have filed the written statement or not.
No, as on date, my written statement has not been filed.
Okay. So what is your submission?
But we'll file it within the next 3 to 4 weeks.
My lord,
4 weeks.
I raise my objection with regard to that. My lord, 3 to 4 weeks.
And
time.
the
My
matter
learned
is
friend
being
is making
heard.
the submission as if 120 days is his right to file.
Let the submission.
But I can argue this point that whether I am entitled to fresh timelines or not. Number one. And secondly, the matter is appearing as to be mentioned. There is no application that has been filed wherein my learned friend has prayed for an order that my right to file the written statement post transfer of suit to the commercial division should be forfeited.
It is correct because see, the plaintiff has mentioned the matter. The court has granted 2 weeks time. But
Yes.
unfortunately, instead of 2 weeks, the court, as per the order, 2 weeks it will be completed on 12th September.
Yes.
But in order, it has come as the 12th October.
Yes, that's a typographical error that has come.
Now, she wanted to correct that date already the 12th October. Now, yesterday you have given the consent, let it be fixed today, then it has fixed today as to be
Yes.
mentioned. If you stated that you want time extension of time 1 week, it is a matter you can. But with regard to the 4 weeks, as per the
Because
commercial
when I
code-
am told there is an application which is pending, that is GA 1011 we had filed in 2016. For praying for extension of time to file the written statement.
that their grievances there, you have not made an application.
My
If
lord, we
that
don't
Yes, the
accept
reason is-
that application.
The reason is prior to these applications or prior to the issue that whether we'll file the written statement or not, an application was filed under Section 8 of the Arbitration Act. Now your lordship knows if I file the written statement, my Section 8 application will become infructuous. Thereafter, we did not press the
What has
Section 8.
happened to the Section
We
8?
did not press the Section 8 application. We did not press it, it was dismissed. Now, if the Section 8 goes, now, I am entitled to participate or, I am entitled to submit to the jurisdiction of this court. My time to file the written statement in the regular division expired because the statutory time limit is 30 days. Hence, there was an application filed for extension of time to file the written statement. Now, in 2023, pursuant to my learned friend's prayer, it has now been transferred to the commercial division. Today, the matter is appearing as to be mentioned. If my learned friend wishes to argue or he wants,
If you are submitting that your application for extension of time is pending, let it be then taken on hearing. You serve the copy.
yes, I'll give a copy.
May I just make one submission? So far as the transfer is concerned, That transfer took place on 17th of July 2023. What my learned friend submits before your lordship is that he's entitled to a new timeline. I don't join issue with regard to that. He is entitled to a new timeline, but that is the discretion of the court. That is not as a matter of right, he is entitled to 120 days. Even the statute under order rate also does not say that he is entitled to 120 days. It's 30 days, and beyond that, 90 days is on the discretion of the court, provided he comes up with sufficient cause. Now, with regard to that, my lord, we had applied for the certificates, and we have obtained the certificate that they had, although they had entered appearance, but no written statement was filed in the regular division.
That we have
Now
admitted, right?
Now that your lordship will consider their application, let that be considered. But for 3 to 4 weeks again,
That's
afresh,
why if they
No, I
filed
can argue this point today.
filed an application for extension of time, let it become on record. Let it become on record,
yes,
and
let it become on record. Let a copy be served
Yes.
upon me, but let my friend also.
This is of
show
2016.
any
This is of
because
2016.
2016.
This is of
Today we are talking about
2016.
He's asking for, he had taken such a long time. Nothing prevented him. He is submitting that because of Section 8, he couldn't have come up with the application or couldn't have filed his written statement. He very well could have filed the written statement without prejudice to his rights pending in the Section 8 application.
No, that cannot be the law.
But
Mala time and
nonetheless,
again, Mala Supreme Court has held since from
Nonetheless,
Boozer
I
and
was supposed
Hamilton.
to submit,
Mala,
show
if
one
I file the written
single
statement, the Section
judgment.
8 application will become infructuous.
Judgment,
not
he
the
was
subject
supposed to
matter.
show that it
Man,
is
I can show your
He is
lordship
supposed to
from
get
various
120 days.
authorities that I am entitled to fresh timelines, and indeed I am entitled to 120 days. I
am-
can argue that point.
These are
Okay, okay. In that case, I am fixing a
Very well. Lordship will fix the date.
Kalat, file the return issue. I am giving a week time. If you're not
Yes.
filing, then the
Yes,
matter
my
will
lord
be
will,
heard on
yes, absolutely. My lord will kindly make
Okay,
that
then
clear.
in that case, kindly gives me 2 weeks time to file the written statement.
I leave it to your lordship. It's not a bargaining policy, I believe. I leave it
The
absolutely to your
matter-
lordship.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. The matter was 30th August 2023, 30, wherein this court has, wherein on the submission made by the counsel for the defendant that the time for filing written statement has not been expired, and on the basis of the said submission, the case is adjourned for 2 weeks. But unfortunately, instead of 12 September, it has been recorded in the order dated 12th October. It is recorded as 12th October 2023. Today, when the matter is called, counsel for the defendant prays for time to file written statement. Time to file written statement. Counsel for the plaintiff raised objection, submitted that initially the suit was filed in the year 2013, and since then the plaintiff has not filed and the defendant has not filed the written statement. Neither the defendant has prayed for extension of time to file written statement. But in the meantime, by an order dated 17 July 2023, this court has transferred the case from original division to this court. Full stop. Consider to this court. Jurisdiction to this court. Full stop. Consider the submission made by the counsel for the respective parties. For the interest of justice, time to file written statement by the defendant is extended for a period of 2 weeks. List the matter on. Today we are on. What is the date? September. On 27 September 2020.
27.
27.
My lord is granting them time for 2
2
weeks to file a
Grateful.
written statement. Grateful judge.
Yes.
My lord, I am the commissioner being appointed in this matter, my lord, to record the deposition of the witness of the plaintiff, my lord, as well as the defendant, my lord.
Ah.
During the course of the commission, my lord, the plaintiff's advocate communicated me a mail, thereby intimating that they are not they don't want to proceed on the commission, my lord.
Counsel for the
Uh,
counsel for the plaintiff.
plaintiff, my lord.
How many witnesses have been examined?
My lord, only the PW1 has been examined on site.
Cross-examination is complete.
No, my lord, no. Only the chief has been completed.
Chief is going on.
No, chief has been completed. Right?
So cross-examination is required to be done.
Here to be completed.
So who has filed an application? Who has
Lord-
requested?
Lord, may I appear on behalf of the plaintiffs? My Lord, my examination of my witness is completed.
Hmm.
My Lord, thereafter, my lords, on instructions, my Lord, this is what I have gotten to know, that my client does not wish to proceed with the commission, wants to do it in court. My Lord, I must tell your lordship, it is upon my application that a commissioner was appointed. But however, my Lord, seeing the progress, my client has expressed his desire not to continue with the commission. My Lord, whatever reason, perhaps costs, my Lord, I was humbly praying I shall come back with an application. Your lordship will decide that on merits, whether your lordship will bring it back to the court. My Lord, today was the day which was fixed after examination of my witness for the cross-examination to be done. It is an email by way of which is 1st September 2023. My client has expressed his desire, which has been communicated to the learned commissioner. Lord, I'm completely in your lordship's hands, my lords. Permit me maximum 2 days to come up with an application appropriately in order to, my lords.
This communication was made
My
on first
my lord,
September.
if your
That's right.
lordship's, my lord,
Just I will come.
My lord.
Yes.
Lord, so, my
So
lord,
this communication was made on
1st September. Yes, my
And
lords.
when you have fixed the date today, on by which order? By which
My lord, by the letter dated 31st August 2023
no, when you have fixed when you have fixed
on
the date today,
12th September and my lord 20th September. My lord.
22nd.
when by which proceeding you have fixed the date today for the examination of the plaintiff witness? By which proceeding? When you inform the date next date to the parties.
My lord, I intimate the date by a letter, my lord, 31st August 2023. My lord.
Okay. Yes.
Lord, I have very little to say in this, Lord. This is something which is completely out of my hands. It's my client's desire. Lord,
Lord,
that is
I'm for the defendant number 1 and 2, and my learned friend is for defendant number 3, my lord. Here, an order was passed by your lordship, dated sometimes in 28th February 2023. 8th February
8th February.
2023, my lord, where your lordship has specifically directed
So why
the counsel for the plaintiff has filed the instant application. My lord, it is at the instance of the application of the
that's he has
plaintiff.
admitted, he has admitted
Yes, my
that
lord.
on his
Now,
application.
counsel for the defendant has not raised. My lord has directed for appointment of commissioner to examine the witnesses of the plaintiff as well as the witness of the defendant, my lord. That was that. Then thereafter, my lord, the dates were fixed for at least, subject to correction, it is 6 or 7 days. I cannot exactly presume that they took to file the chief and to proceed with the examination in chief only. My lord, 6 sittings. The only contention was voluminous document, but my lord, what has happened that beyond what is written in the affidavit in examination also, they have taken certain thing orally. We have raised objection, but we let it the things to continue because with the spirit of the Commercial Courts Act, we knew that we'll cover the issue at the time of the cross-examinations. My lord, they know this. Now, on the last occasion, my learned friends also appeared for the plaintiff. And at that time, what has happened? My lord has directed on the last occasion that let it be so, because they came up with a plea that the cross-examination has to be borne by the defendant. So we say that whether at the time of the examination of the defendant witness, at the time of the chief, we will bear the cost and they will bear the cost for cross-examinations. So my lord at that time directed, no, you carry forward with your expenses for the cross-examination of the plaintiff, and the witness of the defendant will be borne by the defendant. So this is actually happening in every commission, my lord. So my respectful submission is that what is the pick and choose method and what is the desire of the plaintiff, on the very sweet will of the plaintiff, the learned court's order can be flouted, my lord. So this is my submissions. Let the commission continue and let the cross-examination begins.
So why so late?
My lord,
Because there is an order date to.
my lord, there's an order. My lord, your lordships have passed an order in February. The commission was duly constituted.
Even in the May, you have not
Yes.
made some submission, and as per your request, it was
My
extended.
lord, I bow down to your lordship.
Then-
My lord, the company, the company, my lord, these are my instructions, my lord. My lord, this is something which, my lord, we have been proceeding. I can vouch for my learned friends also. We have been proceeding with great expedition. But my lord, only after the examination in chief, seeing that it took 12 sittings have been held in which the examination, and my lord, your lordship were very graciously pleased to extend the time also, given the fact that there are voluminous documents. Lord, I am not on the merits. My learned friend may have a brilliant case on merits, but today we are only on procedure. The only question is, my lord, whether, my lord, I can come up before your lordship with an application,
No,
praying before your lordship
it-
for
it-
this
it
to
is
be
the
done
right of
before
the
the court.
parties. You can file an
Yes.
application.
Lord, I
but
shall do so.
Matter is fixed today for further examination of the
Yes.
witness. Correct.
Yes,
It
my
was
lords.
informed on 31st, and you have given the.
On first.
But you have not made any application simultaneously to this court, either to stop or
Yes.
to change or whatever it is. Now today is the examination. This is the way. Then the examination of the
Lords.
witness is delaying.
Yes. My lords, I understand. I also understand that we are guided by the Commercial Courts Act. My lords, I was humbly praying for just 1 day or maximum 2 days time to come up with an appropriate application. Your lordship will decide on merits. My lord, and whatever order your lordship passes, my lords, we shall abide by that. My lord, but this is the difficulty that my client is faces. I've come before your lordship only
You are
to.
the plaintiff, and your plaintiff,
Yes.
plaintiff is a company limited. It is not a private person.
It is a private limited company, my lords.
Private limited company, but it's a company.
Yes. Yes, my
Correct.
lords.
So, and
There is, my
the
lord, some.
plaintiff has filed an application for appointment of commissioner, and with the consent of the parties, it was appointed, and the remuneration has been fixed by this court with the
Yes.
consent of the parties itself. So, at this stage, it is very difficult to
My
proceed
lords,
with the
my
matter.
lords, I understand, my lords. I will come, my lords, only one, because the company is facing losses. My lord, that is something which obviously should not be an excuse at this stage. My lord, but kindly permit me to, I'll come by way of an application today. Yes, my lords, today there's a time waste insofar as the Commercial Courts Act is concerned. 12 September commission was supposed to be held. Examination was supposed to be done. My lord, that is completely due to my fault. However, my lord, this is only because these are the instructions which have come, whereby, my lords, we have been asked to file an appropriate
But the
application.
matter was mentioned by the commissioner,
Yes.
not by you.
Yes, my
And
lords.
today's the date. What?
My lord, one more thing, your lordship, that at the time, very threshold, when this commission was commencing, at that time, the plaintiff was not in financial distress. Now that suddenly, after 6 or 7 sittings, the financial duress cropped up. My lord, this is something very unbelievable, and they have consented to it. Now they're stopped, my lord,
This is,
saying all this.
my lord, it
Because
was my
this is
application.
something, my lord,
Go and
they are delaying. We will file an objection. The matter will be delayed.
I shall do so, my lords.
My lord,
I shall do so.
please
I
pass
shall
an
do so.
order, my lord, because
My lord,
this.
My lord, one thing, my lord, one precarious thing, my lord. We had given 5 to 6 commissions date, my lord. The client is behind me, my lord. He is not, my lord, this is the balance sheet of the client, your lordship can see, my lord. He is under financial consent. The matter is about after there was a fire over there. I am supposed to get 1 crore 40 lakh rupees.
So you
All
could
the
have been
things
filed an
had
application.
damages.
See, the commissioner has informed you on 12th.
My lord,
12th
commissioner has informed,
September.
I admit, my lord. I also informed there is a financial
When
stringency.
your company came to know that your company
My
is in
lord,
financial loss,
my lord, if they bear the,
it might be in the
my lord,
month of
let
March.
my lord,
Yes,
let
my
my
lord.
learned
That is
friend
correct.
bear the cost of cross-examination
No,
of
why?
mine, and
Why?
let me bear the cross-examination, then we'll try, because he's telling he will take 14 to 15
No,
sittings.
I have never
One
seen it.
sitting
Nothing
cost
is recorded.
23,000 rupees, my
Nothing
lord.
is recorded.
My lord, we are in financial stringency,
My
my lord.
lord,
Really, my lord, my client
my
is
lord, kindly
behind me,
see
my
the
lord. What can
balance
I
sheet,
do,
my
my
lord.
lord?
Kindly
It
see the
is his
balance sheet.
shoot, my lord. If he doesn't want to
It should have
proceed
been in the
with
month
regard to
of
commission, my lord, what can I do, my lord? I had requested him many times, my lord. He's,
But you have not come forward
my lord,
for
then,
this court.
no,
You
no,
have taken the shelter of the commissioner.
No, no.
Commissioner has mentioned the matter.
No,
You
no.
have not mentioned the matter.
no, my lord, I was supposed to, I had given a letter to the commissioner. I was supposed to
You have
mention
given
after
a letter
12.
to the commissioner. You have not come in.
This
before
date has
this
been
court
fixed
by
by,
filing an application.
no, the returnable date is not today, my lord. Before the returnable date, we ought to have come, my lord.
Today is the examination.
No,
of the
no, my
section.
lord, this was not fixed. This was the letter given by the commissioner, proposed letter, not a final letter. It is a proposed letter.
That's why the
I had given reply to this proposed letter, my lord, that I am not able to do so, my lord. Now let me come up with the application, my lord, formal application. Let me give 7 days, my lord.
The matter is listed as to be mentioned on the prayer made by the commissioner appointed by this court for examination of the witness. The commissioner has issued a letter to the parties on 31st of August 2023 by intimating that the commissioner is proposed to hold the commission for examination of the plaintiff witness on 12th of September 2023. And in reply to the communication dated 31st August 2023, the plaintiff by a communication dated 1st September 2023 has informed the commissioner that the plaintiff is not in a position to appear before the commissioner for his examination, and he will take appropriate steps for obtaining appropriate order from this court. It is fine from the record the plaintiff has made a communication to the commissioner on 1st September 2023 by restraining the commissioner for holding the commission on 12th September 2023. But the plaintiff has not taken any steps either to change the commissioner, or the plaintiff will not be in a position to bear the cost of bear the cost of the commissioner. But when the commissioner has mentioned the matter before this court, the commissioner, the counsel for the plaintiff come with the plea that the plaintiff company has sustained loss and is not in a position to bear the cost of the commissioner. This court find that the plaintiff is not interested to proceed with the matter, only to delay the matter, is making one or the other communication to the commissioner and without making a proper application before this court. It is also fine from the record the commissioner was appointed only on the prayer made by the counsel for the plaintiff, and the plaintiff has subsequently also obtained an order for extension of time to file the report by the commissioner. And on the prayer made by the counsel for the plaintiff, the time was further extended till 23rd November. Till
My lord, if they are interested, my lord, to
till
let me give
23rd
me a
November
time for file a
2023.
proper application.
In view of the submission made by the counsel for the plaintiff, this court find that this court requested the commissioner to proceed with the matter. If the plaintiff will not appear before the commissioner, the evidence of the plaintiff will be closed and case is proceeded by examination of the witness of the defendant.
My lord, one thing, my lord, let them bear the cost of cross-examination of my witness, my lord.
The matter appearing at our instance.
Yes.
Today is the date fixed for commission. Lord, plaintiff's first witness is being examined on commission. While doing this, we discovered that there was a few documents, 12 documents, which we need to disclose in the suit. Since it's a commercial suit and the learned commissioner would not have any right, we mention the matter and pray for leave to rely upon these documents. Defendant has repeatedly disclosed additional documents. I have never objected. I don't think they should object to this. And it's the first witness of the
Who is for the
plaintiff.
defendant?
For the defendant.
Yes.
How can I object, my lord, if they want to disclose the documents, further documents?
I will serve the copy.
Yes, yes.
my lord, yes. For
Take
inspection, my lord, we need to
Yes,
inspect
we'll
the
do all that, ourselves, amicably,
When is the matter fixed before the commissioner?
Today, which is the, I don't want to waste a date.
So today is the date how the inspection will be completed.
I am I have to prove my documents. I will take it as if they are disputing it, I'll proceed and prove it.
Listed as to be mentioned on the prayer made by the counsel for the plaintiff. Full stop. Counsel for the plaintiff submit that this court has appointed the commissioner for examination of the witnesses of the parties in commission. This court has appointed the commissioner for examination of the witnesses of the parties and commission. Full stop. Counsel for the plaintiff submit that during the evidence of the plaintiff on commission. The plaintiff has got certain document which is required to be disclosed during the evidence of the plaintiff, and as such the plaintiff paid for disclosure of additional document which was not disclosed at the time of filing of the suit. Full stop. Counsel for the full stop. Counsel for the defendant, there is no objection. Accordingly, the plaintiff is directed to serve the copy of the disclose the document to the defendant by today itself.
Yes, yes, yes.
By today itself, and the defendant is at liberty to inspect the document, inspect the additional document with the plaintiff desires to disclose during the evidence of the plaintiff. The additional document disclosed by the plaintiff be taken on record.
I'm great.
Well, I was making this submission yesterday. Well, the mark in question is silk. Both parties, Millard, I was showing the petition, Millard, have their principal trademark or corporate name, Millard, written on their boxes. My learned friend writes Berger, I write JSW. Jindals, Millard.
Berger Silk or the JSW Silk?
I am JSW Silk. My learned friend has registration, Millard, of the mark silk in a form of a device. He doesn't have a word registration. In all the registrations, Millard, there are, I don't say disclaimer, conditions and limitations. I put it in this way, there are conditions and limitations in relation to the, Millard, mark silk. Why registration? Because by virtue of the registration, one tries to assert an exclusivity over the mark in question. So, Millard, there are conditions and limitations. Like, Millard, silk and Luxol will be used together. The silk, Millard, the right over the mark silk is given to the, Millard, plaintiff, Millard, the manner it's written there. Or, Millard, there is, Millard, no, the word silk is disclaimed. It is, Millard, like this, Millard. Now, Millard, I do not use, Millard, silk, Millard, like a trademark. I define my product or the quality of the product, the paint, or rather I put it this way, Millard, finish of the product or the sheen of the product as a silk finish, which is a mid-sheen paint, Millard. It's a mid-sheen, Millard. It's not a high gloss, not a matte, not a, Millard, Excel finish. It's a mid-sheen finish. So I don't promote it as a, Millard, trademark because my trademark is, Millard, Hello. I am Hello Silk. I am not JW. I have a registered mark called Hello. It's written, Millard, in very big font. Silk is written in very small font, Millard. In, Millard, the tubs. I'll show the tubs, Millard. So, Millard, strictly speaking, Millard, though the plaint is framed, Millard, on a cause of action for infringement, mostly, Millard, infringement per se perhaps will not lie in view of, Millard, the bar or the limitations imposed under Section 17 of the Trademarks Act, read with Section 30 of the said Act. So, Millard, strictly speaking, infringement may lie, may not lie, Millard. But, Millard, secondly, Millard, the question of passing off. Millard, what is passing off, Millard? Millard, passing off, Millard, is a right under the common law, Millard, which is, Millard, preserved under Section 27 of the Trademarks Act. Lordship will find, Millard, the common law rights, Millard, vis-a-vis the plaintiff and the defendant, Millard, is preserved. Who is prior, Millard? So, Millard, mere prior will not do, Millard. To succeed in an action in passing off, the classical test, Trinity test of passing off, one has to succeed. A, one has to show, Millard, the defendant, Millard, defendant intends to, Millard, piggyback on the goodwill of the plaintiff. B, Millard, there is misrepresentation. The defendant misrepresents to the general public and the members of trade that its silk is connected with Millard, the plaintiff, or its paint is connected. And Millard, thirdly, Millard, which is calculated to injure Millard, the plaintiff. These are the classic Trinity test of passing off, coming up from Millard, the warnings case of 1981, Millard, all year. So this is where we stand today. Now, Millard, kindly, if your lordship takes Millard, I was placing the GA1. If your lordship takes GA1. judgment. তুমি আরামসে করে এসো 12টা তো ফিক্সড আছে Millard, kindly have a look at the petition filed by my learned friend, which I was showing yesterday, Millard. Lordship will remember, Millard. When we stopped, Millard, my learned friends has relied upon registration certificates, Millard, which are, Millard, quite huge. That he has got registration of silk with combination of something, and Millard may not be, Millard, with combination with something. So, Millard, these registrations are from page 62. It carries on till page 190. 119. This is his registration of the marked silk. Millard, it doesn't have, Millard, the conditions of registration in the petition.
119.
Yes, 119. These are his registration, host of registration, what he has annexed.
It starts from page 62.
Millard, starts from page 62,
Yes.
which is silk in relation to paint.
Yes.
Now, Millard, this registration my learned friend has obtained. He has applied on page 62 top, 19th of September 2013, and registration was obtained on 25th June 2018. So, Millard, registration relates back, Millard, the date of application, Millard, notice to. So, Millard, there are various marks: silk, experience silk, Luxol silk, Millard, Badger silk, etc., etc., experience silk. This is annexed. But, Millard, lordship will not get the status report. What is a status report, Millard? Or a legal certificate where, Millard, the conditions and limitations are shown. So, Millard, I'll show it from the supplementary affidavit which was produced at the time of ad interim hearing, Millard. So, Millard, now, Millard, this is, Millard, his silk. My learned friend has also relied upon few copyright registrations which my learned friend has, Millard, copyright registrations of my lord, of my learned friends. Kindly, Millard, takes that copyright registration, which lordship will find starting from page 120. Luxol silk and the artistic work, we call it, because it's like a picture. So in Copyright Copyright Act, it's referred to as defined as an artistic work, page 122. Luxol silk. So anyone cannot write, Millard, Luxol silk, or, Millard, have a label like this. Otherwise, it will be an infringement under the Copyright Act or anything similar to that. Then 123 at 124, Badger, Breathe Easy, Luxury Silk Emulsion, written in very short, very short font, page 124. Millard, 125 at 126, Badger is blown up, and Silk Splendor. Millard, this is what he has, Millard, given for, and there are other. Then, Millard, at I also should show 133 at 134. There are others also.
So these are the copyrights.
These are the copyright.
Correct.
So copyright means, Millard, I cannot use the get up or the label in this manner. So this is how he has placed his petition. So he is dealing with paints or an emulsion, which is a silk emulsion. He has registration of the mark silk in either silk in a device, as the first page 62 and 63, or, Millard, silk with something. So this is where it stands. This is his petition. Now, if your lordship now takes volume 2, how he describes this product. I'll not repeat, I'll not go. Page 141 to page 164 are his invoices. Volume 2. 2 number.
Volume 2.
Yes.
Yes. Page
141, this series of invoices to 164. The earliest invoices relied upon by my learned friend, my lord, or the plaintiff, I put it in this way, is 2015. Now, Lordship takes 141 for my satisfaction.
Yes.
My lord, it's Barger, the first column on the top, Barger. My lord, date of the order 13 July 2017.
Yes.
Product code is the description of goods. So what are the goods for? This is how he is describing. Such and such, F such and such with a number, silk base red. So emulsion, which is silk base red in color. Silk red base, I put it in this way. Silk red base.
Where from you're reading?
Page 141, Lordship will, this will have a column in the
Yes.
box like this. It's very small, Miller, very difficult to read. Kindly, Miller, take Barger. Miller is his corporate name as well as his trademark. Miller, it's 13 July 2017 is the date of the invoice. Product code is code. What is the product code? Description of goods. What are the goods are sold in under this particular invoice? Is Miller silk red base 800 ml with a number. So Miller, it's a red color silk base. Paint. It's a paint. No dispute. It's a paint. Why Lordship will find it? Because the next column is dam stop. Means something which stops the dam. So pure generic. In this trademark, we say Miller, it's generic. Or having a direct reference to the character, kind, and quality of goods.
Yes.
Lordship will find these languages in section 30, Miller. So Miller, these are his invoices, Miller. There are many. Same Miller 142. Now one more thing I'll show Miller, just one invoice. Now kindly take 144.
Yes.
It's 5th May 2015. Product description is Luxol High Gloss. So Luxol is giving an effect of high gloss. This is the invoice of the plaintiff. So this Lordship will kindly take now. Also takes 146. It's 6th of May 2015. This will be more clarified. Product description and the product code. It's Millard on the right hand column, right hand top, 5th May 2015. Millard product description, BP white premium primer.
5th May or 6th May?
It's Millard, 6th May. Lordship is correct, Millard. 6th May.
Yes.
It's a product description, BP white primer. So Millard, white primer cannot be a trademark. Now Millard, easy clean. Means a paint which is easy to clean. Then red oxide primer. So red oxide Millard, which is used either in soap for that red Millard. So there cannot. Then it's in the same category, silk PO such and such. Because it's a description of the product. Then easy clean, Luxol's easy clean, then Luxol stainer and Luxol stainers. So stainer means Millard, which has green in it. So this is Millard how his invoices are Millard. And this is further clarified from Millard page.
What you want to show from this
This is Millard shown. He is also Millard describing its product as a generic product. Because that's my case. If it is generic, it has a direct reference to the character and quality of the goods Millard. Courts have held Millard. That Millard, you Millard may have a registration, but you cannot get a full fruit protection on per se silk. You can get silk with something else, silk with Berger. But per se silk, like ultra, in respect of cements, courts have held ultra per se, you cannot get a protection. Like Millard, sugar free. This was Millard fought out Millard.
What about the copyright?
Yes, copyright, then Lordship has to see Millard whether both products look similar. Silk per se copyright will not give protection. Now Millard, kindly take Millard the two tubs together. Both copyright and passing off Millard, Lordship has to see the test the product. It's a test of eye. This is Millard, my learned friend's product, silk. Glamour. না না তোমাকে দেখিয়ে তো দেখাতে হবে তুমি বলে কিছু বন্ধু লোক এক্ষুনি লাফিয়ে উঠবে কি দেখাচ্ছ ভাই this is my learned friend's product. I believe Millard there is no dispute. This is Millard Berger silk glamour. So Millard he is writing silk glamour Berger. This is Millard silk glamour pro base. It's written here. This is Millard my product. Hello is my registered mark. Silk is written Millard in small way. This is how he is agreed. So Millard kindly take these two boxes. The test is Millard test of a unwary customer with imperfect recollection. This is my box as I sell. This is my. Huh? So Millard take the box from here, not from Millard a commercial judge Millard. Millard sitting here or from the test. So Millard, this is mine. This is my learned friends. Millard, where is the question of passing? Where is the question of trading upon his goodwill? Millard, he has a silk written on it. I am writing silk Millard. Is it itself Millard granting an injunction? Particularly Millard, my learned friend doesn't have Millard a word mark registration. The classic case was Millard argued, I'll show the judgment with a reference to my learned friend in the case of Ayur Millard. If it is fully generic and a connection Millard to the product remotely, ostensibly, directly, overtly, covertly, then Millard this protection card because you are not in a position Millard to satisfy the Trinity test of passing off to succeed an injunction in the interim or an ad interim stage. These are the where is the question of passing off or where are the question of me Millard coming as close as to him or to trade upon his goodwill and reputation. Or Millard, this box I have launched in the market Millard to basically Millard cause injury to the plaintiff. This is a passing of action.
Why the silk you have taken out?
Yes. Now Millard, silk Millard in the commodity of plaint when the first it was moved, I'll show Millard, all are there Millard. It is Millard the ultimate sheen of the plaint. Not only I use, Dulux use, same silk, Nerolac use, Millard Shalimar use. The finish of the product is a silk product. In fact, in the ad interim order, the literatures were shown to the honorable single judge who was then taking the product. Millard, naturally, injunction was not granted because it was Millard observed. I am not using it as a trademark. It's Millard permissible in the act, Millard. The act permits me, Millard, to Millard describe my product on the character and the quality of the product itself.
Yes.
Mere silk Millard, if something is a generic mark or something is very generic, under trademark Millard, you can get a protection. If it ultimately doesn't result in a technical achievement. Anything Millard which gives a technical result Millard, under the Trademarks Act Millard, it's not protectable or registrable under section 9(1)(c) of the Act. I am not going that far Millard. Millard, generic words can be protected, cannot be protected. Like Millard, I give an example.
Mr. Ghosh should continue, my lord. May I have your lordship's leave, my lord?
Yes.
Why, Millard? Why it is generic? Like Millard, I give Millard an example. Millard, Apple's lordships in the Apple device is not generic in respect of electronic goods. It's not generic because it has no connection. But Apple would be generic in respect of food products. So in respect of food or food products or fruits, you cannot have Apple as a trademark. You can have if you get a word mark registration. Some people succeed in
So you mean to say this word mark registration has not been obtained, so it is generic?
Yes.
So
I am now addressing on Godmark, he doesn't have it. There are host of disclaimers disclaiming the word sale. Kindly make a note of it.
Correct.
If you, Millard, it's one thing, Millard, to say, Millard, registration is nothing. Millard, let us, Millard, registration is statutory recognition of one's pre-existing right of a trademark in common law. This is Millard, right from 1965 Supreme Court. Millard. Registration gives better protection.
Correct.
Or a statutory protection. If my learned friend Millard had a registered wordmark silk, still Millard, I am giving it. He doesn't have it. Still, Millard, I can argue, Millard, the prima facie invalidity of a mark is a defense to infringement, Millard. And Millard can succeed if I, Millard, can show the grounds made out in section 30 or Millard section 17 of the Act.
Okay.
Lord, you will remember, Millard, we are doing our division bench held, Millard, in a Ganesh matter, Ganesh Atta case, that if it's a household mark, if many people are using, it's irrespective if you use this from 1936,
You cannot
or
be. Yes.
you cannot get it. Millard, we were on the receiving end, Lordship says. So, Millard, this is the law. Law has been now, Millard, held by our division bench in the one manner. Supreme Court has upheld it. In the ad interim stage, you can't succeed. There are, Millard, conflicting views of other high courts. But so far, our high court is concerned, this is, if it is very generic, or many people are using, I have to prima facie come and show that I am a paint company. There are other big players, Shalimar, Nerolac, Dulux, etc., all use or all describe their product as silk. If I am prima facie able to satisfy it before your lordship today, Millard, I can escape an injunction.
Okay.
Second, so Millard, the second argument, Millard. The second argument is, Millard, Millard, infringement action, Millard, is a wordmark registration, Millard. Merely because, Millard, the products look completely different, Millard, it's inconsequential. If it has a word registration, inconsequential. In certain cases also, Millard, our division bench says, Millard, that, Millard, if it is like customary in trade, you can't get an injunction. Even if you have a wordmark, the defendant doesn't challenge. But if a passing off, if there is something called, with inverted comma, Millard, added matter. So, Millard, the boxes looks different. The label looks different. He writes Barger, his principal trademark. I write my wordmark, hello, in a much bigger form. And silk is giving basically a quality of the product. Then, Millard, this added matter, Millard, I can escape an action in passing. This is 1965 Supreme Court 980 para 29. I'll give the reference to your lordship. So on the boxes itself, merely because silk is written, Millard, there is no action for passing off can succeed. Because it's completely different, Millard. Neither I write silk, Millard, as he does. Neither I, Millard, write it in the same font. Neither I have blown it up. I'll rather say, Millard, he's too touchy with it now. Now, Millard, now let us take, Millard, what's query of your lordship, Millard. Kindly now have a look at his cease and desist notice. Which is at page 220 of Millard volume 2. This is a notice issued in the year 2019. It is.
Yes.
Lordship will take Millard. He sells Millard, para 12, page 221. Recently, our client, para 12, page 221.
Yes, this is the case they have made out.
Yes, this is my packet. This is so, Millard, I have shown, I have shown the packet, what is there in his cease and desist notice. So, Millard, with this box of hello, which is square in shape, I am hello. Millard, I am showing, Millard, the silk is one of the end products of emulsion.
Yes.
He says you cannot get silk because copyright and trademark, I have it. Now, my response, there are two cease and desist notice. Millard, kindly take my response of Khaitan Company, which is, Millard, 26 December 2019 at page 227, volume 2.
Yes.
Para D, page 228. The expressions silk used upon the range of products sold under the mark JSW bearing the identified mark hello such and such is a common industry jargon for explaining the type of paint finish and has a mid sheen finish and is easy to maintain, containing the surface with silk finish can be wiped off. Annexed here to articles from various sources indicating the term silk means a paint finish as above named. The fact it is a common industry practice to mention silk upon a paint is further evident from the fact that the entities worldwide are using the expression silk upon their packaging, product description as well as the advertisement with a view to emphasize the characteristics and description of their product. Annexed here to the marked annexure B are the picture of the products, manufacture of the few advertisement and promotional material of expression silk has been used above name. Therefore, use of the expression silk for paint finish is customary in trade and not capable of being protected as a trademark with respect of paint, emulsion and distempers. Now kindly now take a para F.
Yes.
Or Miller, I will read the entire paragraph, Miller. Para E. The attempt to claim, because I don't have to read my petition, opposition again, Miller. It's more or less on the same line. The attempt to claim any monopoly in the term silk in respect of plaint cannot therefore be sustained. Whilst your client has sought to claim exclusive in the term silk, but it has failed to demonstrate any statutory or common law rights with regard to the same. Upon conducting search in the records of the trademark registry, it is evident that your client is not entitled to claim any exclusive right over the word silk per se, and the registration obtained by your client's silk marks containing the word silk are subject to disclaimers, which I'll point out from his affidavit, his supplementary affidavit, and conditions that your client is not entitled to claim any exclusive right over the word silk per se. Therefore, the allegation made in your letter are unfounded, baseless, groundless. It is submitted that the trademark registration, if any, obtained by your client containing expressly are liable to be cancelled or expunged, since the term is not distinctive with regard to paint, emulsion, distemper, etc., etc. And the same is common to trade, descriptive in nature, since no one and no entity manufacturing or selling this can claim monopoly over the same. Now, kindly take para F. Without prejudice to the above, it is submitted the fact that your client cannot claim any exclusive right over the word silk per se. It is evident from a search conducted from the trademark registry. Now, kindly, rest are all denied, not necessary, Lordship. There are some enclosures which were there at the ad interim stage, and Millard, nothing except one document, Millard. Kindly take annexure A referred to in that reply to cease and desist notice, Lordship, at page 235.
Yes.
Page 235. Now, Lordship will kindly take, this is a part of the petition, Millard, because they have annexed it. Millard, kindly take page 236. Lordship will find emulsion. I was saying emulsion. Emulsion is a water-based paint with vinyl acrylic glistens added to finish hard watering. Then matte, sheen, then satin, then Millard silk. Silk gives high sheen finish with the hardest wearing of all emulsion paints, goods in humid area. So Millard, the paint is hard. It's a mid sheen, Millard, high sheen. And Millard, it's very good for the humid area like us. Now, Lordship will now kindly take the next page 228.
228.
238. I'm sorry, 238, Lordship.
In the middle, silk and soft sheen.
Silk, excel, satin, and soft sheen. So this is a sheen of the ultimate result of the paint. Then Lordship will kindly take page 240. Silk finishes are easy to clean. Silk and soft sheen. Miller 240 bottom. Has my lord found out? Silk finishes are easy to clean as well as suited for wall. They reflect a small amount account of light
Yes, this has
and
been
more
denied by
amount
the
of light
plaintiff also.
which can be infection, our silk finish is available for wall. Yes.
This has been denied by the plaintiff also.
Milord, plaintiff's case is like this, Milord. Plaintiff's case is like this. Plaintiff says, look, what you have given is a internationally what he said. So far as India is concerned, that the IS specification do not recognize silk as finish as product. This is what he has said. Now I'll show his affidavit in reply. Now, Lordship will kindly take, Milord, one more page, Milord, for my satisfaction from. This is what I show, Milord.
Regarding the international thing, that is not what I have said. I have said they are of the international companies, for which reason they don't have any base in India. So there is no transborder reputation of that Lux into India. That is the.
My learned friend will have his say, Milord. I did not interrupt. No, I did not interrupt you for a second.
Okay, continue.
I did not. Page 243. This is, Milord, part going as part of my response. Is matte or silk the best finish paint product for walls? Kindly, Milord, takes, Milord, the bottom. When to use matte paint? Just over there. The silk paint dries to a smooth, low sheen finish and provides a graceful glow. This paint is elegant and easy to maintain, but it is slightly shiny surface and might highlight some surface imperfections. Now I kindly take when to use silk paint, page 244. It's called silk. Which to use silk paint. Silk paint is sophisticated and elegant. It is less porous than matte paint. It does not get soiled as fast. The mysterious glows makes the paint appropriate to use in the kids' bedroom, hallway, etc., etc. Now, Lordship will now take, Milord, page 248. It's, Milord, coming from Dulux, Milord. These are international brands, Milord. Dulux is available in India. Berger is also an international brand. Berger is also there in India. Milord, Nerolac is also international brand, Milord. It's also available in India. So, but Shalimar is an Indian brand, Milord, which is also there. Page 248. Satin and silk are mid-sheen finish, which means they look like a slightly polished surface and reflect a bit of light. Silk finish associated with wall and satin for the woodwork. You can wipe silk work finishes, which makes them very practical. But if you have less perfect world, you shouldn't use them basically because it shows the perforation. Now kindly take others are using, Milord. Page 251. Now Dulux, Lordship has heard, Milord, or Milord, it's a foreign brand, but has its operation in India. They are also in paints in India. Dulux trade vinyl silk, middle portion. Dulux pure brilliant silk, just written like us, Milord. It's not displayed as a trademark. And the first one, Dulux velvet touch. There is, Milord, this silk. Milord, it's little smudged. It's this silk, Milord. I have a better copy, Milord. This silk. I also cannot read from my copy. Now 252.
Persian silk.
Persian silk. Lordship can read. I can't, Milord, with my specs. Now, Milord, 252. Shalimar paints. Pure local brand, Milord. Shalimar is a local brand. If Lordship wants, I can bring all the tubs. Shalimar paints, Milord. Shalimar paints #1 silk. So same, Milord. It's rather blown up. Mine small. Then, Milord, Regal plain. Milord, Nippon. Nippon is also available in India. 252. Vinyl sand silk.
So you mean to say all the companies are using
every company, Milord, has, Milord. This is the finish. Now, Milord, Crown 255 vinyl silk emulsion. Some may be big. Johnston, it's a foreign brand. 256. I haven't seen in Johnston in India, Milord. Milord, 256 silk emulsion. Now, if your Lordship takes his container, পড়তে পারবি? পড়তেই তো পারবো না।
Silk glamour high.
না না, পুরোটা পড়তে পারবি? সিল্ক কি? I can't. I'm sorry, Milan. I'm asking. I can't read so
Your
small.
Lordship, in their packaging, they mentioned silk glamour high sheen made with specifically formulated 100% acrylic washable emulsion that gives a high sheen and glamorous look to the walls.
So this purely descriptive. We say it's descriptive. I just hand up to your Lordship. Lordship will kindly take that. This is very important, Miller, because this is coming out of the plaintiff's packaging. Now you have a product silk, which is, Millard, having an end result of sheen, a mid sheen or a light sheen.
It is one type of the quality.
It's a quality of the product. I bow down, Millard. It's
One
a
type of the-
quality, it's an end result which the paint is giving.
One
Giving
type of the quality.
that's it, Millard. So, Millard, it will be, Millard. Now, Millard, without a wordmark registration, Millard, can a right be claimed? Now, Millard, I'll show Millard disclaimer how it is, Millard, framed, Millard. Millard, every mark, there is a conditional limitation. It was not part of the petition. It was brought by way of a supplementary affidavit letter. Now, Millard, kindly take my next one, Millard. Annexure C.
257.
257. Grateful. Millard, this is, Millard, Apolite Silkwood Asian Paints. This is registered. Millard, there is silk with something you can claim. But silk in isolation, you cannot claim. If you are entitled to, otherwise because you went forward to an authority who is an expert, and you didn't get that, what you got as a silk is with conditions and limitations. It's one thing to say, Millard, in a passing of action,
It is
Millard.
like a brand with the quality. One brand with the
Absolutely.
quality.
Lordship has put it in one sentence, in a correct place, Millard. I say now kindly take, Millard. Kindly take, Millard, how many people are, even Asian Paints uses Millard silk. So, Millard, all big players in India, either Millard takes Nerolac, or takes Dulux, or takes Shalimar, or takes Asian Paints, or takes JSW, the defendant, all use sense silk in a way to describe their product.
And I don't think the poor person can bear the silk product in your.
Oh, these are very expensive, Millard. One tub, Millard, costs this tub, Millard.
770.
This is 770.
No, so minimum 1,000.
That is expensive.
1,000 rupees.
Silk glamour is expensive. I don't say, Millard, products are very good products. There's no dispute. And I'm hello. This is, Millard, fights between, Millard. Someone becomes too touchy, Millard. Now, Millard, first, Millard takes, Millard, I give it, this is part of my reply to this territory note. 257. Acrolite silk wood. Asian Paints has registered it. In respect of what? Paints, lacquers, varnishes. Then, Millard, Acro Silk, also registered by Acro Paints India. Then Satin Silk by a foreign company. Then Vino Silk. Then Silk Smooth by Silk Paint. It's also registered. Then Salimar's #1 Silk Emulsion, which is also registered, which I just now showed below. So they're using it in entirety. Shalimar #1 Silk Emulsion. Now, if Shalimar today comes up, Millard, and says, I have Shalimar #1 Silk Emulsion, anyone cannot use silk in respect of, is it permissible? In law?
Yes.
Then Shalimar #1 Silk, also registered. Then Eco Silk, Millard and Millard, it goes on. Lordship takes the next page, Super Silk, etc., Sun Silk, etc.
You mean to say all companies having?
This is common to trade. So this is all his petition is about. Now kindly, Millard, this is, I also give it to him, Millard. Page 259, annexure Q. এটা তো ওই লাগিয়েছে, এটা তো আমার এর পার্ট নয় তো বোধহয়। আরে क्या बोल रहे हैं आप? This is annexure Q to the petition. It's annexure Q to the petition, which is page 259. Kindly have a look at it. Annexure Q to annexure Q to বার কর না annexure Q. আরে এখান থেকে averment বার কর।
So one is the simple halo, another is the
JW Halo Magistrix exterior silk emulsion paint for exterior packaging type bucket. This is what is Millard impugned in the suit as annexure Q. Millard, kindly take finish, silk finish. Finish is a silk finish.
where you are getting this?
Millard 259.
Yes.
Millard brand JSW.
Hmm.
Application
Majestic.
exterior.
Silk
Paint type emulsion.
emulsion.
Finish is silk finish. So what I am saying, that this use of this halo has a finish of silk. That is all written in the box in a very small manner. The next also is the same, Millard. This is, and Millard, in paragraph 48, I just place it, Millard, volume 1. This is, Millard, impugned in the suit. The respondent has, para 48, page 42, the respondent has also taken help of online shopping platforms like IndiaMart, NearShop for sale of its print product with infringed trademark silk, and these products are thus available within the jurisdiction, etc., etc. So according to this, this is an impugned product. Page 42, volume 1, para 20, para 48. It's annexure Q. So this is halo, whose finish, halo paint, with a registered mark, whose finish is a silk finish. It's a silk emulsion. Whatever he is saying in the box, I am also saying in my box. He is describing his product as silk product because it gives sheen. That's glamour. That's below what he has said it. I have also said so.
Yes.
And my brands at 264 are Halo and Orus. Halo, 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 Orus. And the description of the paint is silk. This is part of the petition. I am only showing his petition. Page 264. I am not using silk as a brand or as a trademark.
Yes.
Now, Millard, this is so, Millard, the application is conspicuously silent of his strength of his so-called registration, of the plaintiff's so-called registration. Now, kindly have a look at a supplementary affidavit, which we stopped yesterday, of Deborshi Mukherjee, affirmed on
7th May 2022.
এটা না 29 সেপ্টেম্বর কোনটা দেখছি এটা কি তো আছে
29 September.
এই তো অমন বেদ দুটো আছে
আচ্ছা ওটা
এটা পরে দেখাচ্ছি
Which supplementary? 29 September
29 September, Lordship. There are two supplementary affidavits
on the same day.
no different dates, Millard. Kindly takes the 29 September one off.
Yes.
Millard, this conspicuously was absent, Millard, is absent from the plaint and injunction application. Thereafter, Millard, it was filed subsequently, Millard. When we took the point, I was not there, my junior was there, Millard.
The point, Your Lordship. We on ourselves, on the very first day, said that
Yes.
certain documents are missing, and that is recorded in the order.
As per the order, it is there.
Understand me, kindly not mislead.
No, I am not misleading,
Yes,
sir. You have not annexed it.
It is there in the order.
Kindly, Millard, take Millard. Millard, I was not there, Millard. Kindly, Millard, take Millard, 9th of September 2023. Silk, Lordship has found.
Where,
It's a
which
device
page,
mark, page number 9.
Yes. Yeah, you have pointed out yesterday.
Yes, Millard, registration shall not give no right to the exclusive use of the word silk as depicted. So he cannot get anything else than what is silk written here. So the action should fail. Now kindly take the next one. Is Millard, page 10, Luxol silk, Luxoi silk, also Millard a device in respect of paints.
Yes.
It's not a word mark, it's a device mark.
Hmm.
Now page 11. Lixol silk splendor is the mark. TM applied for, page 11. Date of application is 8th of February 2001. Millard, TM applied for Lixol silk splendor. User detail 3/3/1997. Millard, kindly now take the conditions. Registration of this trademark shall give no right to the exclusive use of the work silk and splendor. So Millard, silk and splendor goes. So Millard, Lixol remains. Then next page, Millard, page 12. Barger. TM applied for is Barger, label is in the bottom. Device user detail 1/11/2004. Now Millard, condition. Registration of this trademark shall give no right to the exclusive use of the word silk. So silk goes. Millard, 13. Date of application 12/12/2023. Louis Barger silk design. Device of paint. This is also device. Now Millard, kindly take Millard. Conditions. Registration of the trademark shall give no right to the exclusive term silk design except substantially shown in the representation or on the form of the application. So Millard, what he is using, Millard, here Millard, he can use it together. In isolation, he doesn't get any right. Then Millard, the next page, page 14. This is Millard also a device.
Yes.
Barger silk illusions. Millard, kindly take the condition. Registration of this trademark shall give no right to the exclusive use of the word silk except as depicted. So Millard, depicted is Millard that big fonts blown up in the manner which is writing. No other right is coming. Now Millard takes page 15. It's silk design, also a device. Look at the restrictions. Millard, conditions, restriction are all Millard more or less the same, Millard. This is the condition of registration that both labels shall be used together. So Millard, silk has to be used with designs, not in isolation. Now Millard, kindly take the next page. Page 16. Page 16. It's experience seal, also a device. Condition, this is the condition of registration that both labels shall be used together, experience silk. So you can use experience silk together in the manner shown because it's a device. Kindly now take page 17. Again, experience silk. It has to be used together. That's the condition. Restriction. This is subject to registration with such and such.
Yes.
Millard, similar is the condition imposed in respect of Dunia dekhegi jab silk se sajegi zindagi. That's a slogan. Millard, there is a restriction also. It's a device mark. This is a condition of registration that both labels shall be used together. So you have to use it in part of this entirety as the label. So you cannot pick and choose from the words forming part of the label. Now Millard, 19. Experience silk. Again Millard. Page 19. Again device. This condition of registration that both labels shall be used together. Now Millard, he now comes up with my trademark applied for as hello. That's Millard, page 20. which is, my lord, I have just shown my box. Silk is in the very small way. Page 20, my lord.
Yes.
So the main part is the halo.
Yes.
And my lord, it is shown what is the effect, how the trademark registry is seeing it. Page 21 is the status report. JSW paint halo level. That's a trademark applied for. Has Lordship found out page 21?
Yes, got it.
Yes, trademark applied for. They describe it as JSW paint halo level. Millard, it's Millard page 21. Millard, 1, 2, 3, 4, 5, 6, 7, 8. 8 TM applied for the 9th column. Page 21, 9th column. So Millard, it's JSW halo. This is opposed before the trademark registry. Millard, this is the opposition, Millard, on relying on what is Millard. So Millard, this is the first supplementary affidavit. Now Millard, I come to the second
Kindly come to the page 21.
21, Lordship.
Kindly come to the last.
Yes.
The opposition rectification details.
Yes.
Dated 27 May 2020. Opposition number so. What has happened to this?
Millard, this is pending, Millard.
Pending.
This is the opposition, Millard, Lordship, page 24. He has annexed that. That I cannot get hello where silk is written in a small book. Because he is silk.
Page 20.
Page 24, TMQ. Now there is one more supplementary affidavit, Millard, which I place. Then I go to the my Millard opposition that came thereafter.
Yes.
That came before that, Millard. Kindly take copy of the supplementary affidavit. It's a second supplementary affidavit. This is 11th of May 2022.
May.
11th May, Millard. So thinner one. Millard, one more supplementary affidavit, Millard. Kindly please.
Supplementary affidavit of 11th May.
It was filed, Millard, upon obtaining leave from this honorable court. This is this particular affidavit, Millard, page 11. Affidavit in reply filed is taken on record. Learned senior advocate for 6 time to file a supplementary affidavit. Let supplementary affidavit be filed. Now, Millard, kindly take, Millard, para 12, page 5.
Yes.
The pictures of the product given by the respondent in annexure J page are taken from various web platforms, but there is no actual presence of commercial presence of such product with trademark in the name of different other person in respect of the trademark silk and various other expression as revealed from the extensive market survey carried out diligently. So it's a market survey of the plaintiff. Millard, annexure B. Now, Millard, his second Millard point, which Millard was, my learned friend was indicating, para 20. The respondent, para 20, page 8. The respondent has also referred in their affidavit in opposition about the website of Dulux Paint, paragraph 4R, and the documents in relied on such and such, but the web page of Dulux Singapore being part of such and such worldwide classifies paints as matte, emulsion, matte, lotion, stainwood, gloss, high gloss. None of the website owned by such and such as silks finish. The same would not have any sale in the transborder reputation. Copy of the web page annexed. Then para 21, the petitioner has also found classification and the specification of the finish of paint, which is widely accepted in Indian standard by BS, is recognized here too with the letter G, which does not categorize silk in the terminology in the class of plant, which again demolishes the contention of the respondent that the expression silk is a commonly used paint by different business houses, and the same is used merely as a description to indicate kind and character of the film and texture and not as a trademark. So this is his stand. Now Lordship will kindly take Millard the market survey, which is relied upon. Millard para 12. His market survey, page 12, Millard. I stand corrected. Yes. So Millard, Apple, his market survey, Millard. Millard, Appolite Silkwood, Asian Paint India, Acrosil India, then Satin Silk is Netherlands, rest all are in India, including Millard Classic Silk, Eco Silk, etc., etc. Then Millard, Lordship will find Millard the next page, para 13, middle portion, Top Silk, Aqua Silk, Silk Star. These are America, Netherlands, rest are all India. Then Millard, Silk Upal, Germany, Airbus, GmbH, Germany. Then the last one, Silk Coat, must be Millard, Turkey, not Tarly, must be Turkey. Then Millard kindly takes the next page. These are all in India. Then my learned friend Millard tries to portray Millard that first of all, Millard, I have to only show in the ad interim stage, Millard, that Millard, there are many users of silk. And silk is an industry practice for denoting or describing a plant whose texture is a semi-sheen texture, which is a silk type. So, Millard, in the survey, market survey filed by the plaintiff comes out that Millard, these are Millard, Indian Millard companies, Millard, who are using silk. Correct. And silk per se is being used by Canada, Farben, India. That's Millard, page number 12. There are Millard international brands according to his plaintiff survey 1, 2, 5, 6, 7. 7. Only 7. Rest are all in India. So all use silk as per the plaintiff's own survey. Millard, in respect of this particular Millard paint, including Berger, the last one. Yes. So Millard, it's a quality, end quality of this particular. So Millard, there's a market survey. Millard, merely because someone, page 14, Lordship will find Shalimar. I'll bring Shalimar also, Millard. Shalimar, page 12, Millard, serial number 7, Shalimar number 1. So whatever I have shown, Millard, these are all here, Millard. Millard, to give this survey, Millard, the plaintiff has Millard, gave Millard as many as Millard, I count it on the next occasion and say Millard, silk is present in respect of paint in India. Except Millard, 7 Millard. Millard, the case now says in para 15, look, their total sales figures is very less, I am much big. That does not give you a right to stop everyone else. You may be big. It may be highest market share, but there are other players in the market, which your survey or the plaintiff survey establishes. Millard, facts established, facts admitted need not be proved. It's your survey. You are giving 30% in India using silk in respect of paint. So it's common industry practice. Now your survey says that I am very big. My sales is much more. Is it a ground, Millard? That's Millard, page 16. They are minuscule, but there are players in the market with silk. And particularly when there is a disclaimer. When you went forward, asked for a protection fully, which was a restricted protection. Yes. There are judgments of Millard, this court, going up right up to Supreme Court, which says Millard, if there is a disclaimer, per se word, you cannot use. So Millard, this is Millard on the silk. And Millard, he has annexed. This is from UK dictionary, Millard. UK Millard. This is Millard, page 17, which silk is nothing but a noun and relates to the cloth and thread. My lord, I have other English dictionary, which my lord has a referral to the paint, my lord. On the next date, my lord, I'll hand up the dictionary. This is annexure C. Now annexure D also, my lord, is an English dictionary, my lord. It's also of the UK version. At annexure D, caterpillars, etc., etc. So, my lord, this is says so. Here has no connection with silk. Now, lordship will kindly now take some other article from the internet has been given to show, my lord, that, my lord, silk may not be a sheen of the plane. It is not recognized. This is also from the internet, my lord. That's, my lord, annexure E. Page 20, lordship. Annexure E. Excel satin. These are there, but silk is semi-gloss, but silk is not there. Then lordship will see, my lord, the IS specification, my lord, which my learned friend, my lord, relies upon for the terminology at page 25. One page, my lord, the last page.
Yes.
Terminology, serial number 3. For the purpose of this standard, the definition given in such and such shall apply. Volatile organic, matte finish, eggshell satin finish, semi-gloss finish, glossy finish. So silk does not find space in Indian specification. That is a document which he has given by way of a supplementary affidavit. Now, my lord, I don't go that far itself. Kindly look at, my lord, the description of the product in his box. Look at the description of his products in his bill. And, my lord, his market survey.
Yes.
This is, my lord, on, my lord, the facts. My lord, now I go to my opposition. If lordship has the time today, or, my lord, I do it on some other day.
12 PM it is there.
Except next Wednesday, any other day. Next Wednesday, I am in some.
Counsel for the respective parties are present. Counsel for the plaintiff argued at length, but due to paucity applied, argument should not be completed. Fix. Give the date. 27.
Okay, John.
No, Wednesday you are not available. 27.
Next Wednesday, I have some. Next 28th. I have
27. I am fixing.
I'm
27.
এখানেই তো আছে তো, ও সকালেই হয়ে যাচ্ছে তো।
No, no, পরপর দুদিন রাখলাম. We can also reply to it. That's it. If two consecutive dates, my lord, can be fixed, then we can reply.
Only
on
my
the-
learned friend has given me a compilation going that fact. I do believe, my lord, all has not. He can indicate to me, my lord, whatever he has cited, my lord, I can distinguish that.
Well, we have not that will indicate. That will indicate.
পুরোটা
No, no, no.
only যে কটা পুরোটা পড়তে হয় না, ওইটুকু
relied upon them, so how can you?
কোনোটাই রিলাই করো
Some of them will give it.
যেটুকু করেছো ওইটুকুই চেয়েছো।
29. 27 and 29.
Very well.
Grateful,
27
much
and
obliged.
But 29th, I mean, it will differ.
29.
And lordship gives in the first week of October, my lord.
Then it will
But
go to October.
26 would be possible.
26 already fixed.
27th.
Adha matter is there.
Yes.
Then
I'll be arguing on 27th, my lord. Lordship gives me that.
27. 28 already fixed, na?
But 29th, my 29th is okay. No, in fact, I made a mistake. Well, 29th is fine.
29.
Grateful, my lord.
27 and 29.
Great.
Much obliged to your lordship. Grateful to your lordship.
Yes, next.
Lordship, I appear on behalf of the plaintiff.
Item number.
Your Lordship, today was fixed for witness action on behalf of the plaintiff. But Your Lordship, my client was out of town until the 4th, and I need some time to take instructions from my client. Your Lordship, I'm kindly praying for some time.
My affidavit of documents are ready. I can file it. admission and denial, my lord, is ready. I can file it. Lordship keeps it his suit, my lord. His witness is not there. He has to first.
31st July, the date was given.
Your Lordship,
Specifics,
perhaps
pay
my
the
client
cost.
was out of, Your Lordship, I'm
Pay the cost.
kindly, Your Lordship, please.
Once the matter is fixed, adjournment cost. No
Your
leniency.
Lordship, the board of directors are in Chennai. Sir, I need
Maybe.
to take instructions.
Board of directors is not above the court.
Your Lordship, I understand.
Then, once the court has fixed the date, you
Your Lordship.
persons are taking the date and time. And when the matter is called on the day, fixed date, they are taking time. Counsel for the respective parties are present.
Your Lordship,
What you are
thank you.
filing, Mr.
Millard, I have Millard.
You are filing?
Yes, affidavit of admission and denial. From my side, Millard, it's all complete, Millard.
The defendant has filed the affidavit of admission and denial. Let the same be kept with the record. Full stop. The matter is fixed today for witness action, but the counsel for the plaintiff press for time. It is fine from the record. This court has fixed today specifically for the witness action on behalf of the plaintiff, especially fixed for witness action on behalf of the plaintiff by an order dated 31st July 2023. But when the matter is called today, the counsel for the plaintiff prays for time. For the interest of justice, the case adjourned, subject to payment of cost of rupees 20,000 to the legal.
Your Lordship, kindly.
To the State Legal Service Authority within a week from date. Let the matter appear. Give the date.
Takes it after vacation, Lordship.
First December at 3 p.m. It is made clear that if the plaintiff failed to pay the said cost on the next date fix, the evidence of the plaintiff will be closed.
Your Lordship, kindly reconsider the cost amount.
Next.
Grateful. Grateful.
Item number. Yes.
Before the walk of good document.
Yes.
May it please, Lordship. Then on the last occasion, you were about to start it on that question whether Waqf tribunal would have jurisdiction to entertain this suit. On that, there is a bold averment in the petition that Waqf tribunal have jurisdiction. But what argument has been made, I do not know. I'm told no, it has not been elaborated.
Plaintiff has not argued the matter. Only the Waqf board has argued the matter, stating that they have appeared, they are the necessary party in terms of the section 19 notice has been issued, so they are the necessary parties. These are the case.
And therefore, first thing, it is primarily must establish that Waqf tribunal has jurisdiction interest in this matter.
So on the last occasion, you have given all the things.
The plain.
Yes.
Because the Supreme Court has said that in the case of assessment of determination of jurisdiction question, plaint has to be seen naturally. Now, if Miller looks at the plaint, it will also find a suit filed by a party who is not a beneficiary of the Waqf at all, who is not a Mutwali, not a Waqf commissioner, and not a beneficiary of Waqf, has filed a suit as a developer.
Dispute between two parties.
To developer. And he says that defendant number 1, for whom I am appearing, he is obstructing his development by not shifting as per the agreement. And that is the whole case. Now, it is not a suit for eviction. See the prayer, my lord? Prayers of the plaint. Decree for recovery of possession, but what purpose? Recovery possession, A, B both, for the purpose of developing the property.
Recovery of possession.
For property, developing the property. You might not see, what is the basis for recovery of possession? Paragraph 27 of the plaint.
Paragraph 27.
No. Can he come to paragraph 27?
Yes.
Like, having been delivered possession of the entirety of the first floor of the new building constructed at the said premises, defendant number 1 has no right to continue to occupy 6 feet by 10 feet temporary structure erected on the northern side. Therefore, we have received delivery of possession of entirety first floor in terms of the agreement, and therefore no right to occupy 60 feet by 20 feet. Temporary structure. The said structure was made only to provide defendant number 1 temporary accommodation while the first floor of the new building was under construction, and as such, the said defendant was obliged to hand over vacant and peaceful possession of cemetery. This is averment. I'm going with averment, not telling you also whether it is correct or not. Only 6 feet, 60 feet by 10 feet structure in the number Dr. Even Brahmacharya number 6 is possession claim.
Yes.
Recovery possession is claim. To that we have a defense, we will come that he need not come later. So, my lord, it is not a case of eviction of a tenant. This is important. The plaintiff never claims, has not claimed at all, that defendant number 1 was inducted by the plaintiff as a tenant. As per an agreement, plaintiff is claiming recovery of possession of a temporary structure and some servants' quarter also, same thing. This is one thing. Now, because therefore, this kind of suit is not covered by the section 85 of the Waqf Act and his court jurisdiction, the plaintiff have rightfully filed a suit in the High Court where the property is located.
Yes.
And claim recovery of possession that's between a different cause of
Two parties.
yeah, Mutali doesn't come in at all, no question. But I developed the developer, I gave you on the development agreement, you are liable to. This is not one thing. So this in this suit not clearly against me, against a private party. I am also not in any way beneficiary of Waqf property, anything. Now, please see paragraph 38 now.
Paragraph
36 and 38. What telling you, Lordship, shoot is as development, that a subject developed building is completely commercial in nature, and question of allotment and non-allotment of any area in a said commercial premises by and between the plaintiff and the defendant, number one, is coming under definition of commercial dispute under Commercial Courts Act, not under Waqf Act.
yes.
It is a nature. Paragraph what is submitting to your Lordship is absolutely clarified in paragraph 30 of the plaint.
Yes.
Is a developed building is completely commercial in nature, and allotment, non-allotment of the premises by and between plaintiff and the defendant. Dispute is between plaintiff and the defendant, number one. Waqf Mutwali is not concerned with that even. Paragraph 30, will not now read 38. Plaintiff claims no relief against defendant 2 and 3, who have been made parties of suit as their parties to the tenancy agreement of 7 January, or the tripartite agreement of January 2005, and compromise terms, etc. No relief is claimed against defendant 2 and 3, that they are the Mutwalis.
Yes.
This suit has been filed, therefore, respect of a property which is a completely a property under development, and plaintiff claims the right to develop that, and he says that under agreement we must vacate these two portions also for completing development.
Yes.
Now let's see the next part is decree for damages. That is not for, that is based on paragraph, my lord. Paragraph 30 minutes. But not vacate, not shifting is the cause of action. Paragraph 30.
30.
Compensation. Paragraph 30. Degree recovery possession, and not had, then please go on, middle of that paragraph. As a different number one, made over this, made over the plaintiff possession of a said temporary structure, service, etc. And upon being made over, the entire first floor of a building has been able to complete the new building and expiring, and that is delay has caused them loss and damages. You know, the claim for.
So it is against the defendant number one.
For the one is not a claim for mean profits. The landlord and mean profits, the damages. All they have made it clear. All claim suit is against defendant number one.
Yes.
and not against Mutwali. No relief scheme Mutwali. The suit is based upon a development agreement made between the plaintiff and defendant number one, to which Mutwali is a party. Mutwalis have not made any complaint.
Yes.
Nevertheless, the entire argument of the learned friend, I'm told, is based on the fact that the last judgment of Supreme Court, by which he thinks Supreme Court has said any matter relating to work of property must be referred to. So, may I deal with the judgment much later on, of course, that is not, but may I, show your lordship, even that judgment do not say so. Other judgment 2010, everything says, this cannot be, court has no jurisdiction. Please, come see that judgment. Judgment thou, 2022 judgment আছে আমার কবিতা এলো আমার কাছে
মানে তো
আমার কবিতা বল ওটা কি
judgment.
Then 2022 volume 4 SCC online. Is Malad got it? তোমার তো দিয়েছিল Then Basir Ali Beg versus Farid Pindari.
Just a minute. Not there. You have an extra copy?
Yes, I have a copy. Copy has it. And anyway, we shall give a copy. Extra copy আছে কিনা বলছি আমার কাছে একটা হাতে আছে
On the last occasion, he has given the.
This is well, we got a copy. Do you know? After the judgment can be relied upon is a different thing. Even this judgment do not support the case of the applicant. Please straight away come to paragraph 56 of this judgment. And before that, please, sir, I made a mistake. Paragraph 32, come to paragraph 32 first, 32, 34. And then come to 56. Please come to paragraph 32 and 34. What judgment লিখেছে না
32.
32. কোথায় গেল 32 এর কোন পেজে page 20.
Yes, got
page
it. Got
28.
Page 28.
Page 28. ওপরে 28. ও ওখানে ধারা দেয় লেখা আছে। 32 million. Got it? It is what this, even this judgment is holding this. A cumulative reading of section 86, 89, and 90 would show that bar of jurisdiction under section 85 is not total and omnipotent. And that there may be cases which could still be entertained by civil courts. In fact, section 93, which prohibits the mutualis from entering into a compromise with the opposite parties in any suit, also refers to court. Section 93 is thus: bar to compromise suit by the against mutuali. No suit or proceeding in any court by or against mutuali of a work of relating to title to work of property or the right of the mutuali shall be compromised without sanction of the board. Then, paragraph 33, we have seen it elsewhere. The second 83(2) specifically enables any mutuali any person interested in Waqf and any other person agree by an order made under the Act to invoke the jurisdiction of the tribunal for the determination of any dispute, question, or other matter relating to the Waqf. Section 83(2) does not make any reference to the Waqf board. However, Section 94(1) enables the board to apply to tribunal for appropriate orders. Wherever a mutwali fails to perform an act recognized by Muslim law as pious, release, etc. Under Section 61, 94 Act, such an application can be made by the board only to the court, but now it can be made to tribunal under Section 94. Then 34. In view of the language employed in Section 83 and 85, coupled with the reference to civil courts in Section 86, 90, and 93, it appears that the question of bar of jurisdiction civil court has been left by the lawmakers to the vagaries of judicial opinion. I don't like the expression, vagaries of judicial opinion, and has given rise to conflicting decisions to some extent. It's not a complete outstar. And it depends, they themselves say, left to the question of bar of jurisdiction. So by simply relying on this judgment, one cannot say all questions relating to Waqf property is
required to be.
Therefore, you don't have to say anything else. Similar paragraph 56. 56. Page 64. Here, the Supreme Court are analyzing all these sections. 56 towards the bottom. A combined reading of section 68, 6, 86, 90, 93 goes to show part of jurisdiction of section 85 does not apply at least to the following matters, covered by section 686, 86, 90. Following matter. One, a district magistrate pass an order, not covered, and I'm not on that. Board may approach a civil court. Board may itself approach a civil court, either to set aside sale of execution of decree, etc. Then 56.3 is important. Mutwali is also empowered to approach a civil court to recover possession of immovable property, which is Waqf property, but which had been transferred by the previous Mutwali without the sanction of the board, etc. That I am at my tenancy was granted by Mutwalis. They have not approached the civil court or any court for my eviction.
There is no dispute with regard to the Waqf. The plaintiff is not having a dispute with regard to the Waqf.
Is a Waqf property, no doubt.
No, with regard to there is no dispute with regard to the plaintiff and the Waqf property. It is only with regard to the plaintiff and the developer.
It is the dispute between the plaintiff and defendant number one.
Defendant number one with regard to the
all two private persons were neither have an interest in Waqf nor the beneficiary of the Waqf.
Okay.
And the judgment on which they rely upon also admits or lays down that the outside is incomplete or omnipotent. There are several areas. Now it is significant if the Mutwali can file a suit for eviction of a tenant of a Waqf property in a civil court. Mutwali need not go to the Waqf tribunal for eviction of a tenant inducted by the Mutwali. Then all disputes between the Mutwali and the tenant inducted by Mutwali relating to tenant's right, civil court have been eviction.
Yes.
Then that's the second way of looking at it. Now, please, now kindly see whether this plaintiff developer would have at all filed this suit before Waqf tribunal. That is a test.
Yes.
In other words, and secondly, you should see whether the Waqf tribunal can grant the reliefs claimed in the suit.
Regarding damages.
What are the prayer ABCD? Can they grant at all? That are two things. Now, Milord, on this, Milord, no submission has been made. In my humble submission, it was beyond really argument to say the Waqf tribunal can grant any of the reliefs, A, B, C. What is A? Direct defendant, a private party, to leave the premises as per the agreement for development. Not as a tenant or anything. Second is also prayer B, also that. And prayer C also rising out of because of delayed delivery of possession. Therefore, damage. Now, in short, the plaintiff case is the agreement was, according to him, which is wrong, of course, that for the facilitating the development of property, we shall leave the area in my occupation, to some area in occupation. And according to plaintiff, when we leave, after construction of the building, when the plaintiff gives defendant one possession of the first floor, then plaintiff and defendant one would also leave a temporary structure and the servants' quarters. And defendant number one has got the possession of the first floor after construction new building, but he has not vacated those two. This is the cause of action. He's not a landlord-tenant suit even. Mutwali has not filed a suit for eviction against me. Yes. I have no privity of estate with the different number plaintiff. So not has been filed, suit have not been filed by the Mutwalis against me. And then with the kindness, what relief, who can file a proceeding before Waqf tribunal? I'm coming to that question. The kindly see section 6 and 7. Section 6 and 7. কোনটা এটা আরো আবার ফিরে আসবো আমি ফিরে আসবো হ্যাঁ ওটা জানি বারবার বেনিফিট কেন বলছি Please will come to section 6 and 7. Who can file proceedings before the tribunal is indicated. Is laid down rather. Even after the amendment. Section 6. If any question arises whether a particular property specified as Waqf property in the list of Waqf is Waqf property or not, number one, or whether a Waqf specified in the list a Shia Waqf or Sunni, the board or the Mutwali of the Waqf or any person aggrieved may institute a suit in a tribunal for the declaration or decision of the question and decision of the tribunal in respect of such property. Mutwali or the Waqf board or any person aggrieved. Aggrieved by what? Section 7 makes it clear. Section 7. Subsection 1. If after commencement of the same is repeated, any past question or dispute arises whether particular property specified as Waqf property in a list of Waqf is Waqf property or not, whether a Waqf president such as Shia or Sunni Waqf, then the board or the Mutwali of the Waqf or any person aggrieved by the publication of the said list of Waqf on section 5 may apply to a tribunal. having jurisdiction in relation to property for the decision of the decision of the question and the decision of tribunal shall be final. So, when a person aggrieved by the list, he is not a person aggrieved. The plaintiff, in my humble submission, could not have filed a suit in the work of a tribunal. The first hurdle for the applicant.
Yes.
Now, the first hurdle on the learned friend part, the applicants, is to show that this plaintiff could not file this suit in the work of tribunal. There, Millet, he has not made any argument at all. Even.
Yes.
Now, Millet, you will also can we come back to the judgment of that Rashid Ali Wali Beg. This only they have read the judgment, some portions, perhaps the head note part. His judgment goes, doesn't support his argument, even. Paragraph 68, Millet, can we come to the end of this judgment? Paragraph 68. Which is at page 68. The dichotomy created, Lordship, remember the expression, matter left to vagaries of judicial opinion? 68. The dichotomy created in some decision of this court is creating complications between the properties which are admitted to work of properties and properties which are disputed to be so, is on account of misapplication of two limited questions in section 6 by 6.1 and 7.1. This is what I've just now read out.
To the whole,
of the act, including section 83. Two limited question, two limited question, section 6 subsection 1, 7 subsection 1, and section 83. As a cost of repetition, we should point out that section 83.1 provides for determination of any dispute, questions, or any other matter. One, relating to a work of, not property, work of. And two, relating to work of property now separately.
That is separate, yes.
This prescription cannot be taken to have been curtailed or circumscribed with section 6 by 1 and 7 by 1 to come to the conclusion that tribunal assumes jurisdiction only when the property disputed to work of property. This is what they say. That's
So
very. Now, then 69. In the case on hand, the property is admitted to be a work of property. Therefore, to allow the plaintiff to ignore the work of tribunal and to seek a decree of permanent injunction and mandatory injunction from a civil court would be to ignore mandate of 83 and 85. They would allow the plaintiff to ignore the work of tribunal and say it, and which speaks of any dispute, question, or any matter relating to a work of property. There is also one more issue. In the written statement, defendant number 1 has admitted the existence of the Waqf and also admitted that the father of the plaintiff, by name Riaz Ahmed, is the Mutawalli. But the claim of the plaintiff that he is the beneficiary of the Waqf has been denied. Therefore, a question as to the nature of the Waqf and whether the plaintiff is a beneficiary of the Waqf has also arisen in this case. This question is necessary to be decided by the tribunal and not the civil court. This question is not. That's why I repeatedly saying it's not by beneficiary or anything. So, my lord, please now come to, my lord, other part of the judgment I come to. That my humble submission is that Waqf tribunal cannot even entertain this suit, number one, and cannot, number two, cannot grant reliefs claim in the suit. This suit
Yes.
This suit has not been filed by Waqf board or any person relating interested in the Waqf or beneficiary of the Waqf. Yes. And no relief has been claimed against the Waqf. This is now where I'm humbly submitting. Against the Waqf at all.
Yes.
Part of jurisdiction, the ouster jurisdiction is not omnipotent or wholly ousted as laid
That is
down by
required.
this judgment itself. Now, my lord, next comes the question, my lord, I humbly point out, well, then construing a statute in the light of all this, what should be the court's approach? Lord, my humble first submission is that court presumption is always in favor of civil court jurisdiction. There are judgment galore. And when the exclusion or ouster would be express or even otherwise the implication, no other implication is possible. There are two judgments on that. But I do not know my learned friend placed before your lordship the 2010, the judgment.
2010, volume 14.
Volume.
SCC 588.
Yes, saying that. Take it.
He has relied upon that. Waqf board has relied upon that citation.
Take it.
2010, volume 14, SCC 588, paragraph 3, 7, 10.
Next. This judgment has been referred to in the next judgment of the Rashid Ali Beg, Wali Beg. And not kindly first see, this is tabular statement have in tabular form, it has been set out. Please me not come to paragraph 35.
That has been followed. If you will kindly see page number 4, page 5.
Page 5.
The 2010 volume 14 is followed by the Supreme in this.
With so many judgments, my lord. I am only pointing out, my lord, to serial number. Ramesh Govindaram is serial number 3.
Page number?
Ramesh Govindaram, the 2010 volume 14 SCC, serial number 3.
Yes, Ramesh Govindaram.
And this is kind of similar. They suit for eviction of the tenants occupying Waqf properties. This suit about subject matter suit. Suit for eviction of tenants filed before the Waqf tribunal. Filed before Waqf tribunal were decreed. Tenant filed revision petition before the High Court. But the High Court, it is an
internal page 31.
Yes, he got it.
In the table.
So Ramesh Govindaram is the case law. What is the case law?
High Court dismissed the revision petition and the tenants were appealed. This is
2010 volume 8 SCC 726.
2010, volume 8, SCC.
Volume 14.
726.
Volume 8 or 14.
No, 14 is another one.
What the next?
14 is the
Eight.
Waqf board versus
7 to
Sangeet.
6. 8. That's right. This is 7 to 6. Yeah, ma'am, because you know, it will relieve me. I don't read all the judgments. Summary is meant by Supreme Court. Suit for eviction of the tenant occupying the Waqf property, the nature of the suit. Suit for eviction of tenant filed before the Waqf tribunal was decreed. The tenants filed revision petition before the High Court, but the High Court dismissed the revision petition. Hence, tenants were on appeal. This court, so Supreme Court held that the Waqf Act 1995 does not provide for any proceeding before the tribunal for determination of a dispute concerning the eviction of a tenant in occupation of Waqf property, or the right and obligations of the lessor and the lessees of such property. Holding that suit for eviction tenant from his admitted Waqf property could be filed only before the civil court and not before the tribunal. And there may not be views of the High Court on and the views of High Court on the Pradesh discussed.
Andhra Pradesh High Court
were not allowed, and views of High Court of Allahabad, Karnataka, Madras, and Bombay were affirmed.
Yes.
This judgment not which I shall rely upon. Then we see the next item, 304. This is from West Bengal. West Bengal Waqf Board versus Anis Petam.
This is the 2010 volume 14.
2014.
2010 volume 14.
Volume 14.
Yes.
Yes, exactly. 2010 volume 14. It is page
588.
588. The summary is this, civil court. Question raised were whether the division of mimul property into two distinctive parts, one for alalawlad and another for pious and religious purpose, is in accordance with the Act. And two, whether the Waqf Act is applicable for the portion of the property earmarked for Waqf alalawlad. Nature of the Waqf alalawlad is important. Whether this Waqf is a Waqf alalawlad or not, that is to be
decided.
Court has to be told about it. Then what the court held? Well, the single judge of the High Court held that the Waqf Act is applicable for the property earmarked for Waqf alalawlad. Held that Waqf, the division bench, the High Court reversed it. The Act is not applicable to Waqf alalawlad properties. While reversing this decision of the division bench of the High Court, this court held any dispute, question, or other matters are words of very wide connotation, and that the tribunal has all the powers of the civil court, including power to grant temporary injunction, Order 39 CPC. This court further held that though Section 83(2) refers to orders passed under Section 83(1) and 84 are independent. Very good. Now, can you see the last portion? Now, item number 4. This is important. The decision of Ramesh Govindaram, they are not overruled, was distinguished on the ground the same related to eviction dispute. Serial number 4. So eviction proceedings cannot be filed in the Waqf tribunal, is not disturbed by the second division bench. And you are concerned with that, eviction or recovery possession. The next, serial number 5, is also a proceeding filed by Waqf board. Waqf board. And yet it also, can you see the last paragraph, next page, High Court holding the suit was maintainable before the Waqf tribunal. This court pointed out clearly that the High Court mistook the suit to be one for eviction, though in fact it was for possession and mean profits. It is not a case of mean profits.
The
Mistook for
damages.
possession. Eviction suit cannot be. There are other judgments which have followed this first judgment, Milord, which is all noted here. Milord, huh? So this is another judgment, a long judgment. Haryana Waqf Board, serial number 8, versus such and such. Here, Milord, suit filed by Waqf Board before the civil court. Waqf Board has filed a suit with civil court on the ground that the property involved was notified as a Waqf property on section 5(2). The trial court decreed the suit, but the first appellate court reversed it on the ground that a question has arisen as to whether a suit property is a Waqf property or not, and that question has to be decided only by the tribunal. There is even no dispute regarding that.
That is
so. Holding the first appellate court set aside a judgment of the trial court and ordered the return of plain under Order 7, Rule 10 of the judgment. Now, please see the next serial number, number 9, Fasila, Munar Basil, etc. Suit was for what? Eviction of the tenant filed by Madrasa committee.
Madrasa, yes.
Not by private body. Madrasa committee filed the suit. Similar to what was found in this, the Madrasa committee filed an application with Waqf tribunal for the eviction of a person on the ground that he was a tenant in respect of Waqf property. Said respondent denied that subject property is a Waqf property, and is also challenged the decision of the court for to that extent of certain jurisdiction. Waqf tribunal first ordered the return of the plain for presentation before civil court, but later recalled the previous order on the ground the issue whether the subject property is a Waqf property or not has arisen in the for consideration. Then we see. Then said order of Waqf tribunal was challenged in a revision before the High Court. High Court confirmed the second order of that Waqf tribunal, recalling the holding that issue relating to eviction of tenant is squarely covered by the decision of this court is Ramesh Chandra Govindaram and Bhadawal Lal is not inconsistent with the Ramesh Govindaram. This court allowed the appeal and restored the first order of the tribunal, that is the plain, etc. Because dispute was regarding tenant. But with the correctness of Ramesh Govindaram, that eviction proceedings cannot be tried, but that is upheld. Well, there are a lot of judgment on this question. They have summarized. Milord, one similar section 15. Other point, Milord, some of the judgment may have to look into. Milord, kindly come to the serial number 11, Dharampal versus Punjab Waqf Board. Suit was possession injunction, etc. Then not in the what is held, section 55C Waqf Act. Then Milord, Amendment Act was never notified. Therefore, 55C had no application. As the court held, ultimately, civil court had jurisdiction to decide the suit by virtue of section 6 of the 1954 Act. I appreciate the endeavor put in by the
Yes.
But after holding and noting all these judgment, my lord,
The court has passed it out.
the summary of law we have read out to your lordship.
Yes. Next.
My lord can now kindly see the leading case, which is Ramesh Govindaram, the 2010, volume 8, Supreme Court cases 726. This was the beginning. It has been cited by my learned friend. But this judgment should have been cited. I'm told he is not cited.
Yes, yes, not given.
This is the beginning. This is the court judgment. Decide করেনি তো? Oh.
Yes.
This judgment has not been overruled, even after amendment. Kindly come to judgment, Lord, to what is suit about. These three appeals by special leave arise out of three different orders passed by High Court of Andhra Pradesh, whereby revision petitions were responded against order of AP Workup Tribunal have been dismissed, and order of eviction passed by the tribunal affirmed. Since the appeals raise a common question of law, determination are hard together. Then paragraph 2, question is whether Workup Tribunal constituted under section 83 of Workup Act 1995 was competent to entertain and adjudicate upon dispute regarding eviction of the appellants who are occupying different items of what are admittedly Workup properties. Workup Tribunal, before whom the suits for eviction of the tenant were filed, answered the question regarding his jurisdiction in the affirmative and decreed the suit filed against the appellant. Aggrieved by said order, appellants filed revision petition before the High Court of Andhra Pradesh. In contending that tribunal was in error in assuming jurisdiction and directing their eviction, dismissal of the revision petition of the High Court was led to the filing of the present appeal. Then 4, whether or not Workup Tribunal can entertain and adjudicate upon the dispute regarding eviction of a tenant holding Workup property under the Workup board, under Workup board, would depend upon the scheme of the Workup Act 1995, and express or implied exclusion of the jurisdiction of civil court to entertain any such dispute. If the Act excludes the jurisdiction of the civil courts, whether such exclusion is absolute and all pervasive or limited only to a particular class of disputes, is also an incidental question that may have to be addressed. There is a cleavage in the judicial opinion expressed on this question by different high courts. Number lawsuit paragraph 5, lawsuit 5, high courts of Andhra Pradesh, etc. Andhra Pradesh, Madhya Pradesh, Punjab, Haryana have taken view that no has got the jurisdiction. The contrary view taken by High Court of Karnataka, Madras, Allahabad, Bombay, that civil courts have jurisdiction. Also, for ultimately, my lord, this paragraph 6, this contrary view is being accepted by Supreme Court. Reference to all the judgments have been given. Now, please come. Lordship has seen in this case that the scheme of the act is now being considered. Paragraph 8 will start the recital of the scheme, historical background out. Work of Act 1954, need for a fresh legislation on subject was our felt, and then next paragraph, then provide effective answer to the question that kept arising. Parliament had to bring a comprehensive legislation in the form of Work of Act 1995 for better administration of the work-ups and matter connected therewith or incident thereto. This is quoted from preamble. This is quoted. Then what definition of chapter? Chapter 1 of the Act deals with the preliminary likely definition. Entire Act is considered. Then High Court different views are noted in paragraph 10. Before we take up paragraph 11, then before we take up the court issue, whether the division of civil court to entertain and adjudicate upon dispute regarding eviction from work-up property stands excluded under Work-up Act, we may briefly outline approach that the courts have to adopt while dealing with such question, ouster question. What approach? Paragraph 12 below. The well-settled rule in this regard is the civil courts have the jurisdiction to try all suits of civil nature, except those entertainment whereof is expressly or impliedly barred. Section 9 of the CPC. The jurisdiction of the civil court to try suits of civil nature is very expansive. Any statute which excludes such jurisdiction is therefore an exception to the general rule that all disputes shall be triable by a civil court. Any such exceptions cannot be readily inferred by the courts. The courts would lean in favor of a construction that would uphold the retention of jurisdiction of the civil courts and shift the onus of proof to the party that asserts the civil court jurisdiction is ousted. This is the approach of the court. Even in cases where statute accords finality to the orders passed by the tribunal, the court will have to see whether the tribunal has the power to grant the reliefs which the civil court would normally grant in suits filed before them. If the answer is the negative, exclusion of the civil court's jurisdiction would not be ordinarily inferred. In Rajasthan, that case number is given, my lord, by Supreme Court, three-judge bench of this High Court said, there is a presumption that a civil court has jurisdiction. Ouster of civil court jurisdiction is not to be readily inferred. A person taking plea contra must establish the same, even in a case where jurisdiction of a civil court is sought to be barred under the statute. Civil court can exercise jurisdiction in respect of some matters, particularly when statutory authority or tribunal acts without jurisdiction. This is not the approach of the court. The burden on the applicant to show the High Court jurisdiction ousted. Yeah. The same, then paragraph 14, same effect decision, a gallows of Supreme Court judgment quoted, that court to lean against ouster of jurisdiction. Gallows number of judges. Then, my lord, let us see whether the respondent work-up board who claims the exclusion of jurisdiction, civil court has discharged the owners that lay upon it. Section 6 is quoted. Section 6 quoted, section 5 quoted, then paragraph 16. Plain reading of subsection 5 of section 6 would show the civil court jurisdiction to entertain any suit or other proceeding stands specifically excluded in relation to any question referred to in subsection 1. The exclusion, it is evident from the language employed, is not absolute or all pervasive. Second judgment also must say so, not all pervasive. It is limited to the adjudication of a question A, whether particular property specified as work-up property in the list of work-up is or is not a work-up property, and B, whether it's Sunni or Shia property. The board or the mutwali of the work-up, any person interested in the competent court is will final, provided no such suit can maintain by tribunal. Then section 7 is quoted. Joshi has read that. Then what conclusion, paragraph 20. From a conjoined reading of provision section 6 and 7, it is clear that jurisdiction to determine whether or not a property is a work-up property or whether work-up is a Shia or work Sunni rests entirely with the tribunal, and no suit or other proceedings can be instituted or commenced in a civil court in relation to any such question after the commencement of the act. What is noteworthy is that under section 6, read with section 7, the institution of a suit in civil court is barred only in regard to questions that are specifically enumerated therein. The bar is not complete so as to extend to other questions that may arise in relation to work of property. The 6 and 7 has been amended. But kindly see whether the amendment has got any bearing to dispute this exposition of law. What is the nature of amendment? See, in the marked work of spelling is now ukaf. This amendment has been made, and addition, work of board or mutali is there, and any person aggrieved may institute a suit. Any person aggrieved, that is the date of section 7, aggrieved by the inclusion or non-inclusion in a list.
Yes.
That is the only addition made, the only amendment. And spelling wakaf is now awkaf.
Wakaf, yes.
So, this finding of Supreme Court here is not affected by the amendments of the 2013. This is one proposition laid down by this judgment. Paragraph 20 I have written.
Yes.
Now, now I come to the second question before I come to Milord. Before this Waqf of 1995, there's a Waqf Act 1954 having similar provisions regarding exclusion. That is in paragraph 21. And this judgment should be placed before Lordship, should be placed. 979 SCC 648. We may at this stage usefully digress from the code issue only to highlight the fact that section 6 subsection 1 and the proviso thereto have fallen for interpretation of this court in a few occasions. Board of Muslim Waqf versus Radha Kishan, that is 979 2 SCC 468. One of the questions that failed for determination was who are the parties that could be taken to be concerned in a proceeding under subsection 1 or section 6 of the Act. This court held that under section 6.1, the board or the mutwali of the Waqf or any person interested therein is entitled to file a suit. But the word therein, following the expression any person interested, must necessarily refer to word Waqf, which immediately precedes. Therefore, the object, interest in a Waqf, the object underlying the proviso observed this court was to confine the power to file a suit to the mutwali and persons interested in the Waqf. In the Waqf, not in Waqf property. It did not extend to persons who were not persons interested in the Waqf. Consequently, the right that interest of a stranger, a non-Muslim, to the Waqf in a property cannot be put in jeopardy merely because the property is included in a list of Waqfs. The special rule of limitation prescribed by the proviso, section 6, subsection 1, was itself held inapplicable to him, and a suit for declaration of title to any property included in the list of Waqf held maintainable even after expiry period of 1 year. Lord, this judgment, if I may tell also, is judgment of 3 judgments. And all this last judgment of 2 judgments. So this judgment I should show Lordship that this is a 3 judgment should prevail. Cannot be. Then Milord, paragraph 22. Following passage from a decision in Radhakishan case, that is just now, in regard to is opposite. Then see paragraph 32, 38. May I read that? To clarify. The question that arises for consideration, therefore, is as to who are the parties that could be taken to be concerned in a proceeding under subsection 1 of section 6 of the Act, and whether the list published under subsection 2 of section 5 declaring certain property, the Waqf property, would bind a person who is neither a Mutwali nor a person. Pausing here, my lord. This section 6 of Act of 1994, previous Act, and the show the section, they're all parameter. I'll show to you lordship later on. All parameter, section 5, 6 parameter. The answer to this question must turn on the true meaning of the construction of the word therein, in the expression any person interested therein. Now, my lord, any person aggrieved by has come in there. Any person interested therein in appear, etc. In order to understand the meaning of the word therein, in our view, it is necessary to refer to the preceding words, the board of the Mutwali of the Waqf. The word therein must necessarily refer to the Waqf, which, which immediately precedes it. It cannot refer to Waqf property. This is not humbly submitting. Waqf will not refer to Waqf property. Subsection 1 of section 6 enumerates the persons who can file suits, and also question in respect of which suits can be filed in the tribunal. In enumerating the persons who are empowered to file suits under this provision, only the board, the Mutwali of the Waqf, and any person interested therein, thereby necessarily meaning person interested in the Waqf, are listed. It should be borne in mind that Act deals with the Waqf, the institution and its properties. It would therefore be logical and reasonable to infer that the provisions empower only those who are interested in Waqf to institute suits. This is the 3 categories. Now, Lord, instead of removing those persons who are interested in Waqf, agree thereby. It follows that when a stranger who is a non-Muslim, I am not relying on the word Muslim, a stranger to the Waqf, and is in possession of certain property, his right or interest therein cannot be put in jeopardy merely because the property included in the list. Such a person is not requested to file a suit for a declaration of his title within a period of 1 year. The special rule of limitation laid down in the proviso, the subsection 1 of section 6, is not applicable to him. In other words, the list published by the Board of Waqf on subsection 2 of section 5, the same thing here, can be challenged by him by filing a suit for declaration of title even after expiry of the period of 1 year, if the necessity of filing as remain. To the same effect, decision of this court in Punjab Waqf Board, this is 2000 volume 2 SCC. The exclusion of the jurisdiction of civil courts to adjudicate upon disputes whether a particular property specified in the Waqf list is or is not a Waqf property, or whether a Waqf specified in the list is Shia Waqf or a Sunni Waqf, is clear and presents no difficulty whatsoever. Difficulty, however, arises on account of the fact that apart from section 6.5, which bars the jurisdiction of civil court to determine matters referred to in section 6 by 6(1) and section 85 of the Act, also bars the jurisdiction of civil courts to entertain any legal proceedings in respect dispute question matters relating to a work of property. Wide work of property.
Yes.
Section 85 says that no suit or other legal proceedings shall lie in a civil court in respect of any dispute, question, or other matters relating to any work of property or other matter, which is required by or under this Act to determine by a tribunal. It is still there, my lord. This has not been changed. Section 85 has been only changed, my lord, any court or revenue court or etc. That all the other two revenue court are doing that. A plain reading of the above would show that civil court jurisdiction is excluded only in cases where the matter in dispute is required under the Act to be determined by the tribunal. The words which is required by or under the Act to be determined by a tribunal holds the key to the question whether or not all disputes concerning the work of or work of property stand excluded from jurisdiction of civil court. Whenever a question arises, whether any dispute, question, or other matter relating to any work of property or other matter falls within the jurisdiction of a civil court, the answer would depend upon whether any such dispute, question, or other matter is required under the Act to be determined by the tribunal constituted under the Act. If the answer be in the affirmative, the jurisdiction of civil court would be excluded. Such a question. For in that case, tribunal alone can entertain and determine any such question. The bar of jurisdiction contained section 85 is in that sense much wider than that contained in section 6(5) or section 7 of the Work of Act. While the latter bars the jurisdiction of civil court only in relation to a question specified in section 6(1) or 7(1), the bar of jurisdiction contained in section 85 would exclude the jurisdiction of the civil courts not only in relation to the matter that specifically falls in section 6 and 7, but also other matters required to be determined by a tribunal under this Act. There are a host of such matters in which tribunals exercise original or appellate jurisdiction. To illustrate a point, we may usually refer to a case of provisions of the Act where the bar contained in sections would get attracted. Section 33 of the Act deals with power of inspection by chief engineer. But these are illustrations given below. If I kindly then we kindly come to paragraph 28. 20. Section 85 of the Act clearly bars jurisdiction of the civil court to entertain any suit or proceeding in relation to the orders passed by or proceeding that may commence before the tribunal. It follows, although section 85 is wider than what is contained in section 6 and 7 of the Act, the exclusion of jurisdiction of civil courts even under section 85 is not absolute. It is limited only to matters that are required by the Act to be determined by tribunal, so long as the dispute or question raised before the civil court does not fall within the four corners of the powers vested in the tribunal. The jurisdiction of the former to entertain a suit or proceeding in relation to any such question cannot be said to be barred. The High Court of Andhra Pradesh, Rajasthan, Madhya Pradesh, Punjab, Haryana have, in the region to which you have made reference to the earlier part of the judgment, taken the view that jurisdiction of the civil court is barred in respect of disputes that are concerned with any work of property or work of property. The decision rendered by the High Court draws support for the conclusion from section 83 of the Work of Act. The language employed in the 83 of the Act has been understood to be so wide as to include any dispute, question, or other matter relating to work of property. Section 83 of the Act, however, does not, this is important one, does not deal with the exclusion of any jurisdiction of the civil courts. It entertains civil suits generally or suit of any particular class of category. No, it doesn't exclude you. The exclusion of civil court jurisdiction is dealt with by Section 65 and Section 85 of the Act. To interpret Section 83 as a provision that excludes the jurisdiction of civil courts is not therefore legally correct, for that provision deals with the constitution of the tribunal, the procedure which the tribunal would follow recently. This is not important, Lord. Therefore, I shall next time. Lord. Amendment of Section 83 is not relevant.
Correct. Section 6 and
that is
Section
a division.
6 of clause 5 and 85.
Fine. There has the amendment of Section 85. Yes, I lost 85 and not.
Correct.
Section 83 reads, the state government shall by notification in the official gazette constitute as many tribunal as it may think fit for the determination of any dispute, questions or other matters relating to work-off or work-off property under this Act and define the local limits and jurisdiction under this Act. Section 80 is quoted. It does not, it gives the power to constitute a tribunal.
Correct.
It does not extend or exclude civil court jurisdiction. Will not all procedure given. Then come to paragraph 31. End of the. It is clear from subsection 1 of Section 83 above that the state government is empowered to establish as many tribunals as it may deem fit for the determination of any dispute, question, or other matter relating to a work-off or work-off property under the Act and define the local limits of their jurisdiction. Subsection 2 of Section 83 permits any mutwali or other person interested in work-off or any person aggrieved by an order made under this Act or the rules framed thereunder to approach the tribunal for determination of a dispute, question, or other matter relating to the work-off. What is important is that the tribunal can be approached only if the person doing so is a mutwali or a person interested in the work-off or aggrieved by an order made under the Act or the rules. The remaining provisions, Section 83, provide for procedure that the tribunal shall follow and manner in which the decision of tribunal shall be executed. No appeal is, however, maintainable against such order. There is then 32 will import, my lord. There is, in our view, nothing in 83 suggests that it pushes the exclusion of the jurisdiction of civil court extend beyond what has been provided in Section 6, 5, or 7 and 85 of the Act. That's why I'm saying that neither the plaintiff, swastik projects, or city enclave could approach the work of tribunal.
Totally excluded.
Not excluded. And this judgment, I show you, Lordship, is based on 3-judge bench. And I shall compare the language of 1954 Act and of this Act. Show me that parameter. This is not left of this matter too.
Thank you.
And Lordship, seen the court's leaning will be against outstar of civil court jurisdiction.
Yes.
And this is very express and clear. Lordship, a division bench cannot overrule another division bench. First division bench order judgment remains valid. Further, my lord requires authority to show you. And this division bench 2010 clearly said that 83 is not an exclusion clause. So amend 83 in whatever manner you like. How would that affect the decision of civil courts? This is not my submission. That's why I submitted in the first day. Any matter required under that. That's the emphasis.
Thank you.
Sorry, not kept.
Who is for the Waqf board? Yes. Huh?
Huh? The notification may be produced constituting this work of tribunal.
So when you will available? Your senior? Next week? Yes. Counsel for the respective parties are present. Full stop. Counsel for the defendant number 1 has argued the matter. Full stop. Counsel for the work-up board raised for time. Fix. Give the date.
Only a little bit of the submission on our behalf is still left.
Counsel for the respective parties are present. Counsel for the defendant argued at length and requires some time to argue further. Counsel for the work-up board requires further time to reply to the submission made by the counsel for the defendant number 1. Where the submission made by the counsel for the respective parties fixed on 9th October at
9th October.
not September. There is no date. 11 o'clock.
9th October.
9th October.
चार्ट को देते हैं ना ये चुटकी बोर्ड है कभी जजमेंट देखा तो ठीक है देखिए your interpretation उनसे चाहिए ना चाहिए
may I be permitted to mention one undefended suit,
This
which is
time
pending.
mentioning.
Kindly, actually.
What is the urgency?
Actually, this is pending for long, since 2019. This is an undefended suit, a money suit. Actually, this has been a change brief came to us.
It is undefended.
Yes, ma'am.
So what you want?
It's a money suit of 33 lakhs. If you kindly allow to put it in the list.
Put on.
My lord, I have one mentioning, my
to be
lord, but it's
mentioned,
not for. My lord, what has happened, my lord, yesterday, my lord, item number 25 in your lordship's today's list was fixed yesterday at 2 p.m. for witness action. My lord, today my witness is here, my lord, but she has informed that she's not well. She's standing here. So, my lord, when the matter might be called, my lord, I'm mentioning upon notice. So, my lord, when the it was fixed yesterday. So, my lord, when the matter might be called, my lord, she might have to go because she's suffering from some ailment. So, I'll have to.
It will not be taken.
So, I'll have to seek for an adjournment. I'm just, my lord, just because to be on the safe side, my lord, because item 25, my lord.
Okay.
I'm grateful, my lord.
My lord, if I may have my lord's kind leave, my lord, I'm extremely sorry. I mean, apologize for mentioning at this juncture, my lord. My lord, today at item number 3 to be mentioned, my lord, there was a matter in which, my lord, the plaintiffs, my lord, had sought leave from my lord to file additional documents in a commercial suit. My lord, item number 3, which appeared as to be mentioned, my lord, of the commercial division list, my lord.
Yes.
My lord, the plaintiffs, my lord, had sought, my lord, leave to file additional documents. My lord, what had transpired is, my lord, this is a suit of 2020, my lord. What they have merely done, my lord, the examination of their witness is at its fag end, my lord. My lord, at this juncture, they are seeking to disclose documents. My lord, the disclosure is not even by means of a formal application which they have to do under the Commercial Courts Act, my lord, because there are no reasons disclosed as to why after 3 years they are disclosing. My lord, this, my lord, was allowed, my lord. Or I was praying, my lord.
Not allowed. She was there. Court
My
has
lord,
asked specifically.
My lord, I would just, my lord, for my lord, kindly consider, my lord, that there is a specific embargo against such disclosure at this juncture.
That is correct. It
My
is
lord, may I just
against in the commercial suit, but when they have filed, he has also mentioned that you also disclose the document. They have not objected, and she has also given the consent. Yes, they have no objection. That's why in the order also it has been recorded with the consent. It has been allowed.
My lord, I recognize that, my lord, but and there was a, I mean, my colleague here was not able to ascertain the exact nature, my lord. May I only pray, my lord, for one, my lord, if it comes as to be mentioned, my lord, tomorrow we may just place
Today the witness action is fixed. I think so.
My lord, today the witness action is fixed. My lord, that is, my lord, there was a direction in my lord's order that those documents will not be relied upon unless inspection is given, my lord. But my lord, our point here today is, my lord, those documents cannot be taken on record. Merely, my lord, it's not just merely because of the fact that it's a specific mention in the act that such documents cannot be lived in without.
It is correct with regard to the act, all
My
the
lord.
things we know, and I also rejected several applications with
My lord.
regard to the additional document, which is time barred.
My lord.
But today the situation was different. It was given the consent, and it was also argued that you have also relied some certain additional document. They have not objected for that. Then they have adduced further document.
My lord, but
And
there,
your
my lord,
junior, your colleagues has given consent to that.
my lord, I realize.
And now at this stage you're mentioning, but other side is not there. You mentioned
My lord, I was told that a notice had been given, informed the other side, but he is not available. I was only praying, my lord, subject to my lord's pledge, if it can feature us to be mentioned tomorrow, we'll just place, my lord, if it can be recalled, my lord.
I cannot recall once the order is passed.
My lord, because they have not even come before, my lord, by means of a formal application.
That's why you challenge it. You challenge it.
My lord,
Once the
would
order is
kindly
passed in your presence, how the one advocate is giving consent, other advocate is coming and giving making some other submission. It is not proper.
My lord, I apologize for that. There was a mistake on our part only. My lord, would kindly consider as to be
Once
mentioned.
the order is passed, you agree, you go and challenge it. Sorry, it is not desirable to fix the matter to be mentioned then recall. So they will also, because in presence of in the open court, the order has been dictated.
My lord, I realize, my lord, but would kindly consider, my lord.
Sorry. Yes, call the matter.
Well, on the last occasion, I concluded my argument in respect of our application under section 34.
Yes.
And my your lordship desired to, my lord, get a short notes of argument that I have prepared. I am giving a copy to my learned friend. And this is the copy for the honorable court, my lord. In the short notes of argument, if my lord allows me, then I would just summarize the point that I raised during the course of my argument, my lord. This is the short notes of argument and the decisions, my lord, that I relied upon.
Have you saw the copy?
Yes, my lord, I have already given.
Yes.
If my lord kindly sees on the left-hand side, there is the claim numbers and the page referred to in my application.
Yes.
And the right-hand side, my lord, I have mentioned the points of challenge. And if my lord kindly see, there are total 7 claims which were allowed by the learned arbitrator, which under challenge before your lordship. So out of the 7 claims, my lord, 5 of the claims which were, my lord, done infringing the terms of contract, my lord. So that is my primary argument, that the arbitrator, being a creature of contract, cannot go beyond the contract. So those, my lord, claims are, my lord, claim number 2, except 1 and 5, my lord, together the learned arbitrator passed the award 1 and 5. So that is, I am treating that as a single award. And claim number 3, my lord. So except 1 and 5 and 3, all our claims are, my lord, was passed ignoring the terms of contract, my lord.
1 and 3 except
1 and 3. So therefore, the remaining, my lord, claims were awarded without relying upon the relevant terms and conditions of the general conditions of contract that were executed between the parties.
1, 5 and 3.
1 and 5 is a single award because he passed a single award, 1 and 5.
1, 3 and 5.
And 3.
Yes. So this is with regard to what
These
is
are
the submission with regard to 1, 3 and 5?
That, my lord, if the claim number 1 and 5 are taken together, I am just summarizing. My lord, the amount that in the first point was that we had a counter claim of 40,000 with regard to claim number 1. But the arbitrator did not, my lord, give any reflection to this, so whether it will be allowed, rejected, anything.
Okay.
And claim number 5, my lord, that is very important. On that head, a lump sum of rupees 5 lakh was awarded, and the very sum that was claimed by them only.
Okay.
That is not a point of challenge. The point of challenge is, my lord, claim number 5 I have mentioned that the claim number 5 was not disputed by them originally. Only during the course of, my lord, arbitration, this particular claim was agitated. Admitted fact, the arbitrator also taken into note of this fact. But if that particular claim was never agitated by the, my lord, the claimant, so therefore, my lord, there was no scope for him to pass this award because the parties got no opportunity to either, my lord, counter or, my lord, they confront this particular claim. So as far as the claim number 2 is concerned, my lord, that is on wrongful assessment of rates for extra work, claim number 2. So, my lord, I have mentioned the relevant clauses of the general conditions of contract. So these particular clauses, for example, 69, Roman 1 to 6, those clauses are dealing with, my lord, the provisions which would govern the parties as far as the rate for extra work is concerned.
So you are also arguing on
Yes,
the
yes. I'm just summarizing, my lord.
Correct.
So those points have not been, my lord, referred to by the arbitrator in his the award under challenge.
Yes.
Under which clause he is allowing, under which clause they are claiming, whether there was any infringement or not, those are never referred to. So basically, again, this argument is on the basis of that the arbitrator went beyond the terms of contract. Then, my lord, claim number 6, that was also part of our counter claim, that is performance guarantee and security deposit.
Yes.
So, my lord, the arbitrator rejected our counter claim, and on the contrary, performance guarantee and excess amount towards mobilization advance and security deposit were granted to them, because that amount we are recovered from the contractor. So, my lord, the clause number 9, I have first mentioned the performance guarantee. That particular clause deals with performance guarantee, and that is to be refundable only when there is a satisfactory completion of the work. So my argument is this: since there was a premature termination of the contract because of the delay caused by the contractor, as per our, my lord, submission, so therefore there was no compliance of clause number 9. So refund of performance guarantee is wrongful on that account. And thereafter, my lord, 72, 1 to 5 and, my lord, 72.1 small a. Those, my lord, clauses dealing with the consequential, my lord, action to be taken by the employer in the event of rescission of contract. So the clauses specifically deals with the fact that once the contract is rescinded, the security deposit would be forfeited in our favor. So since we have rescinded the contracts on a premature point because of the delay attributable to the contractor, so therefore my security deposit was not refundable. Those clauses I have mentioned. And third one, my lord, if my lord kindly see against claim number 6, point number 5 on the right hand side, the arbitrator granted a sum of rupees 2,76,021. That amount has not been pleaded by them. I do not know where from that learned advocate has got this particular amount. Only in the award I have got this particular figure. That is the excess amount towards mobilization advance. So in their statement of claim, they have not pleaded, nor in any other communication I could find this particular figure. Only in the award for the first time. And thereafter, the next claim, my lord, the claim number 7, that is on account of escalation of material, plant and machineries and labor. So again, my lord, there is a infringement of clause number 16 that will deal with rates of escalation of material. Clause number 16 is a very elaborate clauses. It was dealing with various factors under which the claims under escalation of material labor can be taken care of. Though neither of the claims are falling under this particular clauses, nor the arbitrator has referred to any of the particular clauses under which he may have allowed that particular claim. And secondly, my lord, the claim number 7C, that is the repetition. And my lord, here also, my lord, the learned arbitrator awarded an additional sum of rupees 1,10,000. That is the part of the award. That sum has again, my lord, is not been reflected in the pleading or in the statement of claim. That is the last point, point number 7. Award of an additional sum of rupees 1,10,000 on account of claim for escalation on the amount awarded against claim number 1, 3, and 5, which was something never pleaded by the claimant, not filed any calculation in annexure E2G, which the claimant attached with his statement of claim. Thereafter, my lord, claim number 14.1 to Roman 14.2, that is on account of longer retention of plant and machinery and overhead expenses. So it was again, my lord, a breach of my lord, the terms and condition of general condition of contract, whereby, my lord, first of all, as per the clause number 72.1.c, the respondent was entitled to recover the cost. Once the contract is rescinded by the employer, the employer were authorized or rather stipulated to recover the cost by selling their material. So therefore, we retain few of the my lord, the items of the contractor that they have pleaded. Firstly, and secondly, as per clause number 11.1 and 11.2 of GCC, the contractor alone was liable to bear the cost of mobilization and demobilization of demobilization expenditure towards main machineries. And most importantly, my lord, GCC clause number 39 prohibits any idle charges, because they said for this, since the contract was prolonged for certain time, so therefore they had to bear extra cost. So that particular factor is also, my lord, taken care of by clause number 39, which prohibits any amount to be payable on account of idle charges. And the last claim was, my lord, on loss of profit. Yes. The first point is, my lord, the learned arbitrator himself admitted there was no merit under this head, but nevertheless he allowed this amount. And therefore, another point I have taken, my lord, since the delay was attributable to the contractor, so there was no question of loss of profit. And most importantly, clause number 69, subsection subclause 3, that no amount of compensation would be payable to the contractor out of loss of profit arising out of withdrawal of any work. So we have withdrawn the work and got this work executed by at his risk and caused by another contractor, admitted fact. So therefore, this amount was not payable, my lord. And before this, my lord, the claims that we have dealt with in those columns, my lord, may I, my lord, repeat another factor, that before the learned arbitrator coming to deal with the various claims of both the parties, he framed two issues. And in two issues, my lord, the finding was mixed. Something in my favor, something in his favor. So first issue was that the delay. Who was, my lord, responsible for the delay? So it was the finding of the arbitrator that the delay up to 25th of March 1993 was the factor attributable to me or the employee. That is there, in the award. So so he has basically, divided the whole period of delay into two parts. First part was from the date of execution of the contract to 25th of March 1995. That was attributable to me, and from that date to, my lord, the date of my lord, termination that was attributable to them. So, my lord, while dealing with my counterclaim, I will refer to a series of documents to establish that the delay was from the very beginning, the delay was attributable to him. So, therefore, that particular finding was wrong in my submission. Second was that, my lord, whether the termination of contracts was lawful or unlawful. So the learned arbitrator held that the terminations were unlawful. The reason being, the first of all, my lord, there were not enough notice was given to the party, and even if the notice in the form of so cause was given to the party, that was given a go by giving another extension on the same date. That is the first reason. And secondly, my lord, because of different extension and because of giving by that the last extension by the employer, the time was given a go by, and it was, my lord, the open field for both the parties. So on that account, my lord, I have already submitted in course of my argument that clause 72 deals with the issue.
So why if you are also challenge all the on the grounds and they have also challenged, why the award should be continue?
Because I am, my lord, because if the
party challenge
claim
that
and
will be
counter
set
claim,
aside.
yes, if the both claims and counter claims is to be taken into account, I am on the negative balance. So that is why my stakes is little higher. So they will enjoy if the award remains. But I will, my lord, benefit if again, and I do not have any objection. I have taken instruction. If the de novo arbitration happens,
this court only can.
Yes, modification is no more permissible. Whether this award will remain or this award will go. Yes,
If it will
absolutely.
go, even after, if it will go also, this court cannot appoint anybody, then you have
Yes,
to take
another,
up
yes,
as per-
11.6 and
as
new,
per your
yes,
provisions.
yes, provision, and now this provision is no more, my lord, maintainable because of
Whatever it
parking
may be.
decision. 11.6 will have to be applied for.
If you are telling, then if you are telling that it may be go, let if they are also challenged, let it go.
My lord, we have not challenged the entirety of the award. Only a very
No, on the
small
last
Not
portion.
permissible. That is
Mr.
not,
Mitra has made this
perhaps that is not permissible. Part of the award, perhaps he cannot
No,
challenge.
that's
If
because on
it's
the
separable, if it is separable.
no, it is separate. No, last occasion, Mr. Mitra was also
Yes, my lord.
okay. Let us see.
I am challenging the award, and I will try to establish the counter claim. That was also bad because few two important claims, counter claims are not allowed. So what I am trying to submit was that, my lord. So as far as that unlawful termination part, finding of unlawful termination part is concerned, my lord, my respectful submission is this: no previous notice is required as per clause number 72. I have already, my lord, submitted before your lordship that once there is a breach of contract, if there is within the estimation of the engineer in charge, if there was a delay, then the contract can be terminated. So therefore, previous notice was not required. So even if there is no so-called notice, no previous notice is given, then also it could have been done.
That is
And another was the thing that if certain option was given to me and it was not exercised for some time, that does not debar me to exercise that particular option later on. So provided they raise this objection, it was extended for 2 or 3 occasions. So why I did not terminate this contract on an earlier occasion. So that is also covered by that clause. Even if I did not exercise particular option, but later on I can exercise that option. So I have exercised.
Okay.
So this is the sum and substance of my argument, and at the bottom of my columns I have mentioned the decisions. So I have referred those decisions are 3 broad heads. First heading was on the issue that the arbitrator cannot travel beyond the terms of contract. So those 7 decisions, my lord, 8 decisions I have referred to with the copies attached, where it has been specified. It is a settled position of law, but nevertheless for my satisfaction, my lord. And second was, my lord, on the issue of extension of contract not operating as waiver, because they have taken the plea that since I have extended.
That is the only point.
Yes, whether it will act as a waiver or not. So that particular decision says only because we have extended, that doesn't mean that we have waived our right for the purpose of termination of contract.
Waived, but on the same day you have extended and same day terminated.
Terminated. Yes, we have done this, but again, my lord, the so cause and this extension will not conflict with each other because of the clause number 72.
Right upon the.
Yes, that is the right accrued to us as per the general terms of condition is contract. And third issue, my lord, on the issue of debarment of contractor to claim damages if the same is not reserved by the contractor at the time of seeking extension. So when they sought extension of time for the purpose of completing the execution of this contract, they did not reserve its right for the purpose of seeking future damages. And that decision, my lord, I also relied upon on in course of my argument on earlier occasions. So therefore, my lord, those letter I have already mentioned before, that is lying with your lordship. So they have, in all those letters of extension, my lord, they have nowhere reserved their right for future compensation. So therefore, on that account also, they are debarred from claiming this particular damages.
Okay.
And my lord, while preparing our counter claim, my lord, it was found out, my lord, that the statement of counter claim is not part of the record, neither in our application or neither nor in their application. Counter claims. So I have discussed with my learned friend as well. So he also admitted perhaps that is not part of their application as well. So if my lord allows with the concept of my learned friend, we have not made a part of it. Perhaps they have also not made a part of it. Counter claims.
So what you want?
So I have
You
brought
want
a
to
copy
give
of
copy?
it. Yes, my lord.
That's all.
Yes, no, my lord. In support thereof, I have prepared a short
counterclaim.
Counterclaims, not my lord, notes. I have not prepared the notes yet. Those series of documents I have referred to, my lord. That is only. Notes, that is the index of counterclaim by respondent. So I have given a list of my lord, series of letters which are made a part of my my lord, this, compilation of documents. So I have referred the dates as well as volume number and pages number. Those are part of the records, my lord. So I will not go individually through all these letters, but what I am trying to submit is this, my lord. If a single letter of all the series of documents can be referred to, it will palpably make it clear that the delay was from the very beginning was because of them only. For example, there were a series of joint meetings, there were a series of communications, there were a series of admission on their part, seeking financial assistance, seeking extension of time, my lord, explaining the reasons behind the delay. So total, my lord, the 76 letters I have made an index of this document along with page numbers and volume numbers. So all those letters will palpably, my lord, make it clear that the delay was solely attributable to them. So therefore, this is important to establish my counterclaim number 1. And not only that, also to establish, my lord, the findings of the arbitrator that the delay was to certain part delay was attributable to me. So those are the, my lord, series of letters, my lord. And if my lord, I straightway come to my counterclaim, I will rely upon only two, rather I would challenge only two counterclaims, which went against me. If my lord kindly takes up the award. Because remaining counterclaims are mostly allowed or partly allowed. So I will not, for the sake of my lord argument, I will rely rather deal with all those counterclaims. I will deal with only 3 counterclaims.
Yes. Page number?
My lord, that is in my 34 application, the award, the relevant page of the award is 78, 489, AP 489. Page award is mona 32.
Yes.
Counterclaim number 1 on account of recovery of
page number?
Running page number 78. In our section 34 application. Counterclaim number 1. On account of recovery of excess expenditure incurred in getting the balance work of the claimant's contract completed by another agency, namely Mr. P.D. Agarwal, at the cost of rupees 79,99,389. Is the admitted fact, my lord. They have also countered, yes, this particular remaining work was executed by this particular contractor. So, my lord, in the body of the award, the learned arbitrator dealt with this the respective pleadings of the parties, and thereafter the finding, my lord, at page number 80. It has already been held by me in the very beginning of this award that termination of contract and getting the balance work done at the risk and cost of the claimant was unlawful. That being the case, the counterclaim for the extra cost incurred by the respondent for getting the balance work done through another agency at the risk and cost of the claimant does not survive. As such, I reject this same. So, my lord, the basis of this finding was delay, because he held that the termination of the contract was unlawful.
Yes.
Not only delay, as well as, my lord, the notice and all.
Correct.
That was the issue number 2. That is at the beginning of the award, my lord. He dealt with issue number 1 and 2. Issue number 2 was dealing with the termination of contract. So that is why the learned arbitrator has mentioned that it has already been held by me in the very beginning of this award, the termination of the contract and getting the balance work done at the risk and cost of the claimant was unlawful. That being the case, the counterclaim for extra cost incurred by the respondent for getting the balance work done through another agency at the risk and cost of the claimant does not survive. As such, I reject this claim. With regard thereto, my lord, I may rely upon again the general clauses of contract and clause number 72 1C.
Clause number
72 1C. 72 was compensation of delay, because 72 is most important part of this, my lord, our argument.
Where is that?
My lord, on the last occasion, I submitted one typed copy.
Give
of-
that.
Only one copy is remaining with me. Seventy-two point one, my lord, deals with the under which circumstances it can be terminated and consequential actions. Therefore, my lord, at internal page number 4 at the bottom.
Yes.
After giving notice to the contractor to measure up the work of the contractor and to thereof take such part as shall be unexecuted out of his hands, and to give it to another contractor to complete, in which case the expenses which may be incurred in excess of the sum which would have been paid to the original contractor if the whole work had been executed by him, of the amount of which excess the certificate in writing of the engineering charge shall be final and conclusive, shall be borne and paid by the original contractor and may be deducted from any money to him by the NBCC, this contract, or in any other account whatsoever, and from a security deposit and proceeds of sales thereof, or a sufficient part thereof, as the case may be. So therefore, my lord, as per this clause, I had the right to, my lord, engage another agency and to recover
So
the cost.
you invoke this clause.
Yes, we have enclosed this clause, and therefore this amount was, my lord, was payable to us by the contractor. And my lord, if my lord kindly comes to the previous page of the award, 79.
Yes.
Page number 17, 80 was the finding or the ordering part. Page number 79, my lord, the later part. Moreover, my lord has found moreover.
Yes.
Moreover, it was argued that basic structure of Mr. P.D. Agarwal's contract should have been exactly in mirror image of the original contractor. This was, however, not the case. Following points were highlighted. No paper publication was NIT was done as required by the due process of law. Original contract was based on star rate of cement, reinforcement steel and structural steel, whereas Mr. P.D. Agarwal's contract was based on market rate of these basic items. Time given to Mr. P.D. Agarwal 6 months, whereas they took 36 months approx to complete the balance work. No LD was imposed, which should have been done to mitigate the damages of the claimant. I am not aware of whether the arbitrator relied upon these points or not, but nevertheless, these points are not applicable to our case. These issues are not germane, my lord, for the purpose of adjudication of this counterclaim. 1 to 3. Even though it looks like it is a contention of the claimant.
Yes. He has taken into consideration of the contention of the claimant contractor.
It has been, but in the when the heading award is there in the finding, he has not mentioned nevertheless. I have just highlighted this point. In the event it comes to the mind of your lordship that these are the relevant consideration. These points are, my lord, is not the point of consideration to adjudicate this issue. It has no relevance with this particular counterclaim.
Okay. Next.
Therefore, my lord, counterclaim number 8, that is at internal page number 80, running page number 85.
85.
85. Counterclaim number 8, compensation for delay, rupees 65 lakhs. Respondent pleaded, argued that claimant could not complete the work by stipulated date of completion or even by the provisionally extended date. As such, they had to rescind the contract on 20th of March 1996. As per clause 72 of the condition of contract, claimant is liable to pay compensation for delay at the rate of 10% of the estimated cost of the work. Though the loss sustained by the respondent is enormous, they have levied the maximum compensation at the rate of 10% of the estimated cost put to the lender as per clause 72 of the condition of contract, which is rupees 65 lakh. Hence, this counter claimant. Claimant contended that the respondent could have raised this claim only if liquidated damage has been imposed upon the claimant in terms of clause number 72 of contract. Since no LD was levied, this counter claim is not admissible. Finding. I agree with the contention of the claimant. Since no action was taken under clause 72 of the contract for levy of liquidated damages, the present counterclaim does not survive. As such, I reject the same. So, my lord, if kindly comes first to the clause number 72. It is there, my lord. 10% it is there. It is not disputed. So, therefore, my lord, what I can find from this particular clause is that in the event of compensation, which is leviable from the contractor, the maximum amount I could levy from is 10%. Otherwise, several estimates is there, calculation is there, but that is subject to the limit of 65. So total contract value was more than 6 and odd crores. So therefore, 65 lakh was imposed. But the finding of the arbitrator was that we did not impose liquidated damage. That I could not understand what action we could have taken, because we terminated the contract. We gave the warning letter, we cautioned, and whatever the communication, series of communication made between the parties, 2 or 3 extensions, ultimately the contract was ultimately terminated. It was not that some amount was to be recovered by them. Excess amount was lying with them, therefore we should have deducted and pay the remaining. It's not like that. I have to make that claim.
Where is the liquidator clause?
72, my lord.
LD clause?
72. That is the fair copy, my lord, the first page itself. The time allowed for carrying out the work as entered in the tender shall be strictly observed by the contractor and shall be deemed to be of essence of the contract on the part of the contractor, and shall be reckoned from the 10th day after the date on which the order to commence the work is issued to the contractor. The work shall throughout be the stipulated period of contract proceeded with all due diligence, and the contractor shall pay as compensation equal to 1% or such smaller amount as the chief project manager, whose decision in writing shall be final, may decide on the amount of the estimated cost of whole work as shown in the tender for every day that the work remains uncommenced or unfinished after the proper dates. And further, to ensure proper progress during the execution of the work, the contractor shall be bound in all cases in which the time allowed for any work exceeds 1 month, say for special job, to complete 1/8 of the whole of the work before 1/4 of the whole time allowed under the contract elapsed, 3/8 of the work before 1/2 of such time has elapsed, and 3/4 of the work before 3/4 of such time has elapsed. However, for special jobs, if a time schedule has been submitted by the contractor and the same has been accepted by the engineering charge, the contractor shall comply with the said time schedule. In the event of the contract failing to comply with the condition, he shall be liable to pay as compensation an amount equal to 1% or such smaller amount as the CPM, Chief Project Manager, whose decision in writing shall be final, may decide on the said estimated cost of the whole work for every day that the due quantity of work remains incomplete, provided always the entire amount of compensation to be paid under the provisions of clause shall not exceed 10% of the estimated cost of the work as shown in the tender. So therefore, the upper limit was, my lord,
10%.
confined to 10%. So we on founding on this particular clause, we, my lord, made a counterclaim of 65 rupees that the learned adjudicator rejected on the ground that since no action was taken under clause 72 of the contract for levy of liquidated damages, The present counterclaim does not survive. I do not know what steps we could have taken, my lord.
No,
But as
before termination or in the termination,
we have mentioned, my
what
lord.
about the notice? Have you mentioned about
Yes,
the
yes, that is I'm coming. That is I'm coming, my lord. There are several, my lord, that is made, that is a part of this, my lord, application. First is a so-cause notice, that is 157 to 162. It has been mentioned, my lord. Another, my lord, termination letter, that is also part of my application, that is mentioned. Another, my lord, extension of letter, further letter was there, my lord, that is 169, 170. There also, my lord, that is that letter dated 26th of December 1994. It has been mentioned. Another, my lord, extension of time dated 9/11/1995. That is part of this application, that is mentioned, my lord. Thereafter, my lord, 2-3 other letters that is not part of this application, but it's part of the record, my lord. So, my lord, at the end, my lord, I'll giving a short note. There also I mentioned the dates, my lord. In other words, my lord, I could find out at least more than 7 or 8 letters are there where we have specifically mentioned this clause for the purpose of levying liquidated damages. So therefore, this finding, even if it is taken into account that yes, no action was taken,
that document was not placed before the arbitrator during evidence.
Certainly, my lord, those are all. It is not the finding of the arbitrator not placed, my lord. Because the finding is only half a page, my lord. It is not apparent.
No, because arbitrator, the oral.
Yes, absolutely, my lord.
Oral evidence was led.
But perhaps neither party can establish it was given or not given, because no reflection is there. The old, my lord, 96, 97, we are not there, my lord.
No, because the respondent's document, it is what the
Yes, it is there, my lord. Those documents are admitted documents, and those letters are made part of both respective, my lord, pleadings or 34 application or in our compilation, because several compilations were filed by both the parties. My lord, application with attached document.
Though evidence was not led.
None of us attach any evidence.
That's why. So documentary evidence.
Only
so
documentary
evidence. So the documents has been relied by the parties.
That has been mentioned in our pleading,
which the document you relied upon now, that is the part of before the arbitrator at the time of taking this passing the order on this award.
Well, certainly, because series of documents, a few of the documents, my lord, the arbitrator has referred to. And if our statement of claim is, my lord, relied upon, there also we have mentioned, my lord, the copy I have just submitted, my lord. There also we have mentioned those letters, my lord.
Okay.
And in my notes of that index, my lord, that I have submitted, there also a series of documents I have mentioned.
Yes.
Rather, my lord, the claimant, respondent mentioned in course of arbitration, my lord. So it was part of the record. Certainly, my lord.
Yes, next.
Because my lord, since this question has come, my lord, from this, my lord, note, I can find out, my lord, most of the letters were either, my lord, so-cause letter or termination letter or extension of time letter, my lord. So, my lord, nobody has disputed that those were not.
That is not disputed with regard to
whether it was submitted before the register. From the award, my lord, readily I cannot refer to.
Because it has not been referred in the award.
In the award, it has no reflection. But in our,
if there is no evidence, if it is evidence, it can be exhibited as an exhibit document.
None of the parties exhibited.
It is not been marked as
we have
exhibit.
given
So,
compilation of the mother letter.
compilation of the document, it may only be reflected in the minutes of the meeting.
Minutes of the meeting, or in award also, few of the documents has been reflected. Not all in all respect of all claims or counter claims, but few of the claims, my lord, those letters were reflected by the arbitrator. But in our statement of counter claim submitted before the erstwhile arbitrator, because perhaps this is the third arbitrator who was appointed.
Yes.
The first was some other gentleman, my lord. So before whom this counter claim was submitted. So there we are referred to all these letters. That is the voluminous, my lord, the statement of counter claim, my lord. From them, those, my lord, letters I have given that index.
That counterclaim contains these letters.
Yes, my lord. Counterclaim contains these letters, my lord. That is the, my lord, the counterclaim I have just submitted to them, my lord, which are not part of this record from either side, my lord. Yes, my lord, that part, my lord. And from that counterclaim, my lord, I have extracted the relevant or most important letters, and I have made a separate index.
Okay.
To show the, my lord, delay as well as those extension and termination. So this was my, with respect to my counter claim number 8, this was my submission that we have several letters, termination and all. We have reserved our right for liquidation to claim liquidated damages, and therefore this finding was palpably wrong. Therefore, my lord, other claims are partly allowed or my lord, mostly allowed. So I am not dealing with those because I am not gravely
affected.
Yes, my lord, affected by those hours. So I am not for the purpose of only making argument. I will rely upon
So
those.
total how much amount?
At the end, my lord, I will rely
Total,
upon one
total
particular-
award was in your favor.
in my favor, my lord. If my lord kindly comes to page number 95, that is their claim summary of the award in respect of claim. That is 1 crore 6 lakhs.
That is 1 crore 6 lakhs. That is the claimant
Claim,
contractor.
yes, and on the next page, our counter claim 95 lakhs. 95 lakh and odd 95 lakh 63,152.
So it was restricted to 65.
Yes, in respect of this, my lord, if my lord kindly comes to page number 94 at the bottom, that is a very peculiar finding that has been made by the arbitrator. Special note, my lord, at the bottom. The counter claim number 1, 7, 8, 10, 11, 12, 13, 15, and 17 are in the nature of damages, and the total amount awarded against these counter claims comes to around 123 lakhs. That is 1 crore 23 lakhs. All figures in lakhs has to be restricted to 65 lakhs, which is as per contract clause number 72 is an agreed pre-estimation of the maximum compensation liquidated damages that can result from delay. As such, I am limiting this amount awarded against these counter claims to 65 lakhs. So as far as liquidated damages is concerned, my lord, counter claim number 8, he rejected because I did not take any action as per the finding. I did not take any action, therefore liquidated damage is not payable. But while granting this counter claim, suddenly he has limit my awarded sum to 65 lakh. So that is absolutely contradictory to the stand of the arbitrator, because counter claim number 8 he had rejected. And again, my lord, limiting this amount, he relied upon this clause number 72 for the purpose of liquidated damages.
Yes.
Therefore, thereafter the summary of this thing has been given, and the for balance 10 lakhs of my lord, the amount that is as per this award is payable to the claimant. We both the parties are, my lord, litigating with each other. So that is the sum and substance, my lord, my argument.
Okay.
At the once, my lord, the argument of my learned friend will be completed, my lord, then I'll deal with the points and make a short notes of argument. So for my short notes of argument, I have submitted.
Okay, thank you.
I am deeply grateful, my lord.
My lord, I'm led by Mr. Mithro in this matter, my lord, and we have just received the notes today itself. It was directed, my lord, on the last
I
occasion that-
apologize, my lord, I could not. I apologize.
No, my lord, if your lordship can be pleased to fix a
Fix
date,
on today.
because tomorrow and day after tomorrow were fixed for my learned friend's
No, tomorrow is also fixed.
conclusion. Yeah.
3
Tomorrow and day after
consecutive
tomorrow.
dates are given. Today I have summed up my argument.
Tomorrow also fixed. Tomorrow will not be ready.
No, my lord, because we have just received the notes from them today. We'll need time to prepare, and we do not want to interrupt our flow. So we'll be concluding, once we start, we'll be concluding with our reply.
Then it will go to after the puja vacation.
December.
Counsel for the respective parties are present. Full stop. Counsel for the respondent in AP number 443 of 2014 and petitioner AP number 489 of 2014 has concluded his argument. Full stop. Counsel for the petitioner in AP number 443 of 2014 and respondent in AP number 489 of 2014 raised for time. Full stop. In view of the submission made by the counsel for the respondent in AP number 489 of 2014, hearing of the case adjourned. Let the matter appear on to give 2 dates. 5th and comrade, 2 dates I am giving so that it can be concluded.
My lord is pleased to fix any time particular.
12, 12.
12 noon, my lord.
5th and 6th December at 12 noon.
Well, I'm extremely grateful, my lord, for patient hearing, my lord. I've been doing for some time this argument.
Old matters and
Yes, my lord. I certainly took some time, maybe a little longer, but my lord.
Thank you.
Extremely grateful.
Invocation, my lord, in this matter, because your lordship was pleased to ask that the award should go. The only problem is that since 96, this matter has been is yet to see.
Now the problem is that now this it is a settled law. This court cannot modify.
No, we are not even asking for that, my lord.
Cannot modify.
We are
But both the party challenged. That is the problem. Let us see. Let Mr. Mitra argue this. Hey, commercial खत्म हो गए ना?
My lord, I had already shown.
इतना क्यों रख दिया? कमर्शियल मैटर? इतना कमर्शियल मैटर क्यों? Yes.
This is the matter where the defendant had abandoned in course of the cross-examination and has left, my lord. I had already, my lord, placed some documents, my lord, the charts for the first 4 claims, my lord. I don't want to repeat, my lord. I will take hardly much time here right now, my lord. I'll just conclude.
Yes, you have given the total chart.
Yes, my lord. The charts on 4 heads I have given, my lord. Rent, my lord, maintenance, service charge, and electricity. Those charts are conclusive, my lord. There is nothing much else to show. My lord will only take my plaint once, my lord. At para 17. My lord, para 17, these were my heads of claim. 1, 2, 3, 4. I have, my lord, given, my lord, all the charts, including all documents and everything. My lord, so far as serial number 5, repair charges are concerned, my lord. My lord, there is some deposition which is there, my lord, but there is no documents which I have disclosed. Apart from, my lord, a police complaint. My lord, your lordship will only see, my lord, the police complaint, rather the police report. My lord, your lordship, they had, like just the same manner in which, my lord, they have abandoned midway through cross-examination. My lord, the premises also they had left midway during the tenancy in the month of August. August end it was supposed to expire, my lord. They left midway August, leaving the place abandoned. So we filed a police complaint so that the police can come and see what is the condition of the premises. So, my lord, the police went and gave a report. That report, my lord, is at page 100. That's Exhibit DD. Page 100 of the plaintiff's brief of documents, which is Exhibit DD.
Exhibit DD. Should the Exhibit DD.
DD. My lord, Exhibit DD at page 100, my lord. That's Exhibit DD. My lord, it's PD 32 of the plaintiff's brief of judge's brief of documents at page 100.
DD.
DD. Whichever one, my lord, your lordship has, my lord.
DD, yes.
DD. My lord, this is a police report. Your lordship will find, my lord, from the signature at the bottom. This is dated 20th August 2013. My lord, if your lordship reads, this is to let you inform.
Just a minute. Exhibit DD.
DD. It is Exhibit DD. Well, in the judge's brief of documents, it's at page 100.
See DD. 100. Yes.
My lord, my lord, if your lordship will see, this is a report which has been issued by the officer in charge, Shakespeare Shoroni Police Station, dated 20th August 2013. My lord, this is to let you inform that on the basis of your petition dated 10th August 2013, an inquiry has been initiated. On arrival at 10C Hungerford Street, Kolkata 17, the flats situated at the second and third floor, well, these are the two tenanted premises, were found open and without any locks. It could be found that all belongings of the flats, that is electrical wiring, doors, furnitures, air conditions, interior fittings were removed. On enquiry, it was revealed that WLC, that's the defendant, has left these flats on 3rd August 2013 with all belongings. Both the flats are not in usable condition and debris are scattered all over the floors. The contents of the petition do not attract any provision of IPC. The petition is directed to have recourse to proper forum. So whether the police records that on inspection, they find the flats are not in usable condition and debris are scattered all over the floors. And for electrical wiring, doors, furnitures, air conditions, interior fittings, etc. were all removed.
Yes. But you have claimed 9,78,000.
9,78,000. My lord, I have claimed.
What is the genesis of that? Okay, it is damage, but how that claim can be
My lord,
justified?
we have fixed the place. We have not given any evidence to show that property had been fixed. We possibly ought to have, my lord, given all evidence with regard to bills. Those we have not disclosed. But my lord, the fact that the property was left in a terrible condition, that evidence I have given. And my lord, it is, my lord, I'll also show from the agreement for lease, my lord, when a tenant is supposed to leave the premises, they are supposed to leave it in the same condition in which they had entered.
Where is the condition at the time of
my lord?
At the time of leaving the premises, what will be the condition? That there might be some condition in the agreement.
My lord, I'm just checking, my lord, as I'll just recheck, my lord, in the agreement, my lord. My lord, clause 11. Clause 11, if your lordship sees, if there is any breach or non-observance or non-performance of any part of the lease by any of the covenants, of any of the terms and covenants contained herein, it shall be lawful for the lessor or any person or persons duly authorized by the lessor in that behalf to enter into and upon the office block and every part thereof, and the rights of the lessee herein contained shall absolutely cease and determine, but without prejudice to the rights of the lessor in respect of the antecedent breach of any covenant herein contained on part of the lessee, to recover damages, costs, charges, and expenses in respect thereof from the lessee, and whenever this power of entry shall arise, whether the same is exercised or not, the rent or monies as herein above for the month, then the current shall immediately become payable. My lord,
What is rent?
there is the right to claim damages, my lord.
That is there.
That is there. My lord, it is there in law in general also. I ought to have proved what damages I have suffered. ছবিতে হবে না যে আমরা ঠিক করেছি সেটার কস্ট দেয়া ছিল। My lord, your lordship will give us damages which your lordship deems fit and proper, my lord. in this case, my lord, we have, my lord, just, my lord, your lordship has already seen the letter of the office of the report of the police. My lord, to substantiate what condition it was left, you've also annexed some photographs, which are annexure FF or exhibit FF. My lord, this is part of,
because the plaintiff was examined.
my lord, plaintiff had been examined.
But you have not made any averment, but after taking, he has made so much of the expenditure for making.
My lord, I will let me just show what is there, my lord. I can't improve on the case what is there, but if your lordship
There is
sees
an evidence
exhibit FF.
There is any evidence on behalf of the plaintiff after taking that he has made the
My lord,
room habitable by making.
my lord, when this document had been, my lord, I'll show your lordship, when the exhibit was made to show at what condition the property was left,
That is
and there is no cross-examination on that also. My lord, we'll just check once exhibit FF for that. My lord, we'll just check exhibit FF. Exhibit FF. My lord, that's part of a separate, yes, my lord. My lord, these are the photographs showing the condition at which the premises had been left.
Question number 220.
Achha.
223 to 26.
No, they have taken this door frames and all these things.
Yes, ma, they removed everything and gone away at that point of time, my lord. That's why, my lord, the police report substantiate. Police report shows, my lord, what condition it was, my lord. Electrical wiring, doors, furnitures, ACs, interior fittings, etc. were all removed. Both the flats are not in usable condition and debris are scattered all over the floors. My lord, this document, my lord. What else? One question. My lord, we had disclosed, when we disclosed this document, my lord, your lordship will see the examination in which was there and the cross-examination in regard to that, my lord.
Take this.
My lord, in the examination in chief, my lord.
Yes.
My lord will kindly take from question 216 onwards. When did the defendant abandon and leave the premises? Around 3rd August 2013. How did you discover that? After warning that we are going to inquire about our premises and found it under not lock and key, we informed the police to inquire about it, and OC of Shakespeare Shorani Police Station inquired about it and given us report. What was the condition of the premises when the defendant abandoned the same? It was in ruined condition and the electricity and walls were destroyed. A photograph of the premises is also there. There. What do you have to show that? There are actual photographs. Shown 4 photographs. Please tell the court what are these. These are actual photographs of our premises 10 Hungerford Street, Kolkata 17. Who has taken these photographs? By so-and-so. Were you present when these photographs were taken? Yes. How were these photographs taken? By using what apparatus? I do not know the details. We had asked her to take photographs and she had taken. Did she use camera? Yes. Did you check these photographs in the camera? Yes. After photographs were taken, they were shown to me. Are the contents of the photograph true and correct as what has been shown from the suit premises? Yes, it is correct. Photographs are tendered and marked as Exhibit FF. It was marked without any objection. Cross-examination. And my lord, there is no cross-examination on this aspect. We had also possibly not disclosed documents to show we had incurred expenses. But my lord, your lordship will, I cannot claim the money as I have claimed exactly on that, but your lordship, whatever your lordship will deem fit and proper, would be the expenses for repairing, my lord, your lordship will award on those lines, my lord. The fact that damage had been caused, that is proved. What is the exact amount which we have incurred, that I have not been able to prove.
Yes. Anything?
And my last claim is on these sums, interest. Of? Yes. My lord, your lordship knows under the Interest Act, my lord, a notice has to be issued. Once the Interest Act notice is issued, only and then, my lord, interest is liable to be paid, my lord. Your lordship will see, my lord, we have disclosed, we have given them letter that interest will be payable if they fail to make payment. And that, my lord, my notice under the Interest Act is, my lord, a notice dated 21st August 2012.
Notice.
My lord, if your lordship, this is Exhibit M. It's page 119 of the plaintiff's brief of documents.
Exhibit
M. My lord,
yes.
and my lord, this is the notice. This is also at PD 37, page 119 of the plaintiff's brief of documents.
119.
119.
Yes.
My lord will see, my lord, this, we are writing it to the defendant. My lord, if your lordship turns over to page 120, your lordship will find, my lord, under A, Roman 4 is my claim for interest, which I had made, my lord. B also Roman 4. And my lord, C also Roman 5. And at page 122, my lord, I've given the calculation for interest also for the month.
So this notice was issued after vacating? No.
Well, this notice was issued before, my lord.
Before vacating.
Because they had failed to make payment at that point of time.
Have they given the reply?
Well, no, my lord, they had not responded to this. They had not responded. My lord, they stopped right after this, my lord, they stopped paying rent. And my lord, they also stopped paying electricity bill, because of which electricity was disconnected. And finally, my lord, in August 2013, my lord, they vacated the premises.
August
2013. 3rd August 2013, they abandoned and vacated the premises. My lease agreement, my lord, by efflux of time was to end on 31st of August 2013. So my claim is, my lord, for that period when they have not paid up till 31st August 2013 for rent. My lord, only a few questions on the issue, my lord, of interest. I'll just show, my lord. My lord, the document which I disclosed, on that document, my lord, has gone in without any objection, my lord. Questions 84 to question 91 of the evidence, my lord. And the document has been marked as Exhibit M, and it was went in without any objection.
That is a notice.
Yes, my lord, the notice.
Yes.
So, my lord, to sum up, my lord, so far as my repair charges are concerned, my lord, fact that there was damage, that I have proved. The report of the police, as also the photographs, my lord, have been exhibited without any objection and no cross-examination on that. I have not proved the quantum which I have incurred on account of the loss I have suffered. But I am entitled to something which your lordship will deem fit and proper. So far as interest is concerned, my lord, I have also given a notice saying that interest is payable. And in any event, my lord, I am entitled to interest. I have also issued the notice here, my lord, for claiming interest. So these are my claims, my lord. Serial number 1, 2, 3, and 4, I've given the chart. Serial number 5, my lord, your lordship will deem fit and proper what rate I should be entitled to.
And the interest.
And my lord, interest, my lord, is also there. In my plaint also, my lord, I have my rate of interest. I've claimed it at 24%. In the notices, I had claimed 18%. Your lordship will deem fit and proper whatever is the interest payable.
That's all?
Yes, my lord.
Counsel for the plaintiff is present. Hearing concluded. Fixed for judgment.
Although the defendant is in there, my lord, finally a suit of 2013, 14 comes to an end.
December 13.
December 30th. The number is 2014.
Right,
Ninth year.
December. It's one of the CS 12 of 2014.
Finally.
Oh, my lord, if your lordship, my lord, we have, whenever there's been hearings, my lord, we have issued a notice informing the defendant that matter is being heard. Every day, my lord, we have informed, including, my lord,
Should a copy.
I shall mail it.
we'll may supply a copy. My lord, since the defendant is not there, so my lord, we've been giving them notice every day.
Yes.
I'm extremely obliged.
My lord, this is that matter, my lord, with regard to the executor. My lord, your lordship on the last occasion had directed both the executor and the applicant to file, my lord, their accounts. So, my lord, the accounts is ready. May I file it?
Lordship, my accounts also.
May I give a copy?
Yes, he's filing right now. Over here, it's filed in like this.
But I've just now served copies on the applicant and also the advocate for Rajeshwar Parkani.
Yes.
Yes. All parties are filed.
My lord, in this matter, my lord, one of the beneficiaries of the will, my lord, has not been made a party in this proceeding. My lord, I have instruction to file appropriate application in this matter so that my client will address the party in this proceeding.
Who are you?
My lord, in the will, my lord, I am the sister-in-law of the executor, my lord.
Sister-in-law of the executor.
My lord, he has the 30% share of the property, my lord.
Sister-in-law
Of the will, Susila Bole. Page 4 of the
So when you came to know about the proceedings?
my lord, my client has got the knowledge. Somewhere he has been instructed, informed that this proceeding is pending here.
She had a long knowledge. She had a long knowledge about the matter. She's not. It's not that she got recently.
Okay, whatever you want to take steps, you take steps. Why the court will give any?
Can you give me liberty to so that
Why liberty? You are held already having a liberty. You file any application, either blaming this court, either blaming the other party, or blaming yourself. Anything you can do that. And this court will decide whether that application can be allowed or dismissed. Okay, the leave is not necessary. You take appropriate steps. When you take steps, it will be taken up for hearing. Now the matter is on board. Let the hear the party.
Lord, I have just now been not just now, yesterday been served with my lord affidavits of my lord the applicant in the GM, my lord, that's one of the legatees, and also an affidavit filed by one other legatee, Rajeshwar Parkani. So, my lord, my client is yet to, my lord, get back to us on with regard to the instructions on that. My lord, we have been served yesterday, and today we have served the both the appearing parties with our accounts. So, possibly, my lord,
altogether 3 parties are there.
Only 2 parties are there because the application has not been served on any of the legatees. That is what I had pointed out on the last occasion. But one of the parties, Rajeshwar Parkani, is appearing through their advocates.
Okay.
But others are not. I am told today that as has been submitted in court, that for Sushila Bole, they are appearing.
So what do you want now?
But I need to come back with instructions on these affidavits.
So okay, you exchange this account statement of accounts.
I have given.
Other party?
Yes.
Both have. So you go through.
I've just now given them a copy.
So both all the party go through this.
Yes.
You come if any.
This is my lordship my application that I had considered my submission for a removal of Gupta's client is concerned with. Of the now, whatever there is a chartered account report filed by the chartered accountant. That report has not been checked. So far as I can gather, Mr. Gupta is trying to justify that he has given the money back to the fund or back to the estate, right? So that case has been disbelieved by the chartered accountant appointed pursuant to the order by this honorable court. He cannot now reopen the issue because there is no challenge to the chartered accountant's report. I am going by the report. Now, Mr. Gupta is justifying a cause, trying to justify on the basis from a submission from the bar, relying on his affidavit in opposition, which case has been disbelieved. So, if he has to make the court also disbelieve the case, the report should be challenged, which he has not done. So, report holds this field because there's a procedure under the rules. The report has to be.
There's no exception. Yes.
There is no exception to the report. Stating from the bar, will not, because my volunteer is not giving an evidence. Now, if it holds good, the logical conclusion, because there are galore, there's an opinion to such a, it's an opinion or a recommendation.
But I was on the middle of my submissions, so I do not know from where this submissions are being made, because I was, and I complied with the lordship's last direction.
Let me complete. Let Mr. Ghosh come.
Someone should have little bit of patience. I did not interrupt. So, he has to either proceed on the basis that these reports are there, and his submission will be on such basis. The affidavit is now meaningless.
But I'm sorry to say, he had completed his submissions. He has made this exact submissions. I was in the middle of my submission, so I'll come back.
He is not arguing the matter because
yes, but same thing he is once again reiterated after having concluded the submission.
He is not making any only.
You have made your submission.
No, I have not made my. I have not concluded my submission, sir.
Let
I have not
Gupta,
concluded.
Please. The court is there.
The petitioner has concluded the submission.
No, I am not. He is not arguing only.
Very well.
Yes. Now, if he now, how the things can be sorted out? He says he has given the money back to the PT of the assets. That can only come forward by giving the the bank statement. There is a bank account of this particular estate. That estate account should be coming forward to the court, and he will show the entries when the dates this amount has come back. That's the another option.
So that's why they have submitted the account.
His accounts should enclosed there with the bank statement.
Correct.
Of that particular bank. Suppose I, as an executor, without leave of court, though I think it's for the benefit of the estate, take out post rupees 100. So first of all, that is unauthorized. Putting it back.
So that's why they not
the bank account he should give us.
So that they have given whatever it is, bank statement, whatever they have given, it has been circulated, go through and come, and the matter can be heard it on merit.
So
that's what I'm telling.
He should give us the bank statement. That is
whatever. If they have not given, then you argue them and they have not given. That's why I'm telling what they have submitted as an account in terms of the earlier order. Yes. Let it be circulated amongst the parties.
13.15.6. 15.6 that loan amount I have stated in my affidavit.
Okay. So whatever it may be.
The thing I have stated in my affidavit, he is saying he is contesting the proceedings. He is saying he needs funds. Now, if he wants to fight the proceedings, he has to arrange for the funds. Estate will not give him the funds.
That's why now let all the party consider whatever the accounts, and the court will decide on merit. Your submission is Mr. Gupta is arguing. I will fix the date so that the matter can be heard and finally disposed.
Funds should be used for deciding this particular litigation by the executor himself, that I want to remain there from the assets of the estate. This should not be done. If you want to fight, you fight. But the estate is not going to fund.
Yes.
And I'm fighting not from the funds of the estate.
What was the order?
Order was initially passed that the executor will give every naya paisa detail in the affidavit, and he is restrained from dealing with any of the assets and properties of the fund. That's the order of the division bench. He has to give account for every naya paisa in the affidavit. That's a division bench order. He has to comply with it. That's the justice division bench. I have placed the order. Every naya paisa he has to account for it. And he has to basically give all particulars in his affidavit, and he cannot deal with any of the assets and properties of the fund. He cannot now ask funds of the estate to satisfy please go and fight on the
Okay.
That's a division bench order. We were not granted order before the single judge. We had to go up in appeal. The only issue whether he should remove or not. That's all.
Yes, that's all. Yes, what is the summary?
This every Naya Paisa account is what I have handed over today, which I have given till date, whatever expenses.
Have you received, Mr.
Yes.
Bose, you have received?
Yes.
You go through.
And on the last occasion, it was a lordship specific direction that we should file accounts, which we have done. Kindly see the last sentence.
That's why you filed the account.
I filed the
So
account.
it has been circulated. Let
Yes.
the parties go through. I am fixing the matter for
Right.
final hearing.
And one more sentence. It was argued by my learned senior friend that there's a chartered accountant's report which is already there. We have not taken out any exception. I shall establish that I am not otherwise required to, because of the nature of that. I shall satisfy on the next
That
occasion.
is the merit of the matter.
Yes, but the most important thing is, in that report, the loan taken by my learned senior friend's client is not reflected,
Okay,
which is admitted in affidavit.
whatever it
So least said is better. So let's see. We shall come back.
counsel for the respective parties are present. Full stop. In compliance of
We
the
have
order.
also objected to that report.
Have you received the report? Copy of the report.
She's
Yes. Yes.
In GA10, we have filed the affidavit of opposition in which we have opposed it. We are the counsels for the nominee, Mr.
Rajeshwar Parkhani.
Counsel for the respective parties are present. Full stop. The parties have filed their accounts in terms of the order dated 31st July 2023. After serving the copy to the parties, let the same be cut with the record. The parties are directed to go through the account submitted by the parties. Let the matter appear on. Give the date for final hearing. 5th December 2023 at 2 p.m. as for final hearing.
But could it be any day prior to that, Miller?
Lordship's diary is good.
That is the problem. One date is gone.
Yes, Lordship diary. That is the Lordship has imposed cost.
But sometime in November, Miller, if it.
No, there is no date. That is the problem.
There is no date.
Every day. That's why when the person is coming to taking adjournment of fixed date, then I am imposing the.
Yes, your lordship is coming down heavily on them. Miller.
In fact, against the petition,
We'll come back.
there's no point.
Next.
Back to B.
I appear, my lord, for the plaintiff. This is a matter, my lord, which was earlier before the non-commercial division, where I had made an application for amendment of the plaint. A point was taken that this disputes are commercial disputes. We had, my lord, taken instruction. Then thereafter, my lord, we conceded to the point. We also realized that this is in fact is a commercial dispute. And by way of my lord's order of 23rd August 2023, the suit was directed to be transferred to the commercial division. My lord, it has been now it has come before your lordship in the commercial division. The application which is pending is in respect of amendment of plaint, which was being heard, my lord, when the matter was taken up in the non-commercial division, my lord. In fact, I had made my submissions, my lord. I had also cited judgments. Now, if your lordship if your lordship wishes, I can, my lord, recapitulate the submissions which was made. Otherwise, it was for Mr. Banerjee who was appearing on the other side, my lord, to give his reply to my arguments.
What is it is fixed today for?
It was, my lord, for hearing of the application. It was
Nothing on that side.
We were directed to take steps for compliance of which, my lord.
Have you taken all these steps
No,
after,
no.
after transfer
No
of the
steps.
suit? Who is for the plaintiff?
I'm the plaintiff, my lord.
Have you complied with all the provisions of the Commercial Court Act? Have you filed the statement of truth? List of documents? Amendment?
Amendment is carried out, I am told, my lord, but statement of
Reaffirm, all the things not done. Statement of truth, commercial division.
amendment, statement of truth, I am told, we'll do it by tomorrow, my lord.
Order 11, Rule 6, subclause 5 of the amendment.
Yes. In course of this week, that will be done, my lord. Kindly keeps it next week. But
Counsel
amendment was carried out, my lord. Only
Counsel
that.
for the respective parties are present. Full list of counsel for the plaintiff prays for a week time to comply with the provisions of the Commercial Court Act of 2015 after transfer of the present suit from the original division to this court. Consider the submission made by the counsel for the plaintiff. A week time is granted to the plaintiff for compliance of the provisions of Commercial Code Act. List the matter on 26th September.
26. Grateful.
Yes. Affidavit filed.
My lord, my application, my lord.
Yeah, affidavit filed.
My lord, there are several respondents, my lord, on the last occasion. Their lord sought for the leave, my lord, to file their affidavit.
Yes. They have filed the affidavit in opposition. Two affidavit in opposition is here. You are not received.
My lord, 1, 2, 3 had sought the leave, my lord, to file their affidavits.
Affidavit in opposition of 7 and affidavit in opposition of 6 and 7 have filed.
I appear for 6 minutes, so we have 5.
They are the contesting party.
Yes.
Now, my lord, on the last occasion, it was Mr. Dashgupta, my lord.
But he has not filed.
Shoroshi's Dashgupta, my lord, was appearing. He had all along, my lord, appeared for the defendant numbers 6 and 7. But nonetheless, my lord, on the last occasion, he appeared for the defendant numbers 1, 2, and 3. But now, my lord, he has suffered a bereavement. That's true. So, my lord, the affidavit has not been forthcoming as of now. So perhaps
on behalf of Sengupta, you are asking for time.
I cannot ask for time, my lord. It's their prerogative.
No, but what he's saying is true, my lord. There's a bereavement. And
so perhaps
you will file reply to this.
I have prepared my reply.
Replies are filed, my lord, I think.
Counsel for the plaintiff and the counsel for the defendant number 6.
I'm for 6, my lord.
Defendant number 6 are
Or
present.
6 and 7, maybe.
6 and 7.
No, I'm 6, he's 7.
Counsel for the plaintiff and the counsel for the defendant number 6 and 7 are present. Full stop. Due to some personal difficulty, the counsel for the defendant number 1, 2, and 3 are not present. Full stop. For the interest of justice, the case is adjourned for 2 weeks. This is the matter on 29th September.
Grateful, my lord.
29th September.
By then, my lord, hope no lordship has enlarged the time for the affidavit of 1, 2, and 3.
Full stop. The
Because if it's not come, my lord,
defendant number 1, 2, and 3 are directed to file the affidavit in opposition within 2 weeks. Reply, if any, they are to be filed within a week thereafter. Then it will
And
go
my lord,
2 weeks. Then let the matter. Then
September
for 3 weeks. Let the matter appear on 5th of October.
5th of October. And my lord also makes a direction in that in the event the affidavit does not come forward. Very well.
Not yeah.
We'll press it on that occasion.
Lord, may I make one request? Lord, may it be on the week thereafter. Lord, that week I have some difficulty.
You are
Instead
appearing for?
But I am appearing for the respondent number 7.
5th October.
May it be on the next week, not any day next week, from 9 to 12.
Then the vacation start.
5th, Lord, I have some
But
difficulty.
in any event, perhaps we'll be making submissions. So my learned friend.
Then
Still
9th?
9th. Let it be on 9th.
9th.
Grateful.
Number 9. क्यों इतना मैटर रखती है एक्शन कमर्शियल में इतना मैटर क्यों रखती है नहीं देना अग्रचना का मत दो लेट इट न्यू मोशन नोबडी से number 9. None appears on behalf of either of the parties. For the interest of justice, the case is adjourned for a week. List the matter on 22nd September. Number 10. None appears on behalf of either of the parties. For the interest of justice, the case adjourned for a week. This is the matter on 25th September. Next. Item 11. Same order. Fix 25th.
Item number 11.
Huh?
Item number 11.
Ah.
My lord, I'm being led by Mr. Aditya Mondal. He's on his left. If my lord, kindly observe the item.
No, why you are not taken? The case has been transferred from the this court. Have you taken all the steps in terms of the what steps you have taken? So okay, I am adjourned for a week.
Yes, my lord.
What steps you have taken?
My lord, we have amended. We have amended the plea and it has been transferred to the computer.
Then what about the statement of truth and all these things? List of documents? Have you gone through the Commercial Court Act?
My lord, I could say the week's time.
Counsel for the plaintiff is present and prays for a week time. Counsel for the plaintiff is present and prays for a week time. Accordingly, the case adjourned. This is the matter on 26th.
Item number 10, I was appearing for the.
Dismissed.
Only
Dismissed, already dismissed. 25th. Come on.
My lord is having a longer date. The plaintiff, the witness was in the box. He has passed away. I will have to bring in a new witness.
Okay, you mention on that day.
Well,
None appears on behalf of either of the parties. The matter was listed on. It is fine from the record. Since 5th February 2019, the plaintiff has not taken any steps. Lastly, the matter was listed on 28 August 2023. August 2023. But for the interest, 2023, but on the date fixed, on the said date also, none appears on behalf of the plaintiff. And for the interest of justice, the case is adjourned till today, with the condition that if none appears on behalf of the plaintiff on the date fixed, appropriate order will, and the suit will be dismissed. The suit will be dismissed. Today also, when the case is called, none appears on behalf of either of the parties. No accommodation is sought for. Accordingly, CS number 24 of 2019 is dismissed for default. Interim order, if any, stand vacated. Yes.
As to a certain status of service of summons upon the defendant.
Obtain report. Report obtained.
Yes, yes.
Yes, what about the defendant number 3?
Defendant number 3 about here, summons not been served.
Huh?
Defendant number 2 as well. For the 3 defendants, the first has been served and has also filed their written statement. The second, by the order dated 3 November 2021, the need was to be struck out from the array of parties.
Of the
Array of parties. 15.
of defendant number 2.
Yes. But although the order has been passed, the striking off has perhaps not been carried out. So we will have to take steps to strike that. For defendant number 3, it appears not to have been served because of paucity of time. My lord kindly gives us some time to take steps before defendant number 3.
Counsel for the plaintiff is present. None appears on behalf of the plaintiff defendants. Also, counsel for the plaintiff submits that by an order dated when?
November 2021.
By an order dated 15th November 2021. The name of the defendant number 2. Name of the defendant number 2 has been deleted, but unfortunately, the said order has not been carried out till date. Full stop. The counsel for the plaintiff further submits that the writ of summons could not be served upon the and was not served upon the defendant number 3 and prayed for. Could not be served upon the defendant number 3. Full stop. Counsel for the plaintiff prays for time for taking appropriate steps. In view of the submission made by the counsel for the plaintiff, the case adjourned for 2 weeks. In the meantime, the plaintiff is directed to take appropriate steps. Release the matter on 6th of October 2023. It's not working. Yes.
Lordship, I appear on behalf of the plaintiff. The matter has already been reserved by the NCLT and admitted for the CIRP process. My lord, may kindly allow me, then I'll hand over the copy passed by the Honorable National.
What do you want now?
Lordship, may kindly remove this matter from the list, and as and when the moratorium period is over, we shall mention this matter before your lord.
So I am adjourning for 4 weeks.
Lordship, the moratorium is still on.
Still on.
Yes, my lord.
Give the order.
I've My lord, may kindly come to page 7 of the order.
Yes.
Paragraph 13A, the application being CPIB number 121 KB of 2021 filed by Tickmoney Steel Trading Company, the operational creditor, under section 9 of the code, read with rule 6, clause 1 of the insolvency and bankruptcy application to adjudicating authority rules 2016 for initiating CIRP against Imperial Tubes Private Limited is admitted. And the next statement in paragraph 13B is there shall be a moratorium under section 14. So the moratorium is still on, my lord, in this matter.
What is the date?
The date of the
22nd August.
2nd
August 2022.
2020. The moratorium is still, the matter is still.
More than 1 year moratorium is going on.
Yes, my lord. Once the period of moratorium is over, my lord, we shall mention it before your lordship.
Counsel for the plaintiff is present and handed over the copy of the order passed by the NCLT, Kolkata Bench -1, dated -1, dated 22nd August 2022, wherein the application filed by Tickmoney, TIKMANI, Tickmoney Steel Trading Company Limited Company, comma, the operational creditor, comma, under section 9 of the code, COD code, read with rule 6 within bracket 1 of the insolvency and bankruptcy within bracket application to adjudicating authority, comma, rule 2016 for initiating CIRP against Imperial Imperial Tubes Private Limited, Tubes Tubes Private Limited within bracket defendant herein is admitted and moratorium is still continuing. In view of the order passed by the NCLT and the submission made by the counsel for the plaintiff, let the case go out of the list for the present. Liberty to mention.
Much obliged, lordship.
None appears on behalf of the None appears on behalf of either of the parties. For the interest of justice, the case adjourned for 2 weeks. Leaves the matter on 29th September.
Your Lordship, may I have your kind leave to mention item number 9 of the commercial division, Your Lordship.
Sorry. Yes, call the list.
Non-commercial list. Item number 1.
Special officer slash commissioner is appointed for collecting rents and income from the properties, for clearing all the dues of the joint estate, and after clearance of the dues to hand over the possession of the respective shares of the parties for effecting partition in terms of the preliminary decree passed by this court dated 22nd January.
Grateful, my lord.
Item number 2.
My lord has been pleased to state that the special officer has been granted the liberty to pay off the dues. Otherwise, we'll have to
collecting and pay.
Very
And thereafter the possession. And all the GS has been disposed of.
Number 2.
A special officer is appointed, and I have given 5-6 points on which condition. And the remuneration of the special officer shall be paid by equal share, and the special officer shall submit the report.
Special officer.
Your Lordship, item numbers 2 and 3 was.
It was for
Substitution.
substitution.
Amendment is substitution is dismissed. That is different. That is the GS2.
GA2, that is.
GA2 is dismissed, and with regard to this, the commissioner was appointed.
Your Commissioner is, but Your Lordship, the
In
hearing
GS6.
was, yes, Your Lordship, but the hearing was not concluded on that.
Concluded, Mr. He has given the accounts and all these things. Mr. Rupak Ghosh?
Rupak Ghosh had argued on the last occasion. and
But
also-
it was very well, Your Lordship.
See the last order?
Great. Your
Much
Lordship.
obliged.
But before your lordship calls up the next matter, my lord, OCD 15, my lord, I was stuck in the rain, my lord. Lordship 15, my lord, last matter in the commercial division, my lord. My lord will only make it not today. It's a very simple application, my lord. The suit has already been decreed by your lordship.
I have passed some what
My lord has kept it on 29th possibly.
29th.
My lord, it will just
What order you want?
only the interest portion. Your lordship has relegated it to interest. I have taken out an application only for the interest portion.
But the
Nothing
interest person, how the court can what?
My lord, it's your lordship's order only. My lord has relegated it to a suit.
Ah.
My lord, I have taken out an application. Though I need not take out an application, but I have still to assist the court taken out an application. The interest period is settled. Only your lordship only has to pass a direction to that effect, my lord. Nothing else. The suit has already been decreed by your
Okay,
lordship.
come on, 929. Come on.
But any day before that, my lord, if
Before
possible,
that,
my
it is not possible. That's why I'm fixing because
I'll come back on it. Wait.
More orders. Item number 4.
I appear for the plaintiff in this
I'm for the defendant.
matter. Let there be direction for inspection, discovery, and since written statement has been filed and additional written statement has also been filed by my client, my lord.
that has been filed.
My lord.
So now in discovery and inspection.
My lord.
Who is the other part?
My lord, he is for
Both
appearing for
parties
the
are there.
defendant.
Counsel for the respective parties are present. It is fine from the record. The a written statement and additional written statement has already been filed. Full stop. The parties are directed to complete the discovery and inspection of the document within 3 weeks.
My lord.
Full stop. Affidavit of admission and denial of the document be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange the suggested issues.
As you lordship.
Full stop. This is the matter on 17th October 2023 for framing of issues.
I'm grateful.
Next.
My lord, I appear on behalf of the defendant number 3 and all defendants, my lord. In compliance of your lordship's order, my lord, on 7th August 2023, my lord, order dated 27th August 2023, my lord, we have complied with the orders and rupees 36 lakhs that was deposited with the register original side, my lord, that has been returned to the plaintiffs. and the interest accrued thereon, my lord, has been returned to my client as defendant number 3. My lord, now the suit needs to be final degree needs to be passed, my lord, in the suit. It is a partition administration.
That complete.
All things are
Conveyance deed is over.
Yes, conveyance is over. We have the department has disbursed the amount in favor of the plaintiff, and as well as the interest accrued on the amount deposited, my lord, that has also been returned to the defendant number 3. All things has been complied, my lord. Now the suit is waiting for the final degree to be passed, my lord.
What remains final degree?
Lordship, the declaration of the shares of the defendant, my lord, the initially preliminary degree, there the plaintiff's share was 25% that was declared. Now, since the partition could not be carried out, my lord, the 25% shares of the plaintiff has been purchased by the defendant number 3. Now the defendant's shares are need to be declared.
Correct.
I prepared a convenience note, my lord,
but that deed is to be brought on record.
Lordship, the particulars
because at the
of
time
the
final degree, then it will be difficult.
Lordship, the particulars of the deeds, my lord, that has been
That is
given.
correct, but that you do one thing. You are for the defendant, plaintiff.
Defendants.
Defendant. Who is for the plaintiff?
Plaintiffs. I sent for them, my lord. I have been told that
You have purchased that. No?
Yes, I have.
So you do one thing. You come with a small two-page application stating all these things. So because what will happen in the future at the time of passing the final decree, then it will be difficult. If that date will become, then the final decree.
My lord, very well. I shall produce before your lordship the certified copy of the deed, my lord. Only thing is this: the application GA10, my lord, that is pending for disposal, my
What
lord.
is the GA10?
GA10,
What
they have prayed for sale of the property.
So that is disposed of, and that is over.
That is over. That needs to be disposed of formally. And if your lordship another application is required for the final decrement, we may come up for that. That's not a problem.
You do one thing. You come with that deed. You are having the deed now.
Not now, my lord.
You bring the deed.
I have to obtain the certified copy to produce.
You bring the
before your
deed. I will dispose of the final decree as well as this application in terms of that.
GA10.
GA10.
I'll do that, my lord. Any day.
As per the prayer made by the counsel for the defendant number.
Defendant number, all defendants, my lord. Now you are.
As per the prayer made by the counsel for the defendants,
I am
the case
appealing on-
adjourned for 2 weeks.
2 weeks, my lord.
My lord, I am appealing on behalf of the plaintiff.
Counsel for the respective parties are present. As per the prayer made by the counsel for the defendant, the case adjourned for 2 weeks. List the matter on 27 September.
Only one sentence, my lord. Directions upon us, my lord, to produce the certified copy of the
27 September 2023. The counsel for the defendants and the counsel for the defendant is directed to produce the certified copy of the deed executed between the plaintiff and the defendant number 3 on the next date fixed.
This is my application, my lord.
Yes.
For the plaintiff. This is, my lord, in a suit for eviction, a summary decree of eviction was passed under Chapter 13A. A learned commissioner was appointed for determination of mean profits. Evidence was adduced before the learned commissioner. We had, my lord, filed or given evidence to a valuer. Valuer had given his report. The defendants, though, did not give any valuation or file any valuation report. They gave evidence through 2 of their employees, and they relied upon certain deeds of lease in respect of certain properties. Considering everything, the learned commissioner, my lord, has determined the mean profit at rupees 138 per square feet, my lord, in respect of the property. The property is, my lord, on Strand Road. It was used by the bank as a branch for a substantial period of time, my lord, but thereafter, my lord, it has been, we have, my lord, filed this application for, my lord, acceptance of the report of the commissioner, and, my lord, passing of a final decree for mean profits on that basis, my lord. But this is, my lord, the long and short of it. There is no formal application by the defendant taking exception to the report. What the defendant has done is, by an affidavit, they have challenged the report, not by way of a separate application. Now, on the last occasion, this
GA3 filed by you.
GA3 is yes,
For
plaintiff.
confirmation of the final.
Yes, confirmation of the report of the.
And defendants have not filed anything.
Defendant has filed their affidavit to this application.
Affidavit only. They have not challenged
No,
it.
they have not taken out any application. Now, if I may, my lord, notes of argument was also, my lord, on the last. I'm not sure whether your lordship, because notes of argument was also filed, because when the matter was taken up before, my lord, the coordinated bench, there was a direction for filing notes of argument. So therefore, by 10th of March, so we had thereafter filed our notes of argument on 1st of April 2020.
Notes of argument filed by
the plaintiff.
Yes. Then,
my lord, before taking your lordship to the notes, my lord, may I possibly, I have to, my lord, take your lordship through the, my lord, the operative part of the report of the special of the commission.
what the dispute they have raised?
Yes. The in the opposition, my lord, one
ready. You're ready?
My lord, I'm led by Mr. Sashwat Nagan, but he's coming, my lord.
Next. The first dispute raised in the affidavit is that the valuer on whose report, my lord, reliance has been placed by the learned special referee. The valuer is not an independent person. The special referee should have engaged an independent valuer, and then thereafter the special referee should have proceeded on the report. Second defense rather is that the bank was not making profit from the branch which was being run from the suit property, so there could not have been any opportunity of that's neither here nor there in respect of for mean profits. Thirdly, for the first time before this honorable court, they have relied upon a valuation. They have annexed a valuation report to their affidavit in opposition. No valuation report filed before the learned special referee.
Evidence was
Yes. Evidence was evidence was given. Evidence, my lord, by we had given evidence through our valuer, who had, my lord, filed a valuation report. I'm led by Mr. Mitraman. A valuation report. They had given evidence through two bank employees, who are admittedly not experts in the field, who had produced certain deeds to show that what should be the comparative market rate. Now, while cross-examination, the method which was used, my lord, for valuation by our valuer could not be impeached. In fact, there was hardly any question put to that effect. Now, in there, they did not also give any valuation report. Before this court, in the affidavit to my application, for the first time, the defendant has come up with a valuation report. Now, as per their own valuation report, whereas in respect of the plaintiff's valuation report, it was rupees 138 per square feet with taxes. Their valuation report is rupees 88 per square feet without taxes. That's without taking into account the municipal taxes. So if municipal taxes is added,
the 138 has come
with
considering how.
Yes, considering
present market value.
Market value, 3 comparable properties, and also, my lord, yes, I'll show, my lord, the report of the valuer and proper comparison as to what would be the value of the present property in respect of by comparing it with the other properties. And that was, my lord, a detailed report to that effect. Well, I take your lordship, my lord, through that report. Their valuation is, and that was inclusive of the municipal taxes, rupees 138. Exclusive of municipal taxes, as per their report, which for the first time they're relying upon, is rupees 88 per square feet. So if municipal tax component is included, that will automatically 88 rupees per square feet will be substantial, plus 60%. 60% will be commercial surcharge as per the, my lord, the prevailing municipal law. It will be 60% plus 88 rupees plus 60%. So it comes to possibly the same figure of rupees 138. In fact, 10 rupees less to rupees 128 per square feet. So if I may show, my lord, the valuation report which we had relied upon and the findings of the special referee in respect of that report, my lord. Your lordship takes. Yes, valuation report to component. Yes. Page volume 1, the affidavit of evidence, my lord, page, it starts from page 83. Where is that? Yes. Page 107, my lord, is the valuation report. Page 83 is his affidavit of evidence.
83
Page, my lord, 83
of GA.
of GA, yes, volume 1. Page 83, my lord, the affidavit of evidence starts. Annexure E, my lord, GA1. Is your lordship got it? Yes. I'll take your lordship, my lord, straight to the valuation report, which is at page 107. The premises, my lord, description is there. Estimation of market rent of office unit occupied by UCO Bank. Page 107. Well, that's the exhibit, my lord. That's the valuation report, which was exhibited with the evidence.
Yes.
Estimation of market rent of office unit occupied by UCO Bank of the portion of first floor of model house commercial building at 40 Strand Road, Barabazar, for the period of 1st March 2017 to 1st March 2020. This is, my lord, the period for determination of mean profits, and this is an undisputed fact. There's no dispute regarding this.
Period is not.
Yes, no, there is no dispute as to these dates or the range of the period. Yes, because it's still the time they had vacated the property. Yes. Now I'll not trouble your lordship with the scope of work. Yes. Kindly comes to, my lord, page 109. Location and description of the property. Page 109, location and description of the property. The valuation is carried out for the first floor unit facing west occupied by UCO Bank in a commercial building called Model House, which is a basement plus 7-storied building standing directly on Strand Road at the heart of Central Business District of Kolkata. The surrounding area is fully commercial in nature and is full of trade and business activities. It may be mentioned that almost all the floors of the building Model House is occupied by small and medium-sized retail and office units of different nature. This is a west-facing commercial building standing on the Strand Road. The Strand Road is a north-south road of about 70 feet width, which is well integrated with the road network within the Central Business District. The location is very close to Brabon Road flyover and Strand Road intersection. The building is approximately 50 years old and is framed in RCC beams, columns, and floors. The subject office unit is in good internal maintenance. The floors are of mostly IPS flooring in grey cement. The office space occupied by UCO Bank covers a carpet area of 4,800 square feet, more or less, which is not subdivided by internal brick partitions. There is only one enclosure of a medium-sized store and a locker room on the southern side of the floor. The external walls are of bricks finished with color wash. The windows are of plaster size steel frame. The doors are mostly made of plywood. On the northern side of the floor, there is a toilet block. The toilet is finished with ceramic tiles and such and such. But then thereafter, my lord, what are the other accessories in respect of the property? Yes, the description of the property.
Oh, analyze it.
Now, if your lordship comes to page 111, my lord will find 111 and 112. He has, my lord, taken 3 properties or used 3 properties, my lord, as the basis for determining, my lord, the market rate of surrounding areas. The one is, my lord, the Lushan Sarani, page 111. This is, my lord, I'll just, my lord, indicate the area. There is an office space situated on the ground floor of a 15-storied commercial building in the close vicinity of Tereti Bazaar. The property is at a distance of about 1 kilometer from the subject property, measured as the crow flies towards north-south. Now, yes, if your lordship sees the last paragraph, there is an existing lease in the property where ICICI Bank Limited is the lessee. The lease was created with effect from 10th August 2017 for 9 years, granted by Mrs. Ganesh so-and-so to ICICI Bank Limited. The lease was granted at the rent of rupees 3,15,000 per month, that is rupees 186.17 per square feet plus GST, subject to the condition that the maintenance and repairs and municipal taxes will be borne by lessor. There is rent review clause of enhancing the rent by 15% at the end of each 3 years interval. So your lordship will find the period of 10th August 17. That's similar to the period which was there. Now, the next page, it's, my lord, the second property, 18 Robindra Sarani, Kolkata 1. The first paragraph, I'll just give the description of the property. This is an office space situated on the first floor of a partly basement plus 10-storied commercial building named Poddar Court in the close vicinity of Terity Bazaar. This property is at a distance of about 0.9 kilometer away from the subject property, measured as the crow flies towards southeast direction. This property is situated just on the intersection of Lusan Sharani and Robindra Sharani, both being about 75 feet wide roads. So and so. Then, Mala, the next paragraph. There is an existing lease in the property where Central Bank of India is the lessee. The lease was created with effect from 1st October 2014 for 21 years, granted by Messrs. Poddar Projects Limited to Central Bank of India. The lease was granted at the rate of rupees 120 per square feet plus service tax, subject to condition that maintenance and repairs will be borne by the lessor. 50% of the municipal tax and 100% of the commercial surcharge are to be borne by the lessee. There is a rent renew clause of enhancing the rent by 15% at every 3 years interval. Then, Malo, the last property is the Church Lane, 6 Church Lane. There's an office space situated on the ground floor of a 4-storied office building in the close vicinity of Calcutta High Court. The property is at a distance of 1.1 kilometer from the subject property, measured as a crow flies towards the southern direction. This property is situated on Church Lane, facing the road to its east. Then Church Lane. And if your lordship kindly turns over the next page, my lord, page 113, the second paragraph. There is an existing lease in the property where United Bank of India is the lessee. The lease was created with effect from 16th July 2018 for 10 years, granted by one Rukmani Devi Bangar and 4 others to United Bank of India. The lease was granted at the rent of rupees 150 per square feet per month plus GST, subject to the condition that maintenance and repairs and municipal tax and other tax will be borne by lessor. Lessee will pay at the rupees 3 per square feet per month towards maintenance charges. There is a rent review clause enhancing the rent by 25% after 5 years interval. Now, if your lordship kindly sees, very well. Yes. The approach of valuation, just above the market rent of the subject property as on 1st March 2017, in the same page, the paragraph before it. The approach of valuation in this case is market approach, and the method followed is comparable transaction method. We take up the comparables one by one. First of all, we estimate the market rent of the subject property as on 1st March 2017. Market rent of the subject property as on 1st March 2017. We take into account the following characteristics of the subject property and comparables for giving appropriate weightage by way of additions and deductions because of differences between these characteristics. These characteristics are time aspect, location aspect, age aspect, specification aspect, size aspect. Now, comparable A, that is the first property. Comparable A, is the Lushan Sarani property. Comparable A is the ICICI Bank Limited, situated on the ground floor of Todi Mansion. The rental value of comparable unit is rupees 3,15,000 per month. That is rupees 186.17 per square feet per month. But there is security deposit of rupees 9,45,000. Annual return on the security deposit is, say, rupees 6.5%, which is rupees 61,425. So annual return, taking that into consideration, is 61425 by 169 to rupees 36.30 per square feet, or rupees 3.02 per square feet per annum, and rupees 3.02 square feet per month. Therefore, effective rental value is rupees 186.17 plus rupees 3.02, that is rupees 189.19 per square feet per month. It has been rounded up to rupees 189 per square feet. Now, adjustments are made as follows. Time aspect. The comparable unit A was leased out with effect from 10th August 2017, whereas the rental value of the subject property is to be estimated as on 1st March 2017. It can be stated from an examination of macroeconomic indicators of Indian economy that the GDP growth rate continuously fell from first quarters 2017 till date. Time has impacted to a great extent to the real estate sector, and rents can only be taken between 17 January to December as stationary. So we allow no addition and deduction due to the time aspect. Location aspect. Locationally, comparable A and the subject property have more or less similar features with some differences because comparable A is situated at a nodal point of transportation network. Also, the surrounding area is occupied by several office complexes. Further, it is its close proximity of the Territory Bazaar complex. Also, Metro Railway corridor runs only about 5 minutes walking distance from comparable A. Further, comparable A, ICICI Bank Limited, is situated on the ground floor of a 15-storied building on about a 65 feet wide road lying to the south of the property. There is a corner plot with frontage on a local road of about 15 feet width. The ground floor position gives the unit a good potential for other profitable uses such as showrooms. Having considered the advantages and disadvantages of the location, we allow the following adjustments. For proximity to Metro Railway station of the comparable unit, we allow a deduction of 10%. For position in the ground floor of the comparable unit, we allow deduction of 15%. For the subject property being in close proximity with Bara Bazaar, we allow an addition of 10%. Net deduction, there is 10 plus 20%. Age aspect. Comparable unit A and the subject property are more or less same age, both being more or less 15 years old. So I do not allow any addition and deduction on this ground. Specification aspect, the floor of the comparable A unit is of vitriol, whereas so on this account, we allow a deduction of 4%. Size aspect, for larger size of subject property, we allow a deduction of 10%. Therefore, after total adjustments are worked out, then the deductions have been given, adjustments have been given. Therefore, from this comparison, the market rent of the subject property is worked out as followed. Market rent with the adjustments, rupees 125 per square feet per month, subject to terms and conditions stated above. So considering a property which has rupees 189 per square feet, after giving adjustment of various location, time factor, and other factors, as per the first property, it has come to, as per the valuer, rupees 125 per square feet. Then the comparable B was in the Poddar Court, the property with Poddar Court. I'll not take your lordship, my lord, with details of the adjustments, because adjustments in the similar manner, adjustments have been given. If your lordship kindly comes to page 117, upon adjustment, as per comparable B, the market rent was rupees 139 per square feet, as on. Similarly, my lord, page 117, my lord, this is in relation to comparable B, was coming to rupees 139 per square feet.
Yes.
Comparable C, my lord, was in respect of the Church Lane property. That also after adjustments,
155.
page 118, is rupees 155. That is after adjustments. So now on page 119, the market rent as on 1st March 2017 has been determined by comparing all the three rates. Page 119. But considering the different aspects of the comparables and the subject property, and based upon discussion noted above, I am of the opinion that the market rent of the subject property as on 1st March 2017 is rupees 139 per square feet per month, subject to the terms and the lessor will undertake all major repairs and maintenance work and pay the municipal taxes. So this was excluding municipal taxes, pay rupees 139. Then market rent of the valuer was of the view that the market rent for 18, 19 until 1st March 2020, there would not be much significant changes. This also he has indicated in page 119, clause 2, 3, and 4. The performance of not being impressive, so is of the view that there has been no substantial increase in market rent in either 1st March 2018 or 1st March 2019 or 1st March 2020. And then his conclusion is at page 120. Based on the above discussion, I'm of the opinion the market rent of subject property as on then 17 to 20 is estimated at rupees 139, subject to major terms and conditions. The lessor will undertake all maintenance and repair work and pay municipal taxes whatsoever. Well, this was, Mala, the report of the valuer. He has taken into consideration three properties. He had given adjustments in respect of all the advantages which the three properties had, and along with all the disadvantages also apropos the properties. And he had come to a finding that it, without the obligation to pay municipal taxes, it comes to rupees 139 per square feet for the period of 2017 to 2020, with there being no substantial difference in the 3 years as to enhancement of rent. I mean, valuer report. My lord, kindly permit. My lord, grants leave to Mr. Mit. Notes file.
Note kindly. The notes of argument. I will not. This is not a matter which should take up too much time. Can you see the notes of argument, lordship? which we had submitted along with the judgments.
Yes.
From page 2, the applicable provision is Order 20 Rule 12 or 12 Sub Rule 2. So important because though the section is very much in my favor, it says the report will be accepted. But I will not push my case that high, but that is the statute language. Order 20 Rule 12 Sub Rule 2. As you kindly take a look at that. Where an inquiry, because Order 20 Rule 1, Order 20 Rule 12. This is a case covered by Order 20, Rule 12, Sub Rule 1, Clause C. An inquiry was directed by the court. So now what happens? Sub Rule, now Order 20, Rule 12, Sub Rule 2. Yes. Where an inquiry is directed under Clause B or Clause C. A final decree in respect of the rent or mean profit shall be passed in accordance with the result of such inquiry. So that's a mandatory provision. Of course, they can. I will not push my case that high to say that they can't challenge the report, but still that is the provision. Now, a few basic parameters. Property in question is 4,800 square feet. It's on the ground and first floor of Strand Road. Now, our evidence I've given a comparison chart, page 2. Paragraph 6 is the list of properties. At page 3, Lordship sees. Because the period in question here is from
17 to
February 17 to March 17 to February 2020. India Exchange Place. This is first property is ground from India Exchange Place. India Exchange Place is no longer what it used to be, Lordship may take it, from the time when the stock exchange was functioning. Calcutta Stock Exchange gave a boost to India Exchange Place. Stock exchange has been closed down. So India Exchange Place is no longer has its charm. 2017 for 9 years, 186 rupees. We have given Ravindra Shore Chitpur Road, much lesser quality of property. 120 rupees plus service tax plus KMC plus surcharge. It comes to much more than 150 rupees. And then third property we are given Church Lane. That's very close by, 150 plus GST plus maintenance. So these are our 3 cases. The defendant's evidence is page 4. Now they want to come out of it. Is a case of from 1st August 2009. 2009. This is 8 years apart. This is also first floor, not ground, and ground gives a different value. The second one is a lease commencing from 2011 on second floor of Canning Street. Canning Street is also much deeper inside. And lastly, it's a conveyance deed they've gone by. Conveyance is on a market account value. Now, Lordship kindly come. So we have given the paragraph 8 is the special officer's report, who has analyzed the entire evidence. There is no allegation of impropriety or any. Now, what is the law? Law is applicable. Law is market rental value is the basis for determination of mean profit. I have given 3 recent judgments. And what is very important is paragraph 9, subparagraph Roman 2, page 5. There is no cross-examination on comparable rentals relied upon by the plaintiff's expert. He was not cross-examined on the rental. Thus, the comparable rental relied upon by the expert should be accepted. Here, I have relied upon Carapiet and Justice Arun Mishra's judgment with CBI. Kindly see Carapiet's case, which is our favorite on the original side. Lordship kindly comes to page 28, just P.B. Mukherjee's judgment.
No cross-examination.
Yes, no cross-examination. And the next one is just, I think it's Arun Mishra. Na? So there's one just Arun Mishra. This is not by head note. The next proposition I've gone on to is Roman 3. The defendant having failed to adduce any evidence on market rate on market rent existing on the date of expiry of lease or around that time, or a date around that time. The court would have no option but to accept the plaintiff's evidence of such market rent. Here, I'd like to place this paragraph from Indian Oil Corporation, page 186. Paragraph 9 of this judgment, running page 188.
Yes.
This is the proposition which applies here. Paragraph 9, page 188. It would be seen from the order passed by the First Appellate Court that the respondent plaintiffs in their plaint had stated that the market rent of the suit premises was approximately 40,000 per month. They deposed to the same effect in their testimony in court. The appellant did not cross-examine or produce any evidence to counter the statement made by the respondent. Since the appellant failed to produce any evidence or even cross-examine the plaintiff respondents regarding the market rent existing on the date of termination of tenancy, there is no option but to hold the order passed by the First Appellate Court, fixing mean profit at 35,000 per square, which has been duly affirmed by the High Court. I mean, I'm on this problem. And lastly, Mother, coming back to my note, page 6 of my note, Division Bench judgment of our High Court. This is Matre presiding over. Roman 4, determination of mean profit by the special referee should receive a liberal and purposive construction. And the court ought not to be over strict in accepting proof of the amount as given in the special referee's report. Otherwise, here, this is element of guesswork has to be there. That is National Insurance Corporation, page 189. It starts at running page 200. Sorry, 195. Paragraph 19 of this is Matre and Stopobroto Chakraborty's division bench. Paragraph 19, page 195. It is well settled that a person who is deprived of a right to possess a property is not only entitled to receive possession of the property, but also damages for wrongful possession from the person who had occupied the property wrongfully and illegally. The mean profit is meant to be a compensation, which is penal in nature. Object of awarding a decree for mean profit is to compensate the person who has been kept out of possession and deprived of enjoyment of the property, even though he is entitled to possession thereof. Since mean profit is in the nature of damages, no invariable rule governing its award and assessment in every case can be laid down, and the court may mold it according to the justice of the case. There exists hardly any uniform and standard pattern of assessment of mean profits. Comparative assessment of the nature, location, accessibility to the main road, facilities, age of the suit premises on the one hand, and similar circumstances in surrounding area on the other hand, be relevant factor in assessing the mean profit. Such determination of the amount of mean profits must receive a liberal and purposive construction, and the provisions relating to mean profit is required to be construed in a manner that is just and equitable. While determining the mean profit, the court need not be over strict in expecting such proof of the assessed amount as would accept for holding certain facts being established. By applying such proposition of law to the facts of the case, we will find an infirmity in the decision-making process as adopted by the Commissioner. Towards determination of mean profit, and the learned single judge, upon appropriately weighing the evidence on record and upon considering the relevant factors as applied by the Commissioner towards determination of mean profit, has arrived at a specific finding and not find any illegality. Now, Lordship, I will finish my submission by relying upon the affidavit in opposition filed by my learned friend, which is their objection. The affidavit, an exception they've called it, to the special officer's report. So it kindly comes to page 6. Page 6. Paragraph 19. This is their only statement so far as this report of the Learned Special Referee is concerned. Paragraph 19, page 6. The defendant respondent states that the said report is erroneous, incorrect, and based on the wrong appreciation of law. Why? Learned Special Officer's conclusion as to a mean profit is solely based on the valuation report. Report submitted by Valuer Vijay Chakraborty. Comparative rents are taken, but why? Why is it bad? What's wrong? Nothing. The defendant respondent state that for the purpose of consideration of the fair market value, the defendant had appointed a valuer, and the valuation report has been prepared dated 16th of February 2022 for estimation of fair rent. Property which is coming at 88.99 rupees. This was not before the Learned Special Referee. This they did not file.
It was not produced in the evidence.
No, not producing evidence.
Yes.
The report of special referees are 31st August 2021. And this is prepared in February 2022. The principles of Order 41, Rule 27 has to apply. We are really the appellate forum now, before my lord.
Yes. So it is 19 February 2020, the report.
Yes, and this is 2022. This report, page 7, Lordship will find.
19 February 2020 is our report.
Oh, well, the 1920 is our valuer's report, and the Learned Special Officer's report is dated
31st August 2020.
31st August 2021. That is page 351.
Page?
351 of the application, volume 3.
And when the witness was examined?
Was examined. This was, I will tell your lordship, this was 24 volume 3, page 284.
Okay, well, anyhow, this is the 2022 after the report. Okay.
After the report. This is the explanation why they could not get a valuer earlier. And she also sees paragraph 22. The plaintiff has suppressed the fact that they had, as per their own accord, given proposal to the defendant, increase the rent exorbitant to 120 per square feet. 120 per square feet plus taxes would make it 60% more. It will become to almost 200 rupees per square feet. Now, Lordship kindly sees the report of the special referee, which he has now got. Of the valuer which they have got in the opposition. Page 44 is the report. Kindly come to the conclusion at page 52. I'm going straight to the conclusion.
52.
52.
Yes.
Page 52, Lordship will see 88.99 per square feet. It doesn't say 89 rupees per square feet. It does not say inclusive of municipal tax. Under section 230 of the Municipal Corporation Act, a landlord is entitled to recover the entire surcharge plus 50% of the municipal tax.
Yes.
Now, kindly compare with with the report of the Learned Special Referee. Kindly come to page 328, volume 3. Kindly come to the conclusion. Oh, sorry, 351, last volume. Report of the special referee. Kindly come to the conclusion at 360, last page of third volume. 366.
139 into 4,800.
Yes. Kindly see the bracket portion, including taxes. So as per this, I can't recover the taxes. So I have to, so it will come to 89 rupees, 90 to 89.99 90 rupees. It will come to 20%, 10% more than what even their late valuers report has given.
So 88.99 plus the
Plus the commercials tax, plus 40% is the municipal tax, and 50% of that is the commercial surcharge. So 60% is the total tax on 90 rupees. 60% is 54 rupees. So it comes to 54 plus 90, 144 rupees, more than what the 60% of 90 is 54. Add to I'm talking 88.99, and I'm not taking 90 rupees. 144. Now I get, as per section 230 of the KMC Act, 50% of the municipal tax I can recover from the tenant. The tenant is liable to pay the occupier and the entire surcharge. So 40% I can recover. 40% of 90 is 36 rupees.
40% 90 equal to
36.
Okay.
So 116 rupees if you go by their value.
And 50%, how the municipal tax, the 50% you can calculate?
Lordship, the commercial tax. Lordship, kindly takes a look at the KMC Act. Lordship has the KMC Act. Where does it say? কোথায় আছে? Yes. 230 of the
Act. Yes, 230, apportionment of the property tax.
The person primarily liable to be, which is the owner, instead of any lander, may recover if there be but one occupier of the land from such occupier half of the rate so paid.
Half of the rate so paid.
And may, if there be more, I mean, here is only one occupier. And now see B, the entire amount of the surcharge on the property on any land, which is the surcharge section. Go to surcharge section. Surcharge section. Provided that if there is more than one here, so now you will see from every bill, it is 40% is the municipal tax.
No, it is correct. 40% the municipal. See, he has taken the total 139, including the
taxes.
Correct. So, how the tax is calculated? How?
The tax is calculated on the rent 40%.
On the total rent of the
total rent is for total rentable is 40%, and of the tax, 50% is surcharge.
Surcharge.
Commercial surcharge. So 40%, half of that is commercial surcharge. So 40 plus 20 is 60.
60%.
So the landlord can recover half the municipal tax. That is half of 40% is 20%, and the entire surcharge. So 40% he can recover. So here, what they have given comes within the margin of discretion. So there's, if you go by their report, I can recover 116 rupees. My report 39 rupees. Now, assuming this report is looked at also, the report of HON'BLE should not be looked at, because after all, this should have been there. But just for my lord's conscience, I'm saying that.
Yes.
See, I'm not placing all these judgments separately, but these are.
Thank you.
That is all. I'm grateful to my.
Yes.
At the very onset, my lord, as taking a cue from the judgment already placed on record by my learned friend, this court, my lord, would not be restricted to the special officer's report. That would be the settled proposition of law. So even at this juncture, if my lord looks at the property, the valuation that has been arrived at in the special referee's report, and then your lordship sees that the amount could be changed, could be even in for that matter increased, or for that matter decreased, my lord, your lordship would have ample powers to do it. So the question of order 41 rule 27 effectively, in my understanding, and your lordship tests it, would not apply, because technically your lordship is not sitting in appeal of the report filed by the special referee. The special referee is acting as an officer of your lordship.
No, see, special referee has filed the report on the basis of the expert. Correct, appointed by the party or the special referee, whatever it may be. So, and you got the chance for cross-examination of
I have.
correct.
I have.
And I don't know whether what is your submission. So you are not cross-examined on this point.
No, with respect to bringing in a valuation report at the time of the proceedings which were pending before the special referee, as per my own admission, I have not done it.
Okay.
I brought in 2 new witnesses. I led evidence on points. I have cross-examined the valuer appointed by the plaintiff. So that cross-examination has also happened. Now, what is the outcome of that? Your lordship will have to judge that. I will argue on. But with respect to the point that the valuation report that I've annexed to my exception, and Mr. Mitra was extremely fair, he said that for your lordship's conscience also, that may be looked into. He also said that the difference between the two would also be slightly marginal. So I'm not getting into the point of whether that can be at all showed before your lordship or not. I am saying that today my lord would have ample powers to look at, for that matter, if there was no documents, no records in front of your lordship on a presumption of what is the actual situation at the ground level, would be able to arrive at a conclusion. And there are several judgments on that point.
No,
So
that is correct, but if the court once the court find that the report which has been relied by the special referee is sufficient and is good enough, so
to that I'll argue that it's not, my lord. And I'll also indicate for my learned friend's convenience, the point on which I am challenging the report are manifold, my lord. One, the basis, whether Mr. Mitra took a certain paragraph of my exception and said that I've challenged the validity of that report. The ground on which I challenge the validity of the report is that the report relied upon by the special referee takes into account 3 properties. Now, if you have to take into account properties for the purpose of arriving at a fair rent, that property has to have some nexus with the property in question. Now, these properties, as relied upon by the valuer, and therefore that valuation report is relied upon by the special referee, are properties which, in my humble submission, subject to your lordship's test, my lord, are properties which, number 1, do not fall within the same locality. Number 2, the property has different other advantages, such as the connectivity, such as the age of the building, such as.
Nothing was done cross-examination.
But I don't need to. That's my point.
Nothing in cross-examination.
That's why if
No, these questions were, I would show them, my lord, to the extent.
You can challenge the special referee report, because the special referee report is the final report. You
Right.
don't get the chance of cross-examination of the special referee. That is before this court. Now, but you got the chance because the special referee has accepted the report of the expert.
And lordship looks at the reasoning which the special referee.
Okay, will come on.
Lordship looks at
Correct.
the only reason that report is taken into account, because he says that the person is lordship will allow me to give the phrase, my lord, because I don't want to usurp his wordings. The only reason, my lord, he says that the special referee's report is to be taken into account is because he's an expert in the field. So whether or not the validity, whether there's a propriety attached to whether or not these properties that are considered in comparison are at all related to and or on the same pedestal as the property in question, is not even discussed in the special referee's report.
Okay.
So I ask myself if I'm required to, in law, my lord, to challenge the valuation report separately if I'm challenging the special referee's report itself. So there are 2 aspects, 2 legs that my arguments stand on. First is that the valuation report itself is faulty because of the property and the nexus between the property in question and the property is concerned. I'm detaining your lordship back, my lord. I'll just indicate, I'll come back. Number one. Number two, whatever valuation report, my lord, has been given by the valuer, the special referee is also under an obligation to find some reasoning as to why it is relied upon. Those would, I wouldn't stretch this beyond the point, my lord. That would essentially be what my submissions are. And apart from that, only one other document, Mr. Mitra has already placed that, which is why I'm taking the liberty of placing it, is that today what is fair rent would have to be fair both to the plaintiff and to the defendant. So today, my lord, if the plaintiff themselves assert it, because there's a period taken into account, 2017 to 2018. So if the plaintiff themselves in their communication, and I indicate that communication to your lordship, where they themselves say that fair rent would be 120 rupees, then today the question that would arise, and I would try to place that case, my lord, subject to your lordship accepting that or rejecting that claim, is can the plaintiff themselves be permitted to say that the claim that I made today, I don't stand by it? So can they be permitted to go from 120 rupees to 139 rupees? I will indicate these, my lord, whenever I come back.
Okay.
Mr. Mitra already says these submissions don't make sense. So I'll take the chance of preparing myself a little more to come back.
Counsel for the respective parties are present. Counsel for the plaintiff concluded his argument. Counsel for the defendant, due to paucity of time, defendant due to paucity of time, the argument of the defendant could not be completed. Please give the date. 22nd November 22nd at 3:45 p.m.
22nd November. Then kindly make it parted. You heard this in length because it's after food.
As parted.
I'm grateful to her. 2nd October. Thank you.
बोलते पारबি না